Good morning. I tried to find something that was reminiscent of Miss Love's blazer yesterday. This is the closest thing I've got. So good morning, everybody. Lots of early birds here today. Today we get to find out if Love finally has her list of witnesses and also if they are prepared to go through witness statements for redactions for witness Sledge. Because Judge Whitaker doesn't seem too confident that Kenneth Copeland is going to actually sit on the stand and deliver testimony. So in that case, she wants to be prepared and not waste the jury's time next week when they finally come back. If they come back. And I don't know. We've had a lot of run-ins with Whitaker and Love where things aren't ready yet. So I don't know how much faith I have that Love will come in today with everything she needs ready to go. However, if Atkins is leading the charge on these redactions for Sledge, it might be in a bit better hands, I'd say. Atkins did pretty good yesterday, for what it's worth. I know some people might not want to hear that, but he did pretty good. He was a lot easier, in my opinion, to listen to than Adrian Love trying to make arguments about co-conspirator statements. It was much easier to follow with him arguing. And it was really a lot of Shard versus Atkins back and forth all day. And Keith Adams had his moments too. I also loved, it was like a special spotlight appearance, it felt like, for Miss Westmoreland, relating to arguments about possible bad faith behavior by the state with repeated, even after Glanville yelled at them, stop doing all this late discovery. They kept doing it. And Miss Westmoreland really had to lay it on the table and say, Judge, I know you weren't here. I know you haven't been here. But trust me when I say, they've been told. They've been told, they've been told, they've been told. And they still continue to do this. So I can't just accept that it's just an honest mistake or not happening in bad faith. So really, we got to hear from a lot of people that we don't typically hear from yesterday. Plus, Doug Weinstein was out of town. I believe he's coming back, but I don't think he'll be in court today, but I guess we'll find out. I'm not really sure. But yeah, the case, there you go. Gary H. says the case was actually moving with Atkins. Yeah, it sure felt like it. All right, we're on. All right, so Law and Crime is never live, so we'll hop over to, I guess maybe Infamous Sylvia. But then we'll switch over because, the caption drill. That way we can see, and honestly, the captions get it wrong a lot of the time, but whatever. There we go.
All right.
And Your Honor, this one, it dovetails with a topic we discussed yesterday. This portion regards the phone call that when Mr. Zachary was at Big Boo's house.
Okay.
And Woody and I believe Shannon and Little Pokey had left with the shooting of Mr. Bennett's mother's home. So this is all about what Zachary is stating about Big Boo got the phone call that there's $10,000 on whoever's head did that. And so the state's argument is similar to what was stated yesterday in terms of the fact that that phone call was made, that Mr. Copeland specifically, also Mr. Zachary, whoever was listening to that call, would have known that there's money on the head of whoever did that. It interweaves into the retaliatory nature of what's going on at that place and time between the two groups. So the state feels that this topic, because Zachary's right there when the phone call's made, it's not as much about what the individual who made the call, if they, what they meant, if they actually had $10,000 on someone's head, but the fact that that's made gives credence to the retaliatory nature and also their knowledge that obviously putting money on someone's head is a thinly veiled threat of violence to action that. So that's why the state feels Zachary hearing that call is relevant.
Okay. Any argument? Mr. Short.
it seems to me that well, first, good morning, Judge.
Good morning.
This all seems to tie in with what we previously discussed. My issue isn't so much about the call and the contents of the call and Woody having money put on his head. My issue comes in when my client is somehow, this is attributed to my client.
All right.
So I don't believe it can be attributed to my client. In and of itself, I don't have a problem with it. It's
Okay.
when they try to link it. So I guess that's my answer.
Okay. And, I think that just as I put parameters on the last item that we took up yesterday evening, I think the same parameters are on this one, unless you can establish that Mr. Stillwell is there when they return and hears this, then this would go only to Mr. Copeland's knowledge.
Yes, Your Honor.
Okay.
When you say, did you mean, Your Honor, Mr. Zachary's knowledge? Or I didn't quite understand.
Mr. Zachary and Mr. Copeland. I mean,
Okay.
they're both present for it, but the point being not Mr. Stillwell.
Okay.
So yes.
Your Honor, number
Mhm.
23 is also on the same topic.
Okay.
And so Mr. Shard had objected to hearsay about who shot up Mr. Bennett's mother's home. This portion, the question that Detective Dennis, from listening to the time hack said, what kind of gun do you think Shannon had on him? And then Zachary says, I don't know. They had an AK and another 223. It was two
Okay.
223s and an AK. There's not much more other than kind of the portions we have discussed.
Uh-huh.
It's not like Mr. Zachary goes into much additional detail about that night at the home of Big Boo when Mr. Copeland and then leave and come back and here's the phone call. My reading of it, or listening to Detective Dennis and Zachary's conversation, is Zachary is stating, he's saying this by my listening and reading, that he's like, they had an AK and 223s. He's saying, because he's not in the car, he doesn't
Yeah.
know, because he makes a comment shortly thereafter where he's like, I don't know how many guns they had in the car. But to me,
When they got in the car, yeah.
yes, Your Honor.
So yes, to me as well, that sounds like at the point in time when they all leave out, which seems to include Mr. Stillwell, here's what they had on them in the way of guns.
And Your Honor, here's my concern,
Yeah.
and I get that this session, this interview, the police are just trying to get Mr. Zachary to dump knowledge or dump information on them and just get as much information as possible. I get that. Obviously, the detective's job is a little different than an attorney's job. I don't know, as I sit here right now, what Mr. Zachary is basing any of this on. Does he know, for instance, is he saying he saw my client go into a car holding a 223? Or is he saying, well, I just know Shannon to carry a 223? See, and those are the type
Yeah.
of things, if I was prepping a witness, I would clarify. I think we need to clarify exactly what he means, because if he just knows my client to carry a 223, if that's what he's saying, then that is something very different than seeing my client get
Yeah.
into a car with Woody with a 223.
Agreed. So on page 113, lines 11 and 12, there's some unintelligible. Do we know what that
I don't
actually
have,
said, or can we listen to that? Because that
Yeah,
may
play it.
shed some light on it.
Play
I
it.
believe my review of this, it was unintelligible to me. I don't know if it,
Oh, no.
other
Okay.
people may find it intelligible, but
Okay.
I don't have anything written there.
Well, maybe if we just listen to this part of it.
Yes, Your Honor.
The chat can figure it out. And Cutthroat, you were right. This is the love shirt. It's the best I could match
I will pull
from
up-
yesterday.
We'll pull up that video to play it.
Okay,
It may take.
sure. So we can move on and come back when it's queued up.
Yes, Your Honor.
All right,
Speeding
so the
through.
next item is on page 122.
And Your Honor, this portion is regarding, they're asking Zachary about what Birdman knew about the shooting of the Little Wayne tour bus, and they also ask him questions about the murder of Donovan Thomas.
Uh-huh.
And so this kind of falls in the category of the state. If we discuss this topic or ask Mr. Zachary questions while he's on the stand, we would lay out an either meet foundation or not meet foundation for, how does he know Birdman? Has he been around him? Like the foundation for this, because it's not clear from just this interview how he's forming this opinion about Birdman's beliefs on or feelings towards these events. And so this is one that I still think it's fruitful to do what we're doing and going ahead of time, but some of it is contingent on Mr. Zachary's
Okay.
on the stand questions.
Your Honor, for instance, just to let you know what the unintelligible is, on 122 line 12, Mr. Zachary says, nah, Birdman, they asked, did he order that murder? Talking about Birdman, Mr. Brian Williams. Nah, Birdman, like he mad at, when he thought Thug had something to do with the tour bus, he mad at him. Like, I don't know how Mr. Zachary can convey Mr. Williams, not Jeffrey Williams, Brian Williams' thoughts
Knowledge
about, well, not even knowledge, is speculation, what his feelings are about an event that neither of them were present for. That just strikes me as a whole lot of speculation on Zachary is speculating about what Brian Williams is speculating about. And I just can't see a world where that would be coming in.
Okay, well, I think that Mr. Atkins is essentially conceding that unless the state is able to establish a foundation for how Zachary can testify to what Birdman is feeling, that they wouldn't be able to use this. Right?
Correct, Your Honor.
Okay.
Your Honor,
Yes, sir.
the state of Georgia had Mr. Brian Williams on their short list. They did not call him. Same with Rich Homie Kwan or Mr. Lamar. I specifically asked the very first witness in the case. He testified several times. I can't remember his name. Belknap, Belknap. He's with City of Atlanta Police Department. Whether he is alleging that Mr. Brian Williams was part of any type of conspiracy, any type of gang. And he said, no, it's entertainment for show. He has no information. He was not making that claim. So it's total hearsay. There's no co-conspirator link. This would be just, I heard him say something or I didn't hear him say something. So I would object on that basis.
Okay.
Besides, reading someone's mind and what your court said.
Okay, well.
I'd like to cross-examine Mr. Brian Williams.
What he's saying is, no, I don't think he had anything to do with it anyway, but.
Your Honor, if I thought Detective Belknap had discussed some of that Mr. Birdman was a blood, but we're not saying this is a co-conspirator statement
Right.
for one, and who the state calls or doesn't call is irrelevant to the evidentiary considerations for today.
Sure.
Is the state's position.
I agree.
I disagree because being a blood, quote unquote, I'm not saying that the gentleman is, I'm not trying to tarnish him or maybe say something accurately, but that's come out in this trial. That's not illegal.
Agreed.
Okay.
Agreed. I just think as to this issue, if and when it potentially arises at trial, we take it up then. But at this point, the state understands that they don't have a foundation to be able to use this.
Correct.
Okay.
We need a term
right.
for that, like a split win.
23.
It's not excluded,
Your
but they
Honor,
still have to lay foundation.
We addressed part of this yesterday in terms of Detective Gaither asked, do you think that Thug ordered that against Nutt, talking
Right.
about the murder? And Zachary says, nah, they're just trying to get a name. this had came up yesterday. It kind of falls in a similar category where the state would have to lay more foundation for how Zachary knows that their motive, knows someone motive. Is it because they told him? Is it because he interacts with them daily? So we would not just ask Mr. Zachary cold, why did they do X, Y, Z? There would have to be adequate questions for that foundation.
All right.
We would object to an order now to eliminate the first word of no. I don't believe that Jeffrey Williams ordered that. If you're saying it's a co-conspirator and he would know about it, then that is relevant. I don't want it axed from the questioning.
I'm not sure if I follow you.
Okay, so I think that the answer by Mr. Zachary, the direct question is, do you have any evidence that Mr. Williams, Jeffrey Williams, knew about or ordered the
Right.
killing? The answer is no. Then he
Right.
goes on, and that part, I agree, should come out. But the no, or the nah, N-A-H, I assume, should not be struck if you're striking things.
Okay, well, I'm not striking or not striking this right now. All of it could only come in if there's some sort of an inconsistency and they're presenting it as, to impeach or something like that. So with,
In Your Honor.
I mean, I guess there are two separate, do you think that Thug ordered the murder? And the answer to that, and then
The next part,
the
I
people that he thinks did do it and why.
understood. And I just don't, the first part to be part of the equation of that potentially is not going to be played.
Okay, so yeah, I mean, they would be two separate items.
Yes, Your Honor. And the way I could potentially see some of this coming out is if Mr. Zachary was asked questions about, because in this interview, he describes, and he tells Detective Dennis YSL is a gang, and he talks about who he interacts with. And so if we asked him questions about, how does that work? People making a name for themselves or going up in rank, some of these could become relevant if he says, I don't know what you're talking about, things like that.
The same ruling that I made with regard to there are a couple of other comments. Yes, you would be able to use that part of it. They're just trying to make a name to show, okay, yeah, this is how it works. And you have told us this before.
Correct, Your Honor.
Yeah, so that's kind of separate as well, and you could use it for that. And then there's, if you are using it to show what he knew or didn't know about who ordered it, then you need a foundation for his knowledge of that.
Yes, Your Honor.
Okay,
Um,
that clear for everybody?
yes, Your Honor.
All right,
Your Honor, could I just add one, a 24B to my list? And
Yeah,
it doesn't
sure.
even show up.
Okay.
It doesn't show up in the transcript, but I think it affects Mr. Williams, frankly. Off the transcript where, well, you see it, but the transcript's not accurate. On 123 line 12, the woman who's investigator Gaither is asking about the rank of who's the leader, and she's suggesting that Mr. Jeffrey Williams may be the leader of YSL, and Quindarius says, who said Thug's the higher up, essentially. I think that's pretty accurate quote.
Okay.
And investigator Gaither, and it shows up at the end where after it says unintelligible, she's actually interrupted by Quindarius.
okay.
And she says, that's just what I heard. I do believe that it would be improper to play investigator Gaither basically an out-of-court statement suggesting that she's heard from other people that Mr. Jeffrey Williams is the higher up of YSL. It's confrontation clause and hearsay.
So, Your Honor, Detective Gaither she's testified previously in this trial, but this portion, when she says, who said Thug is hired, Detective Dennis is like, who's the boss, who runs YSL? Zachary says, he was not right there when they started YSL. And they're like, who started it? And he says, my brother and Slug, who is Trontavious Stevens, also known as Tick. And so
Hey, we got an
the
actual name.
the state's not going to ask Zachary, did Detective Gaither tell you that she believes Thug was hired? That is not what a question that the state would ask. But however, this portion could become relevant in terms of he's acknowledging YSL is a gang. When she says, when she says, isn't Thug the highest, or however she phrases it, he's like, who said Thug was higher, which acknowledges there's a gang with some kind of hierarchy, or because he would have been like, what do you mean higher over what? You know, so
Okay.
so the state, if Mr. Sharp's objection is to Detective Gaither's, words saying, I heard Thug was higher, the state does not intend to be asking Zachary about Detective Gaither's opinion on Defendant Williams or the YSL gang. But this portions of it in relation to Zachary saying who he believes started YSL and his own brother, that kind of stuff, he has adequate foundation. We'd have to ask him on the stand to explain that. That's kind of the state's.
Yeah, I
And
hope
I
they
don't
say
have
this
a
is
problem with
cumulative.
anything that Mr. Atkins just said. All I'm saying is, and they could ask about that, and quite honestly, I think the defense likes Mr. Zachary's answers. All we're objecting to is if it's played, there's a prior inconsistent played to the part that Investigator Gaither says, that's just what I heard, referencing that Mr. Williams is the leader.
Okay, so you're saying if for whatever reason it does end up getting played, strike that's just what I heard part.
Correct.
Any problem with that?
No, I agree with Mr. Short on that.
All
Okay,
right,
so we got an agreement.
sounds
We've
good.
got 2 evens and 1 agreement. Thank you for becoming a member at Cut Above, Lady T.
Make it easier on everyone. So I think there was a bond hearing or something that Detective Dennis or Gaither, they're referencing a court hearing and arguments that Mr. Zachary's attorney made. They were like, those are good arguments. We all know that. Anyways, the state is not going to be asking. We're conceding this in regards to it's a really brief back and forth where they're laughing about a court hearing, about the argument on bond, about
Okay.
the gang. And so the state's not going to be asking Mr. Zachary anything related to number 26.
Okay.
So that's
So
agreed.
redacted by agreement.
Your Honor, and also on number 27,
Yes.
there is and he says that earlier. And so when Detective Thorpe, who's the lead detective on the Donovan Thomas murder, comes into the room, there's some greetings, and then Detective Gaither kind of tells Mr. Zachary, Thorpe's been working really hard on the case. We've been talking to a lot of people. We appreciate your honesty. The state's not going to be, I don't think this will come up. So the state's conceding this portion in terms of, I'm not going to be asking Mr. Zachary about if Detective Dennis and Gaither thought he was truthful or doing a good job.
Okay. Thank you. Was that all that one needed to cover?
Correct. It's just them bolstering
All right.
basically
Yeah.
on the tape.
Okay. All right. 135.
So, Your Honor, this one, Mr. Zachary says, I think Nard was driving them, and then Thorpe just kind of repeats, okay, Nard was driving. This is when they're speaking about, because Zachary at the beginning of this interview talks to Detective Gaither and Dennis some about Donovan Thomas's murder, and then they get Detective Thorpe to come over because he's the lead homicide detective. And so he goes into more detail at that part. So the state, this part of the interview, Mr. Zachary, as like all of his interviews, he's not saying directly where this is coming from, but the state's position, kind of similar to yesterday, is that the primary source of Mr. Zachary's knowledge is from when he says Defendant Stillwell, Defendant Kendricks told him that night. He also has a brief mention when he goes down to Miami with them that he had some kind of conversation with with Demise McMullen, Nard. And so he does say, I think Nard was driving them. The state's position, and again, this may depend on the foundation of the questions he's asked, but the pool of information that the state's aware of from Zachary's statements is other co-conspirators telling him about either their own involvement in the murder.
Okay.
And Your Honor, my stance as previously stated, is that if Mr. Zachary is claiming the source is anyone other than my client, Mr. Stillwell, I would object. However, if the source, I understand the court's prior rulings, and if the source falls under the court's prior rulings, I understand
All right.
what your ruling is.
Okay.
But I don't, as I sit here now, I have no idea what his source is with some of these statements that he's making.
Okay, well, I think we have to take the entirety of the statement into consideration, but that would fall under my prior rulings with regard to the co-conspirator exception, so that'll be permitted.
Your Honor, I believe next is number 29, which is 136, line 18 to 137, line 11.
Okay,
In this portion, Detective Thorpe says, after the shooting, do you know what happened to the cars and the guns? And Zachary says, yeah, they dropped it off at OG Bentley's spot, who's Mr. Treadwell. And he asked them, do you know if the guns are still around? Did they get rid of them? And Zachary says, most likely got rid of them. He's supposed to have gotten rid of them. And then they have a conversation about, Detective Gaither's like, how do they usually get rid of guns? And Zachary's like, well, this is the first time. Usually we keep the guns. And
Okay.
Detective Thorpe asked if anyone got a word to shoot nut, which is one we kind of just addressed. And he says they just wanted a name. So it's speculation, hearsay. I think the speculation objection is coming from where he says, do you know if the gun's around? He's like, they most likely got rid of them. The state's position here is that, again, his source of them going to Kevin Treadwell's house is, again, the same co-conspirator statements. And he is not definitively at the house or see them bury the guns in a backyard or throw them in a river. But I think it's reasonable to think that from his conversations with them that they went there to get the car and the guns so that they couldn't be caught. So the speculation is Zachary's not physically present at Mr. I have no information that he's physically saw these guns being hidden. But I think because he spoke with co-conspirators about it, it is not as speculative as that question
right,
seems.
he has a basis for knowing from his other co-conspirators that they were dropped off.
Yes, Your Honor.
What happened to them after that? That is what he's speculating. He knows the purpose was to get rid of them, but whether they were actually gotten rid of past OG Bentley's place, he doesn't know.
Correct, Your Honor.
But that they were dropped off, he does know.
Correct. And because he kind of answers, like, it's clear that he doesn't exactly know if this particular portion through impeachment came in, it's, he's kind of telling, like, I don't know exactly, I think they did, but it makes sense in the context of the conversation he has a couple hours after the murder.
Right.
That
All
they
right. Well,
wouldn't, so.
with those parameters.
And it just goes, I've stated my objection.
Another
I understand
even,
the court's
probably.
ruling. However, I do believe that 9 and 11, lines 9 and 11 on 137 are a little different because, again, that is just, from my understanding, just pure speculation about motive.
And this is kind of similar, Your Honor, in terms of the state would have to ask him foundation about how does he know they wanted a name?
Sure. All right.
What do you guys think about the Duke connection with Judge Whitaker and Max Shard? Because the whole chat yesterday was like, the judge likes Shard, and then, oh, she likes Atkins.
Hey, on this one, Your Honor,
Hang on just a second. I need to actually figure out
I think she likes that the two
where
of them
we are,
together.
because so that actually, even though 1, 3,
Have gone through 5 statements already.
I wrote it.
so that went past what is notated on your number.
It was supposed to say 136:18 to 137,
Okay.
line 11.
All right. That's I looked down and I'm like, well, we're talking about 137. Okay.
So thank you so much, Legally Brown Girl. It's good to see you.
All right. Now I'm back with y'all. Okay. 138.
So number 30 on my list. This transcript is really rough here, so I'm just gonna, if the court allows me, just
Sure.
on 138, line 6. Mr. Zachary is talking about Shannon. So Shannon's the topic.
Okay.
Gaither says, right. Zachary says, like, Thug really wasn't messing with him. He was around Thug as Woody's friend.
Okay.
Okay. So they're still talking about Shannon. Line 13, right. So once he did that, it was kind of like, we can trust him. Zachary says, yeah. And then line 17, she says, we know he a shooter.
Okay.
That's my objection. The law enforcement saying, we know Shannon's a shooter.
Okay.
And so, Your Honor, this portion, which I agree with what Mr. Shard's saying, that this time hack states. And so they're talking about, it starts with Zachary has a comment where he's like, usually Woody and Moontunk are doing all the shooting. And then Gaither's like, well, did Mr. Copeland slow down with his BS? And he says, when he's around a lot of folks, he gets pumped up. And they're kind of asking, how did Shannon Finnett Stillwell get into the picture? And so he's like, well, he was friends with Copeland, comes around, and Zachary says, no one really knew Mr. Stillwell that well. And then, the way that what they're talking about is after the murder of Donovan Thomas, Gaither's like, well, once he did that, and that is the murder of Donovan Thomas, that we could trust him, know he's a shooter. And Zachary's response is, he started messing with Shannon hard. I take the he being defendant Williams. And so the state feels that Detective Gaither's question to get Zachary's response, if the right questions are asked on the stand, could be relevant because, for one, Zachary on some level confirms what she's saying, because he's like, after she says, they can trust him, they know he's a shooter, Zachary says he started messing with Shannon hard, kind of confirming that, yeah, he started messing with him or hanging out with him or being closer with him because he was a shooter in the context of what Zachary's saying happened on January 10th, 2015. So the state feels that it's not just Gaither in a vacuum saying, we know Shannon's a shooter. I'm not going to ask Zachary what's Detective Gaither's opinion, but yes, my apologies, Madam Court Reporter. But it could become relevant because of asking Zachary in the context of his relationship with Mr. Copeland, how defendant Stillwell came into the picture, that this exact clip, if the right questions are asked, could become relevant to get Mr. Zachary's response.
Okay.
But if this clip is played, line 13 says, right. So once he did that, it was kind of like, we can trust him. And Zachary says, yeah. And then we could easily go to line 19. He started messing with Shannon and then they go into Woody becoming a new Slug and Shannon becoming a new Woody. But none of that requires line 17, law enforcement saying, we know he's a shooter. That's my objection, specifically that line. I understand. Right.
So up above on line 6, what gets said then? They already knew Shannon liked something.
I just have it say that until. Like that until. It doesn't make a lot of sense, but that's what they're kind of interrupting each other.
Yeah.
My note, Your Honor, is Zachary says, nah, so lines like 2 or 3, Detective Gaither says, did Woody slow down with his BS? And Zachary says, nah, when he seen that there's a lot of folks around Woody, they pumped him back up. No one knew Shannon like that until Thug, not really messing with him. He was around Thug because he's Woody's friend.
I agree.
Yeah, that's on the prior page, right?
That's 138, line 10. Right, Mr. Atkins? That's where you're at?
I believe so. The transcript lines I'm looking at, I went back through and added, from listening to it. So my line and page is a little off, but.
Well, I see did Woody slow down with all his BS once Nut got killed? Or was he still?
Right. That was on 137.
Right.
And
And
then
then this is the no, he'd get, the answers, no, he'd get pumped back up, or what?
Yes, Your Honor. It's, Zachary says, nah, when he's seeing that there's a lot of folks around Rudy, then he pumps back up. And then he says, no one knew Shannon like that until Thug, not really messing with him. He was around Thug because he was Woody's friend.
And then Gaither says, right. So once he did that, it was kind of like, we can trust him. Quindarius Zachary says, yeah. And then Gaither says, we know he's a shooter, or we know he a shooter.
Right.
And I don't know why the Gaither would be allowed to make a declaratory statement, whether she's talking generally that law enforcement has
generally his
determined that he's a
role.
shooter,
Right.
or if he's a shooter in this case,
Right.
that's a question for the jury.
Right. But I mean, assuming that he started messing with him hard after that is actually in response to the statement, we know he's a shooter.
Well,
And maybe I just need to listen to this part.
I view it more of a response to line 13, where she says, so once
He
he did that, it was kind of like, we can trust him. And he's like, yeah. And then you could easily go, he started messing with Shannon he started messing with Shannon. He repeats himself. I don't know why. And then they don't really, there's no real meat to what Zachary says, because then they move on to Woody. But my concern is specifically with, we know he a shooter.
I understand. I'm going to listen to it. It may not elucidate anything, but where is this timestamp?
So, Your Honor, I have a little bit before this is at 3:25:44.
Okay, I'll just start there. And you did send this
So
video?
there's two that she wants to listen
or
to.
no? I can't remember.
I will double check, Your Honor.
Okay, just make sure y'all do so that I can
That's
listen
right,
to
we
it.
did give a thumb drive, so it should be.
Oh, so it was on the same thumb drive that the other one was? Okay, I know there were like 4 items on there.
Yes, Your Honor.
Okay, all right, well, I'll listen. Y'all can remind me to circle back on it. Do we have that other thing queued up?
Yes, no, and I wanted to make certain that I got the exact time, because I just pulled it over to this time frame, when you want to listen to this.
Yeah, we're going over.
Just say you have the time. She always has like, I just wanted to make sure I did it
And I mean,
exactly
maybe
the
we can
bestest
just
way
listen
ever.
to 'em both while it's up. I don't know.
This is the first moment of truth. Will she have the timestamp right? Thanks, FFS.
Forward that to, forward it to.
If this is all she's been doing, she better
Your Honor,
get it
for the
right.
record purposes, we're pulling up, we're gonna start at 3:08:50.
All right, and this is, we're going back to item number which?
We are going back to,
That was like the second or third one they talked about.
this actually kind of tackles a couple items because this is all about who shot Lucci's mother's home. But I believe what prompted us to go back was,
Item number 23, was that the one we were?
yes, Your Honor, I think it was 23.
Yeah.
Because we weren't sure if Zachary physically saw these guns or.
Right, okay.
And thank you, Dave, for becoming a member. Choose your racer in the member emojis.
Right.
And A Cut Above also gave someone a membership after becoming a member, which is really sweet of you to do. Thank you so much.
And I've been told that if I plug a headphone into the computer, if I'm on Zoom, maybe I can hear it better.
Crispy
I don't know if
Bacon, I
that's
think this
true.
is a
I
great
have to get on
strategy for the
Zoom
state.
first. Are you playing it through Zoom or are you playing it off your computer? All right.
Just
let
keep
me
love quiet.
Then join Zoom. And figure out where this might plug in.
Your Honor,
Mhm.
before we play, so 30850 is when they first start, literally Detective Dennis asks him who shot up Lucci's mother's home. And then I'm happy to start there for the court if the court would like. There's about 3 minutes of conversation, but when he specifically starts talking about what kind of gun did Shannon have on it, which is more tethered to number 23, I can jump just to that part. I want to just ask the court if you wanted me to play a little bit before or go right to when he's discussing the part about who had what firearms.
If you think the context will help, that's fine.
Okay. We'll start at 30850, Your Honor.
All right.
Officially 30841.
Thank you, Aries Goddess, for becoming a member. I'm also an Aries.
So, let's get to this. Who shot up Lucci Mama?
Shut up, Lucci Mama. I'm telling y'all, I got work with me.
We got bro.
Like,
You're doing great.
Wooly, Shannon, and Lil Pokey.
From Boulevard?
Nah, those are the nephew. Lil Pokey's in jail right now. Quentin Pittman. So, how did, cause that was the gun that you had, that you got caught with. No, man, that's too long. So, how did Woody end up with that gun that day? We was at Boot Mama house, big Boot Mama house. And we was like, hey, fucking shit, that's right. Okay. Then when they came back, they ain't even tell us what they did. What kind of car were they? They were in what? It was in that white Charger. Woody Charger? Okay. And then the boy, Mushu, who he did Lucci, Mushu. Yeah. He called Boo, like, when Woody got back, he called Boo, like, Boo, they got in. Boo, like, what? Like, somebody just shot up Lucci Mama house, and Mom got shot. And Boo, like, don't tell me how they did that. Cause they come back and they say that. Don't tell me how they did that. Then that when Woody got scared again, cause Mushu, like, got 10,000 who else did that.
Who had the monotone gun?
Woody. So they actually came back and said they did it, or y'all just assumed it? No, they said they did it. He finally said it when Woody, like I told you, Woody got scared when they said he got 10,000. Like, man, we just shot up Lucci Mama house. So because Lucci was close with Nut, they just... Lucci was hanging with Kel. Right. I told you all about Lucci and Kel. Like, Nut didn't go get killed. I don't know what made him do it. Did you know Nut? Yeah. He give me 20 all this stuff. You know, I pull up on you some gas money, phone bills, doing stuff like that.
So he's like a big homie.
Yeah, he cool with the whole city. I'm gonna tell you, that's what everybody said.
So everybody speaks highly of him, but he still a street nigga. So he had dirt on his head.
He was trying to, but he, like, every time I see him, so I feel like I'm gas in the car, so he give me 20 or 40.
So they look at you like the little like,
Yeah.
little guy.
I ain't no harm.
Basically. So, what gun did you think Shannon had on that?
I don't know, they had a AK and another 223. It was 223s and an AK. I know they had that big AK. That was poking on.
The AK was?
Yeah.
And what Shannon had?
They had one of the 223.
So he had an AK.
I don't know how they got in the car. I didn't know guns. They go like I was.
So answer this question. So when we were in court and you found out that gun,
All right. I mean, it sounds like to me like he's saying essentially this is what they had with them when they left out.
That's the state's, we're in agreement, Your Honor.
So I'm going to permit that.
Overrule the objection and permit it? Your Honor?
Yes.
Yes, Your Honor.
Okay, so
That's
can
a
we-
win for
can we
the
move
state.
to the other one that I was going to listen to, that we know he a shooter.
Yes, Your Honor.
That pretty easy.
Yes, Your Honor, it is.
Okay.
So we're going to 32544 for the record.
All right.
Yeah. Kat says, I can see why the person transcribing this has issues. Even Detective Gaither's hard to understand. And thank you. Jess gifted a membership, so say thank you to Jess in the chat. That was really nice of you. And then SD Hellfire also became a member. So thank you so much. You guys are channel sponsors. I really appreciate it.
325.29.
And Cutthroat says, I'm glad Glanville's off. we wouldn't be this far today. We'd be on, we'll talk about these statements later.
So.
Let's take a
after the
comfort break.
shooting, do you know what happened to the car and the guns?
Yeah, they dropped off at OG Campus Park.
Do you know the guns still around when they got rid of them?
More likely they got rid of them. I think when they dropped them off at Campus Park, he pulled it got rid of them.
How do they normally get rid of guns?
I don't know. That ain't the first time they ever used to keep them.
Yeah. Okay. So, did anybody get word to shooting up, or this was just an opportunity?
They just wanted the name.
They just wanted the name.
Cause it used to be one and more to them going out shooting. They just wanted the name.
So did Woody slow down with all his bullshit? Or once Nut got killed, did Woody slow down with his stuff, or was he still?
Nah, when he seen that he had a lot of folk that ran with him, then he popped back up.
Moody.
Yeah, but see, they nobody really know Shannon like that until then you do.
Right.
Like those weren't really messing with him. He was running for with water from him.
Right. So once he did that, it was kind of like we can trust and we know he's a shooter.
He started messing with Shannon for he started messing with Shannon.
So he put Woody to the side and Shannon back to the Woody spot.
Yeah. So like Woody took slugs back.
So Shannon and
It is really, I don't know that it can be determined that he started messing hard with him is in response to him being a shooter, to him doing that, to him coming around with Woody and it being okay because he's Woody's friend. I mean, I just think that I don't think you can base that Thug started messing hard with Shannon on him having been a shooter. I'm going to exclude that.
Understood,
I say, like,
Your Honor.
Teenagers say that's a big win for the defense, especially after the win that the state just got. That's kind of going to be
Okay.
confusing to the jury to listen, whatever, you know.
So, moving
This is
to
all probably confusing to the jury. But that's a big win for the defense right after a pretty big win
Give
for
me
the
just a
state.
second.
Delta lost your luggage?
All right.
Your Honor, with this next one, I'm in agreement. This is probably this section where Zachary is stating that his older brother used to hang out with defendant Stillwell. And then Zachary says something along the lines of, until Shannon got locked up,
Okay.
the state would omit or ensure that the jury never hears about Shannon getting locked up, but
Okay.
may ask him about him knowing his brother.
Okay. That takes care of that objection.
Yes, Your Honor.
All right. Thank you.
And thank you, Saz, for becoming a member.
Now, this next
Appreciate
one,
it.
Your Honor, 32, I don't believe I'm pretty certain she's not referring to Shannon. I think she's referring to Terry Rivers,
Okay.
who I don't know if his name has come up in this. He's certainly not in this case. He's certainly not indicted. My understanding is he's alleged to be associated with some of these gentlemen in some way. But then Gaither adds, yeah, I know Terry Rivers used to steal ATM machines. And I just think that that's just
Okay.
throwing another.
Your Honor, the state agrees and concedes this.
All right.
this
If
portion
y'all are
of it.
going to agree, tell me before we
Yes, Your
listen
Honor.
to the argument. We can save Mr. Shart and my voices.
Yes, Your Honor.
All right.
There is some agreement with this next number 33.
Okay.
So they're talking about the Dexter Montgomery shooting, which was in Act 36. We've already introduced at trial. Mr. Zachary was not present. He admits in this interview he doesn't have any personal knowledge
Right.
about it. The part of this that the state may get into is the photographs used in that case. For example,
Mhm.
there's gas station surveillance stills.
Okay.
He recognizes, for example, Demise McMullen, who was one of the defendants in that case.
Okay.
The same photographs that Detective Gaither and Dennis are showing him during this portion are already in evidence. And so depending on, there may be some questions with those exhibits,
Okay.
but we're not going to be asking Mr. Zachary anything about what happened to Dexter Montgomery because he doesn't know.
All right. You'll just be using it.
That's fair. I mean, I don't, Mr. Murphy, DK, took the stand and he's acknowledged that it was him in Nard. So I don't think that's really in dispute. I would add though, and this doesn't show up in the transcript, Investigator Dennis has a habit of doing this with a lot of these gentlemen he interviews. He takes out a picture of Dexter Montgomery's head, which is actually in evidence. And he just goes into this big thing about, oh, he's got half a head. What do you think of that? And I just don't
Right.
think that's appropriate.
Okay.
But if for some reason there's an issue about who was there, I do concede that Quindarius Zachary, after Investigator Dennis does the half a head thing, does show him pictures from the scene and he says, oh, that looks like Nard, that looks like DK, or
Okay.
so I concede that he
Alright.
does do that.
So to the extent that this is him identifying, yeah, that's that person. I know that person. That's this person. We don't need commentary about, oh my God, look at this guy's head. You know. that.
Agreed, Your Honor.
Okay. Great.
Number 34 also is an agreement.
Okay.
This is in relation to something that's been suppressed
Yeah.
under
Yeah, I
grade of
think
a
y'all
house,
told me
so-
That already.
that's right, Your Honor.
Okay.
They've gotten through 10
35,
already.
this is a portion where Mr. Zachary they're asking his girlfriend, Summer Good, says that basically she doesn't like him hanging out with them. And then he mentions defendant Stillwell because like Zachary gets in trouble with them. And so the state feels that, in the context of when, and the Detective Dennis is going to be also, he's testified before, but he's going to testify again. He's on the witness list and he's in this interview. This could become partially relevant in regards to this. In what's going on in Mr. Zachary's life at this time, he's trying to pull back, in his words, and kind of get a
Right.
fresh start, spend more time with his girlfriend, things like that. And so this is kind of wrapped into why at this moment in time he's in jail. He's speaking with the police. And so the fact that his girlfriend, who he's kind of self-admits is very close with, interact with a lot, she doesn't like him hanging out with them. And so the state does feel like this could become relevant with the right questions of Mr. Zachary.
Okay. And it could. So I think at the point in time when y'all think it does, that's maybe something we'll just have to wait on.
Okay.
Okay.
Your Honor,
FFS
the
has speculation on
next one, number
Delta losing your
36.
luggage.
So Zachary is discussing when his brother died. And what he says is he died when Haiti Gang robbed him.
Okay.
Haiti Gang is kind of a subset and affiliated with If Gang. And so the state feels like this is very relevant because Zachary's older brother, who in an earlier part of the interview, he says was one of the, Zachary says,
Founders.
correct,
Yeah.
that the fact that Haiti Gang robbed and killed his brother, that is relevant to how he kind of got involved in a gang. So it's not as much about what happened. We're not gonna be asking him details of his brother's murder, but this portion could become relevant when we ask him questions about his brother if he, so that's why the state wants this to come in, at least in relation to, because the objection was discussion about the murder of the witness's brother. So it'd be a brief discussion of that, if at all, depending on how he answered.
Okay. Well, I mean, 159 looks to be like the details of it. So even based on what you're talking about, this part may not come in.
Yes, Your Honor, like we won't be asking him like what street his brother that happened on, or
Okay.
we would just be asking him, or we may never get to a part where we have to play this to discuss this part, but it's just about the fact that Haiti Gang robbed and killed his brother.
Okay.
That's the part the state wants is relevant.
All right.
Yes, that's another one. A lot of evens today where if the foundation's laid or if there's an inconsistent statement, there's still another battle to get through for this stuff to come in.
All right. Number 37 is on, starts at the bottom of 163.
Your Honor, this portion is when he's discussing the shooting of Dwayne Carter's tour bus. So Zachary, Detective Dennis personally sees Zachary when he arrives. They're at a nightclub outside. And then there's a lot of things that happen, some of which Zachary's present for, some of which he's not. And so he is not in any vehicles. He never says he's in a car that did the shooting, things of that nature, but he mentions being with different members that are there, like co-conspirators, defendants, other witnesses. You know, they go different spots in the city before they arrive at the nightclub. They go to places afterwards. The events of this shooting become something that gets discussed amongst each other. And so the objection was, the investigator testified about his theory, hearsay and speculation. The state's more concerned with what Zachary, you know, what he states happened. Like, for example, he's discussing what cars people went in, like Detective Dennis asked, did they put Thug's sisters out? Like, because some people got in different cars. And Zachary says, he's saying, I don't know where she lives, but he mentions, he confirms like Max is who he calls his sister was there. And so, and Mr. Sharp, correct me if I'm wrong, if there's a specific portion, but Zachary's knowledge of what happened that night will be something we'll be asking him about. And so this may be one that we have to, it really depends on the questions he asks, because it would only be impeaching him if he kind of backs off the details of that night. And so I will not be asking him about Dennis's theory of what happened, but depending on what he testifies to, certain of these portions, you may need the question asked in his response, but this is kind of very much wrapped into how he testifies, because he goes through a lot of different facts of that night.
All right. And it seems like, Mr. Sharp, you're objecting to man one, who's one of the investigators, saying, here's what I know, or here's what I saw.
I am
right?
objecting to that. I mean, my understanding is that's Investigator Dennis, and he's already testified to what he saw on the stand.
Okay.
And
So they wouldn't be offering that for it to get in anything about what he actually saw. This would be if it becomes relevant to, if the answer becomes relevant.
this is the dilemma, Your Honor, as I see it. I concede that seems pretty clear that Quindarius Zachary was at the compound that night. The compound, I don't know if Your Honor's familiar. I've been to the scene. It's
gigantic.
It's very large.
Yeah.
It's unclear to me. I know that he was not on 285. That's pretty clear. Or he's saying he wasn't on 285 or when buses were shot.
Mm-hmm.
What's unclear to me is where he was when he's claiming people were leaving out and switching cars.
Right.
He's definitely giving that information. It's unclear to me if it's based on, and this was a widely reported event. There was hip hop gossip, internet sites almost immediately that are reporting what happened, different theories. So it's unclear to me whether he's there when he's saying people were leaving in certain cars.
Yeah.
And I concede if he was there, if it's established that he was there and he's saying he saw things with his eyes, I mean, it is what it is for me, and I'll have to deal with that in cross-examination. But what I don't want is the state for him to say, well, I wasn't there for that part, and then the state to start impeaching him. Well, didn't you say this and this and this? And then it was just all based on speculation or internet gossip or other things. So I don't know what his source of information is for some of this stuff. And that's what I'm struggling with. I understand in a certain circumstance, he would be able to testify about what he saw. Well, in any circumstance, he'd be able to testify to what he saw. But I'm not sure he saw these things. I'm not saying he didn't. I don't know.
Well, I think we already made rulings, and by we, I guess I mean me,
Well,
about that.
you made rulings, my recollection is you made rulings about what Demikion Garlington allegedly told him about the Donovan Thomas situation. I don't.
Okay, I thought we had talked about him. Maybe we haven't, but I mean, to the extent he gets on the stand and says, yeah, I wasn't there, I don't know any of this, the state can cross-examine him about what he said before, and it may be that it's established through, not cross-examine, but examine, and then y'all can cross-examine him about whatever the inconsistencies are. Even if he says, you know what, I don't know who got into any car. I wasn't there. I was in Alaska at the time. They can cross him. I mean, they can examine him, impeach him with this.
Because that would be clearly inconsistent with his prior statements. But my concern is if he says, you know, as the crowd was dispersing, Investigator Dennis saw me and said my name and I ran.
Yeah. And
I ran from the scene and got into a car and left and went home. And then they're like, well, didn't you say that Shannon got into this car? And it turns out that his testimony is actually that he wasn't there for that part. And what his prior statements were based on something else.
but who knows whether it's true that
I understand
what his testimony is, you know, whatever, next Wednesday, that he says, oh my gosh, the cops saw me and I ran and I went home and got in my bed. We don't know whether that's true or not. So he's still going to be able to impeach him. And then y'all are going to have to ask, you know, hey, you know, how are we supposed to believe that this is true? And he can say, well, you can see it on my Ring camera. You know, I walked in the house, and y'all will just have to explore that. I mean, we don't have any way to know. They're telling the truth. They're supposed to swear to tell the truth and then tell the truth, but we don't know that. So I can't do what it is that you're asking me to do here. Okay.
I understand the court's ruling.
All right.
Your Honor, number 39 and number 40, they all are in relation to the same topic regarding the shooting of Dwayne Carter's tour bus.
Okay, hang on. Did that cover 38 and 37?
Definitely covered 37.
Okay, because I thought we were on 37, so,
My apologies, Your Honor. So
Okay.
for 38, really 38 through 40, and we can take them one at a
Okay.
time. They all talk about this same event.
I would agree with 38 that what your ruling was just covered.
okay. All right, so moving to 39 and 40, is this also still the same incident?
I'm catching up.
Me too.
And yeah, this is a great time for this. Cutthroat says, I'm
Okay,
so glad
so-
Glanville's off the case.
On 39, excuse me, 30, we're on 39. He is saying that someone said we shot up the tour bus, but there's a pronoun we, and it's unclear who the declarant is or where that's coming from. He's saying that people showed up at the studio later that night and someone said we shot up the tour bus.
Okay. Okay, so does he ever say who showed up at the studio later?
He does mention where various people come, but I don't have memory of him ever clarifying exactly. Well, I will say this. Give me 1 minute, Your Honor. I'm trying to find this part in my more detailed notes.
Mhm. I mean, it says after they shot up the bus, what happened? We met up at the studio. What were they saying? They're basically saying we shot up the bus. But we don't know who the we is from here, but we may know who the we is from if he somewhere else says, here are the people that showed up at the studio.
And Your Honor, there is a portion where he's discussing who switched cars.
Okay.
And Zachary, so Detective Dennis says, so Max, referring to one of Defendant Williams' sisters, and Shannon switched spots. And Zachary says, told everyone they were going to watch him, call him, meet at the studio, say we're going to go shoot up the tour bus. And Detective Dennis is like, they said this? And Zachary says, I don't know what the hell made him shoot up the tour bus anyways. Oh, my apologies. Yes. They were at the studio. Say, we're going to go shoot up the tour bus. Detective Dennis says, they said this. And Zachary says, yeah, I don't know what the hell made him shoot up the tour bus anyways. Detective Dennis, who said it? And Zachary says, Pee-wee, referring to Jimmy Winfrey, who was the individual. It was a Cobb County case, but relation to this incident. And then Shannon said it, and Detective Gaither's like, well, who was more hype about it? And he says Shannon. Now, I believe this context is before the shooting, whereas what we're talking about is afterwards, but this is kind of very much wrapped into how, when we get to this part of the interview, we'll be asking him questions about that night. And so depending on how that questioning goes and what his answers are, he will have to have, the foundation for who he was speaking with or interacted with. And I actually say a little bit further, Your Honor, and I can actually play this if we need to. I have 3:45:49. Detective Dennis says, after they shot up the bus, what happened? Zachary says, we met up at the studio. Detective Dennis says, they came back to Metropolitan. What did they say? And Zachary says, they say they just shot up Wayne's tour bus. It was Max's truck with them in there and Pee-wee's car, referring to Mr. Winfrey.
Mhm.
Don't know who Pee-wee was with. And Gaither's like, so both cars up there, other cars following them? And he says, probably followed them to Expressway, not sure if they followed them to the shooting. And then he just goes into a diatribe about how Mr. Winfrey came into their friend circle. So I don't see where he definitively says who it was at the studio told him. But there, this event happening, there's a lot of communication about it because it becomes a big incident that happened. And so I don't know definitively who at the studio told Mr. Zachary, but
I mean, I know that this is alleged to be a gang act, and I would assume part of your RICO.
correct, Your Honor.
Okay. The only complication is with our potential limiting instruction about, who, well, I mean, it would only be charged against the people that it's charged against.
And it's Act 39. It's only in relation to the RICO count because this incident happened in Cobb County. So this is.
That makes it easy.
Yes,
Okay.
yes, Your Honor. So.
All right, so then that, it is, yes.
Your ruling, only Mr. Winfrey is alleging that overt act. He's not on trial.
Okay, but it is alleged to be an overt act in furtherance of the RICO conspiracy, right?
It is an act in relation to count one, which every defendant's charged with count one.
Right, okay.
It's true. But also the overt acts have a statute of limitations of 5 years from the time that the indictment's returned. This is in 2015. There's a series of overt acts that Judge Glanville said, I understand your argument. We'll get to that. He just passed on it, basically, that those could not be considered by the jury in reaching a verdict. I asked for a special verdict form. So all of this, I just want to raise your
Okay, now
attention.
I appreciate that if that's yet another pending determination for me to make, but I would think that they can still be, I mean, nobody's being, even if it were in Fulton County, nobody's even potentially being convicted of this act, but I would think that statute of limitations or no, it can be considered by the jury in determining whether the people charged are guilty of a RICO violation. So if you've got case law that says differently, and if you already filed it, just let me know where to find it. But if you,
And Your Honor,
and is that the argument that you're making, that they cannot even consider when they're considering whether anybody is guilty of a RICO violation, acts that there is a statute of limitations for, and that statute has run?
So I think when you say they, my position.
They, the jury.
Okay, so the jury can only, they're going to have to find the overt act because it's a conspiracy.
Uh-huh.
That overt act must be, in my opinion, and the case law that I'll again show the court or show this honorable court would be within 5 years.
Okay, well, if there's case law that says that, then certainly I'll take a look at it. And it sounds like that issue is still on the table to be determined, right?
Yes.
Your Honor, being a newer addition to this team, I wasn't present when this, I'm being told that this issue has been addressed before. And so if there's going to be further, I don't have the case law right now, but in terms of Act 39, the fact you can charge overt acts in furtherance of a conspiracy that happened outside of Fulton County. That part is clear.
Oh, yeah, no, he's not talking
And-
about where it happened. He's talking about statute of limitations having run.
And there is, to my knowledge, and we can, I don't have a case to cite right now, but we can, if this needs to be briefed, we will brief it. But that is not the state's understanding with,
It's not the court's understanding of it either, but I mean, been wrong before. I could be wrong right now. It is not my opinion that matters. It's what the case law says that matters. And if it has already been briefed by both sides, super, just point me to which brief and which response I should be looking at. And it very well may have been addressed before, but not decided. Ms. Lev, do you think it's already been decided?
Judge, that's what I was just saying. I
Okay.
believe that this issue was raised by Mr. Steele very early on, and I believe that it was decided in the state's favor against his position.
Okay.
But I was saying that we can check the transcript for that because my firm belief, because I remember the argument, is that it was actually argued and decided. We will also look for an order to that effect. But I specifically remember Mr. Steele's assertion regarding a statute of limitations. I believe that it may have been Mr. Floyd that argued that.
All right.
But we'll check and see.
All right. Well, thank you. And whatever you find, send to me or point me to it at least. Now, this is not really an evidentiary ruling that's been, assuming it has been decided. This isn't really an evidentiary ruling. This is a ruling that's going to impact how I tell the jury to deliberate on issues and what kind of verdict form we need. And so it really is something that I don't find myself bound by whatever the prior ruling was, even if it was made. I want to take a look at it myself and make my own determination based on the case law. So y'all just, again, point me to what I ought to be looking at, and I'll look at that and then make a ruling.
And Your Honor, so that I'm making certain that we are speaking apples to apples, Mr. Steele's assertion is that because the statute of limitations on the overt acts have run, that the jury is not allowed to consider the overt acts?
That's what I think he's saying. No.
I'm just saying to deliberate for the actual verdict. Let's say that we're asking for a special verdict form. There's 191 overt acts in count one. Let's say the Honorable Court grants a special verdict form, and every one of any overt act within the statute of limitations, within 5 years of the return of the indictment, says not proven. But then there's one or more overt acts before 5 years of the return of the indictment that says proven. Our position would be the overt act is not satisfied because the statute of limitations bars the conviction because the overt act was previous. I'm not talking about evidence because that shows the history of the quote organization.
It could just be intrinsic or whatever. So
Right.
I mean, okay. So I mean, but I do understand they can consider it for whatever, the history and how it all fits together. But you are saying that case law bars the jury from returning a RICO conviction if the only overt acts that they find to exist are overt acts the statute for which has run.
Exactly.
All right, well.
And the state opposed at our previous argument a special verdict form. That was the Honorable John Floyd. And what Judge Glanville said was, we'll address that later.
Okay, well, we
That's what happened.
need to address that.
I didn't believe the state that it was already a decision already ruled on.
What? I think you just lost the battery in your.
I did. I'll put it in writing because, I think it's a fascinating issue, but we'll put it in writing.
Okay, and if it already has been put in writing, you don't have to do it again. You can just point me to, this was, motion number 50,000 filed on May 1st or whatever.
50,000.
If you haven't put it in writing yet, great, do that. And same for the state with regard to a response. And if there is a ruling, I want to look at that too. I mean, I don't want to reinvent the wheel either, but I will make my own determination about it.
Yes.
Okay.
So Love has more homework.
Yeah, I believe there is a ruling regarding the statute of limitations. Since one overt act is the murder, then that statute applies to everything else. But
no deliberation instruction where if you don't find that the murder actually happened and you're still considering overt acts for things that happened more than 5 years ago, then you can't just find overt acts in general.
No, that you can't. I mean.
So, but that's what Steele's arguing, right?
Yeah, I don't think that was argued back then. In that case,
I feel like I can picture. the state being wrong on
Your
this,
Honor,
that
we were
Judge Glanville
on,
made the ruling on that
um,
point.
176, line 6 is
Yeah,
what we were
and
just
like-
discussing.
Okay.
And just to be
Number.
clear, if the foundation is laid that Mr. Zachary is falsely asserting that my client stated that, then I understand that that's just going to be a subject for cross-examination. However, if it comes from a source, allegedly comes from a source other than my client, our stance would be that that would be either rank hearsay, something he read off the internet or something, or if it was said to him by someone else.
Okay.
I'm just using an example.
Sure.
Pee-wee, that would be spilling the beans. And that's,
Okay, well, and I'm rejecting your spilling the beans argument with regard to all of these things as they're going down and immediately after they go down. Now, if his source is off the internet, then that's a different story. But you have you have a basis for, I mean, they all get, whomever they get together at the studio afterwards and talk about it. So
Yes, Your Honor. And Zachary says we met up at the studio, and then Detective Dennis says they came back to
Yeah.
Metropolitan, and he says they say they just shot up the bus. So he's kind of responding to like a person he's around.
Mhm.
So, but understand, and we will ask him the right foundation for that before just asking an out of the blue question of, they
All right.
told you they shot up Little Wayne's tour bus.
Okay.
And certainly the next two, Your Honor, the state
Mhm.
is in agreement in regarding Mr. Sharp's number 41, page 178, line 1 through 2. It's a comment that Gaither makes, so the state,
I'm going to withdraw. Can we deal with 140 first? 40 first?
my apologies, I skipped over that.
40 is just him saying what he feels that there were cars following on the expressway. He wasn't there for that. And he actually says they probably followed them to the expressway, but I don't know if they followed to no shooting.
Yeah.
So he's just speculating there.
He's basically saying beats me. Yeah.
Yes, Your Honor, we will
Okay.
not be asking about
All right.
those cars on the highway.
40 is out by agreement.
41, I'm going to withdraw.
Okay.
And I just think it's needed to add context.
All right.
I think it would be improper in some ways, but quite honestly, it involves Mr. Steele's client and Mr. Adams' client, and Mr. Zachary says no. So I think it's needed to provide context to the no that Mr. Zachary gives.
All right. Thanks.
And Your Honor, number 42, the state's in agreement of.
Okay. All right. And then 43 is our last item on this statement.
Your Honor, we're also conceding number 43.
All right.
We'll not be talking about this
Okay.
topic
Thank you.
with Mr. Zachary.
All right. Then we've gotten through this statement.
So we're done. I think that was like the April 2017 Zachary statements. We're done.
All right. We'll take a break in just a second.
And most of it
Housekeeping-wise,
was even.
Did, Ms. Love, were you able to email over to everyone last night what you have so far?
I sent some, and then I.
Oh my
have,
God.
The broader folder containing Mr. Sledge's exhibits that numbered, and so I will share that. I haven't shared it because I was actually still typing in it just now, but I will share that with counsel for the defense. And Your Honor, as I look towards next week, it would be Mr. Sledge before Mr. Zachary.
Okay.
So,
So we did this in the wrong order, but. All right, that means we need to get to all of what might be used with Mr. Sledge today.
that's the folder that
Okay.
they're about to,
All right, well,
and it's not,
not voluminous.
I don't consider it voluminous. but it's not.
Okay.
So I'm gonna drop that.
All right, so
Please,
go ahead
miss.
and send that now. And then we've got to sort out potential jury instructions for when they come back today. We're not going to have court on Friday. Okay.
So she didn't have the
So,
thing done yesterday, and she
take
was
a
working on it in court
10-minute
today.
restroom break and come back and get to
Oh
work.
my goodness. So real quick, I had pinned some stuff earlier. Thank you for the cute sticker, watermelon juice. Thank you for the support, SD Hellfire. Good to see you. I know I think he became a member recently too. Recused Judge Glanville is telling Miss Love, Adrian, remember, just like we practiced last night, do the hand signals if you get tongue-tied again. So always a pleasure to see recused Judge Glanville. I love the new picture. We've got Fonnie Willis, Simone Hilton, and ADA Chief Deputy District Attorney Love right behind him. Also, Kel says, thank you for the $2, says, the defense graduated cum laude, and the prosecutor graduated, thank you, Lottie. I do think Atkins is doing a decent job. I'm appreciating him. Then FFS, so we thought Love was Googling how to properly lay foundation, but we found out just now she was working on the assignment she was supposed to send within one hour of court being in recess yesterday. She still only sent partially yesterday and was working on in court today. And now she wants to change the witness order, so that's a good time. Bridgetta says, thank you so much. When will the streets be on the stand? Your Honor, we'd like to call the streets as our next witness. And to double back on the thank you, Lottie, Mahadi says, Fordham University Law, Bronx Steel. And Otto, thanks so much for the gifted memberships. So good to see you, Otto. Hold on, I want to yell gifts in the chat. That's so, so nice. You guys know I love the gift feature. And guys, say thank you to Otto. Otto has a super cute picture. That's actually Otto in the picture. So when you shout out Otto, you're also kind of shouting out Otto the dog. And thank you so much, Aussie Tank, with another 5 and another 5. So big love to Otto and Aussie Tank in the chat. So if you guys are now members, make sure you take advantage of your Mario Kart emojis. And thank you so much, Aussie 10. Giving 10 memberships is so sweet of you. And then, no. Kel says, Love, the dog ate my homework. Otto, are you eating Love's homework? And then let's see, where are we at? Nana, oh, good to see you. So Nana Misty's joining late and says, hello, Kat, Nick, mods, and crew. Shout out to the mods. It's going to be Drea's birthday on Saturday, so 2 days out. She's baking her cake today. And then hope you're having a good day. You too, Nana Misty. And then Ava, if Woody doesn't testify, does the state's case go down the drain? I think a large part of it will come out. But at the same time, I really think Woody testifying and being cross-examined could be a big help for the state. So I don't think Woody not testifying would be like the biggest win for the defense and the biggest loss for the state necessarily. Because they've already gotten some stuff in. The jury's seen some stuff from Kenneth Copeland anyway. I don't think that stuff was that helpful for the state personally. But I do think it would be a win for the defense to be able to cross-examine him. And I know there'd be a lot of drama. I think there would be issues if he gets on the stand and says something that we need to kick the jury out. So not really sure. I don't think the case will go down the drain, but I think it'll frazzle them and they'll get off rails and this was all for nothing. So thank you so much for the 5. And then Nick.
Yeah.
So you got a little echo from me.
Yeah, I know. I'm trying to fix it with. Why am I not? Am I gone completely?
Hold on, no, I can hear you.
Okay. Yeah, I'm trying to fix it with my other phone because my in-ears, when I put them in, I can't use my microphone.
Oh, so you can't hear both at the same time?
No, I can hear, but the microphone doesn't pick up my voice.
Yeah, it's definitely garbled. I think someone said it sounds gravelly, and that's a good description. It sounds like there's like fuzz in the cord.
Could you send the link to my email instead, because I'm trying to get in through my other phone. I had to buy a new one because this one isn't eSIM compatible, so I had to drive to an AT&T and buy a new phone. That was fun. Oh, I don't know if that was supposed to happen. Cat, where did you go?
Sometimes when I click the invite button on StreamYard, sometimes it's just pulling me off the screen. It does it about 50% of the time. Like the pop-up window does something funky.
Mm.
And it pulls me completely because it pulls the shared screen as well. So I'll email you.
Yep. Okay. Then I will skip out and I will see you through my new phone.
Okay. Sounds good. There we go. We're going to get this fixed. Yeah, I got booted off. This is the takeover. It's a coup in the YouTube channel today. And then let me make sure. I know I have Nick's email somewhere. But that's gotta suck. Oh my God. Someone said in the chat earlier, if you are traveling, keep your electronics in your carry-on. Don't put them in your checked bag. And, you know, that might be something that some people take for granted. We think that we know that, but maybe it's worth saying out loud. If you're not used to traveling, you've never thought about it, you've never brought electronics with you, that can be a big issue if your bags get lost, your luggage gets lost. So keep the things that you need, no matter what, in your carry-on. Big, big tip. Okay. So there we go. And I'm still laughing about this. I'm going to say that it was Otto that ate Love's homework. Good job, Otto. And then Dublin Bug, good to see you this morning. So we'll get this back up when Nick comes back up here. That's a rough... First of all, I hate flying, guys, so I can't imagine how Nick's feeling after a long flight to get overseas. And then to have your luggage lost is just not a good time. So I'm going to pin this for when he comes back. Dennis Nixon, thanks for becoming a member. And then FFS says, love to Atkins. Where'd you learn all this stuff? And then thanks so much for the super sticker growing. That was really nice of you. And I would love when Nick gets back to have this conversation about an earlier comment I had saved from FFS. So can you see Judge doing a JNOV if the case even gets that far? So judgment notwithstanding the verdict. Now, there's another thing that's kind of parallel, it's a little bit different, called a directed verdict, which could be if at the end of the state's case in chief, the defense moves to ask for one and makes their argument for it. The state can respond and oppose it. The judge could find, and personally I don't think they will find in this case, but if they don't think it's really a sufficiency of the evidence kind of question. The state rests their case. They're the ones that have the burden of proof, which is why a directed verdict can be asked for. If they haven't met their burden to prove the elements of what they're claiming, the defense could argue, and maybe successfully, that, look, Judge, you should just issue a directed verdict right now. You make the decision that, dismiss this because the elements of the crime aren't met. There isn't sufficient evidence to meet the elements required to prove these charges. Now, a judgment notwithstanding the verdict would be the jury actually makes their decision, and then the judge steps in and says, look, this decision is an extreme, misjustice. Something went wrong here. I'm going to make a different determination. I'm going to enter a different judgment than what the jury found on one or more counts. And what's really cool about something like that is if there is case law, and I saw Rob O'Neill posted some cases in the chat that I wrote down, so maybe I can pull them up. If the judge does see this case law that, there is an expiry the 5-year statute of limitations. So if the jury finds that we don't find the defendants guilty of things that, you know, the statute of limitations is longer or whatever, like the murder, we find them guilty of like maybe having possession or something more small, but they still find guilty of the overt act for those activities. Well, then the judge might be able to say, well, I'm going to enter a different judgment because by law, that act is outside the statute of limitations. So interesting that you had sent this at the beginning of the stream, and now the judge might be considering case law that Brian Steele says he has. If she agrees with it, I think that could be a nice it could become relevant when the jury returns a verdict if they aren't properly instructed or if they don't quite understand. And their decision falls within, we decided on an overt act, but it was really for an activity that was expired. So, or where the statute of limitations had expired. So, sorry I got to your question so late. I knew it would be a bit longer of a discussion, especially because I wanted to mention a directed verdict and kind of explain a little bit about what it is. But I think it's actually kind of a bit more relevant now if there is that case law, as Brian Steele says, and the jury were to find just some acts are applicable. We don't agree that the state has proven their case beyond a reasonable doubt about these major acts, like the murder of Donovan Thomas. So thank you so much. You know, I always love the food for thought. And then let me get back over to the chat and see what you guys are saying. I just got Nick emailed, so if Nick's in the chat, I just sent the email your way. And then I had saved this earlier. So Positive Masculinity said this emoji looks exactly like Judge Whitaker, and I agree. Okay, and let's see. Let's see how you sound, Nick.
Okay, do I sound better?
You're not garbled. Let me see if I can get rid of your echo.
Don't. Because now I
Right,
have
say
my
something.
in-ears and I can hear you.
It's a little better. You just sound like you're in a room with no stuff on the walls.
Well, I. Ah, this is annoying. Sorry, folks.
And then I was gonna say too, guys, you're asking about the mistrial. I mean, I don't think we're lacking a grounds for it. I do think mistrials are a rare exception. Look, all I can keep saying is the judge has told us what she's focused on. She doesn't want to keep hearing that it was Glanville because Glanville's no longer on the case. She does want to see that there's a different reason besides Judge Glanville being the reason for the mistrial. She's hinted that she's tuned into Brady issues relating to the ex parte. She's tuned into that she's interested in the defense possibly not being present for a critical stage of the trial. And I do think she tried to cure the critical stage issue by saying, we'll just start completely over with Woody, and then we'll bring him in, we'll discuss the immunity issue with him. But I'm not sure, especially since the defense isn't agreeing to rewind previously. They want to keep June 7th through June 12th in. I don't think she can actually say the critical stage issue was cured because it's not a full redo with Kenneth Copeland.
Yeah, since there are one more ex parte meeting, then no. I mean, the 10th, she kind of cured, but then all of a sudden, oh, there was another one.
Yeah. And it's like, what do we do with that then? And what do we do if there were more? Because how did all these other witnesses that were uncooperative suddenly get their deals in place that they were suddenly cooperative? But at the same time, hear me out. With the way Whitaker, do you think Whitaker would hold these ex partes with the state to allow them to do what they may have done with all the other witnesses that didn't want to testify? The state is worried about Zachary. They've said they don't think he's going to be cooperative. They're trying to change the order they're presenting him last minute. They've been asked like 3 or 4 times who their next witness is if Copeland doesn't testify. And they've said Zachary, and they don't know after that. Then they finally said Sledge will come after that. Now, all of a sudden, we need to call Sledge when we should have told you this morning, so we could have started with redactions for Sledge right away. So when was this change, this audible called?
Yeah. The lack of Glanville is seriously hurting the state's case.
Yeah,
Because
no, it
they knew
seriously
he
is.
could. Yeah, they knew he would just punt it forward and then approve of it, and on occasion say, "Don't do that again." But yeah, I specifically recall Miss Bennett, who they actually threw in jail for not cooperating, for what they alleged not cooperating. Was she told the same thing, that if you don't testify, we will keep you in jail, not only this trial, but indefinitely? And she
And
lost
that's
her
just
job.
sad. And she had a different reason for not wanting to testify. It wasn't for self-incrimination, or, they couldn't cure her with, plopping immunity on her. Their only thing was to
Exactly.
threaten her with the contempt.
Yeah. And what if there are no transcripts? What if those was just one of these, as I believe, when the state made the PSR motion, I think that was handed over, but there was no transcript, and we don't know if they called each other on the weekends, because that will be an extremely high bar to even be closed
All
for the
right.
defense to get phone
If
records.
y'all
I
have
agree.
just now gotten the evidence that is gonna go with witness Sledge, I don't know if y'all are ready to tackle that right now, or.
It can't be, because it's still sending, uploading. So I'm on Dropbox trying to.
All right, well, what all is it? Because, presumably they've gotten it all before in Discovery anyway, right?
Definitely have, and I can do that.
Yes.
I can address, Mr. Sledge gave a prior statement that's can be played on evidence reviewer, following his arrest for the 2015 alleged shooting of houses. He was arrested, as well as Mr. Zachary.
Okay.
I can address that. And there was one on what Mr. Adkins said. There was one jail call that was identified, and I can address that as well. I don't know if there's more, but his statement I can address, the jail call I can address.
So those two, he's correct, identified those and given them to those. The statement is the statement we mentioned earlier. And the jail call is that Mr. Shard is correct in those. And if we are ready to respond to whatever it is that they bring up while we're sending the rest of it.
Okay. The prior statement he made in 2015, he's brought in regarding the ag assaults, and he is questioned. He's Mirandized. He gives a statement. He denies any involvement. He later pleads guilty.
Okay.
Or offered, I'm not sure. He pleads somehow. He resolves it short of trial. He's just denying being there. So I don't know under what circumstances that statement would be used to impeach any testimony. I suppose he acknowledges that he knows Mr. Zachary. So I guess if he said he doesn't know Mr. Zachary, I guess that could be used to impeach him, but it doesn't seem to be a statement that would be used to impeach him or would necessarily be played. His jail call, I've listened to it. It's essentially him. He had a preliminary, he was charged with the murder of Donovan Thomas by Detective Thorpe. The state has since determined that he is not responsible. He had a prelim where no probable cause was found. After the prelim, he calls his significant other. I'm assuming it's a significant other. It sounds like it from the context. And he basically talks about the testimony at the prelim. He speculates about who witness 1, 2, and they used codes in the prelim, witness 1, witness 2, witness 3. He speculates about who that could be. And he basically says, it sounds like witnesses 1, 2, or 3, and, you know, or some combination of within those 3 people really threw Shannon under the bus.
Okay.
So he's commenting, he's speculating, he's commenting about testimony he heard from a detective about what witnesses told the detective, and is just giving his commentary. It sounds like people really threw Shannon under the bus. I have no idea why anything from that phone call to his significant other would be admissible in this trial.
And Judge, the phone call would only be necessary if Mr. Sledge said something contrary to what he's indicating in the phone call. And I think a broader context, a broader sort of description of that phone call and what he says is necessary. So a few things are going on. Mr. Shard is correct. He's, there's a prelim. He's talking about stuff that has happened. What is most important in terms of the preliminary hearings are that Mr. Sledge is, he's privy to information that is given in other preliminary hearings of other YSL members. And he's aware that during his own, they are talking in terms of witness 1, witness 2, witness 3, rather than giving names.
Right.
What he says is, Lil D told, and Lil D is the witness that we've just finished listening to, Mr. Zachary. And he said, I can tell Lil D told because of, and he gives the information that was given by witness 1 or Lil D. He said, I can tell witness 1 is Lil D because he says this. So the fact that as he's discussing with his significant other, the information that he has learned while he's been in jail with other YSL members and in court, and he is not asserting that so-and-so lied or on Shannon. He is saying he threw Shannon on the bus, or they told on this particular person. That in conjunction with his factual acknowledgments in his plea agreement that he made when he entered a guilty plea in this case, we believe it establishes, 1, the nature of you do not tell. 2, he has knowledge that people did tell, and he is not saying this didn't happen. He's not saying this person just flat out lied. There's no way. And it also explains indirectly why certain things may have happened. By certain things, this part is just an argument that would be made later. But if I were to make a statement in closing arguments that, of course, Mr. Zachary changed his story, everybody learned that he told, and he knew that everybody learned that he told, and now he's being looked at as a rat. So the call that Mr. Sledge makes and the content of that call are necessary for a number of reasons, and they become very relevant when put in the context of other evidence that we will be introducing at trial.
Okay.
So we can play the call for the court. We have it. It's a single 15-minute call.
Hey, Kayla.
We might have to do the 60 seconds that allows all cap rage for listening to love.
I mean, how she almost stutters on her words when she tries to explain, because all of a sudden she has to be formal. She has to apply law and due process. These are things that are completely strange to her. I don't think Kat wants to see my all caps words I have about Miss Love.
Failed the smell test. Why is she like that? There's always so many grrs when we do this. Everyone's like, grr. Ah.
One of my viewers sent me a list of words you're not supposed to say on YouTube.
Oh yes, Ghost. Thank you so much. Ghost gave me the 2024 list of updates. I have to actually look at it, Ghost. I saw the notification message, but didn't get to read it yet.
Yeah, that explains a lot, because a few of those words are used instead of worse words.
Final 10 seconds, you guys. Final 10 seconds for all caps shouting. Yentas. There we go. Thank you guys. It's always a good time when we do our 60-second venting sessions. We'll sing in slow motion for me. She does kind of speak slow. It might be the right song.
Fulton County Jail. This call is subject to recording and monitoring, and your location information may be collected and used by corrections and law enforcement. During special moments as .net to learn more.
What you be telling Quanah for her to be doing how she be doing that? Man, I ain't even talked to Quanah. I seen Quanah in the courtroom with Tip today. I swear to God, I ain't even talked to Quanah. I seen in the courtroom today with Tip. I was shocked when I looked back. I don't think what made me look back, because when they first started calling the charge out, that nigga Peanut them dad punched the damn thing and got up and walked out. The folks did miss you today, though. You know, Derek called me and told me everything. What did he say about the bond, though? He said,
Yeah, I'm sorry, but that is entirely too muffled for me to understand what they're saying. I'm happy to listen to it at lunch if I need to, but until I can figure out how to hear it through Zoom, or, you know, if y'all want to, sometimes attorneys will bring another speaker, but if I need to hear what's being said, I can't from there. Sorry.
So I do have things, but I'd rather test it and then, well, I can try and test it, but I can send it to the court.
I mean, if there's an interview we need to get through anyway, why don't we just do whatever the small, I guess, more discrete objections are to that interview.
So Mr. Shart's characterization of the interview is correct. What he does during the interview is essentially he's telling the police, you know, you don't have to do your job. So there is no particular reason at this point that I see that we will be playing it.
Okay.
It is not, it's a statement that a witness has previously given, and if a reason arises, I just don't see a reason beyond, you know, you didn't want to tell him until you, I don't see a reason that I'll be playing it, but it's his statement that he gave, and he's denying it. He's saying to them, do your work.
All right, well, Mr. Shart, do you know what the discrete portion of that is? And then maybe we can just see whether, even if she does maybe want to use it for some reason, she can say, oh, I'm definitely not going to use that.
I didn't identify any.
Okay.
Speaking for Mr. Still, Mr. Still was not mentioned in it.
Okay. All right. Okay. So Anybody else have issues with Mr. Sledge's 2015 statement that the state's probably not going to use anyway?
Mr. Williams,
All right.
if it comes up, though, obviously we'll deal with it.
Well,
There's nothing in that statement that is harmful to Mr. Williams,
Okay.
but, depending on the circumstances, we'll find out.
all right. Well, anybody else? Silence from everybody else. Okay. All right. So, as to the telephone call, is there anything in particular y'all want to direct my attention to? Y'all know what it says, even though I haven't been able to distinguish it yet. Or you just want me to listen for the whole?
I just object. I mean, it's Mr. Sledge reporting to his significant other what happened in his hearing that day. And I don't know this for a fact. I believe that he had the prelim. I believe it was him and Mr. Stillwell together.
Okay.
I don't know that for a fact. I could be wrong about that. But he's just commenting. The investigator Dennis, I believe, is the person. It may have been Thorpe. And I wasn't at the prelim. I didn't represent Mr. Stillwell back in 2015. And he's just commenting on witness 1, witness 2, and witness 3, and who he thinks they are, and his significant others commenting back. I don't know why the state would think because Mr. Sledge, who they're saying wasn't even at the shooting of Donovan Thomas. Okay, they haven't charged him with that.
Right.
I don't know why they think that the fact that Mr. Sledge isn't saying that's a lie about something he wasn't even at is somehow a tacit admission against Mr. Stillwell. It makes no sense to me. And
Okay. No, I mean, that I can see the logic of it. It may be that on that issue, it is inadmissible and not relevant. But in terms of him being able to tell from what witness 1 says and doesn't say versus witness 2 or witness 3, that he knows who that is, it may be relevant to their whole concept of everything that goes on within this YSL gang. Everybody shares the information for, and, I'm tight with him and I know what's going on. So, which is one of the issues that they thought it might potentially be relevant for. Now, they'd have to have a reason to play it. And I think we're going to have to wait and see on that. But if that becomes actually why they're playing it, then I think I would overrule a relevancy objection to that if it's, legitimate.
I don't foresee any situation where Mr. Sledge, I'm fairly confident is going to say that he knows all these individuals. He knows Mr. Zachary very well.
Yeah.
He was charged in a separate crime and pled guilty to that crime with Mr. Zachary. But even then, I would, even if it became relevant for that, which I can't foresee any circumstance, I would strenuously object to him commenting on other people's testimony about a case that
I understand.
against my client that he wasn't even present.
I mean, I
according to the
understand.
state.
And it may be that, and I think even the state's saying, I don't know that there are circumstances under which we'd be able to get this in, this would become relevant. If there are such circumstances, then I would think that much less than the entirety of the phone call needs to be played and we can limit it then. So maybe Miss Love, if you are thinking, or it starts to look like you're going to need it, then if you can, get with the defense beforehand and y'all come to an agreement, understanding what my ruling then would probably be on what part would be relevant to that and what part wouldn't, instead of just, hey, I'm getting this whole 15 minutes in now. Okay.
Yes, I can do that. That makes perfect sense.
All right. Okay. So then anything else on Mr. Sledge's, the evidence that might be used with him at all that we ought to be looking at beforehand?
So the other items that and I've shared, if I don't know if anyone has been able to, if it has shown up, but I've shared the link with everyone except Mr. Howell, whose name just wouldn't populate.
We just received.
Right.
Yeah, we got Nick on Love's laptop today.
All right. So what other evidence is there? There's the phone call. There's this interview. What else?
So there are also.
In case I will ever be on Miss Love's laptop, it is what for an arrest warrant.
The agreement of Mr. Sledge.
All right.
We have had the need to play other witnesses' plea agreements.
All right.
Thank you, Black Butterfly.
Well,
At this point.
I'm really holding back now on the things.
Then we don't have any need to play that.
right.
If it begins to intimate that I didn't know what was going on, it wasn't really freely given or
Right.
anything like that, then we would want to show him entering that plea.
Okay.
She doesn't know what her strategy is.
We also have, and we may have already admitted this, we're checking the exhibits, but there is the video where Mr. Sledge is with Mr. Zachary, and they are threatening Kelvin Watts. We've labeled that, if we haven't already admitted it, as State's Exhibit 398 Yankee. There is Mr. Sledge's cell phone records, which we would be using or asking Mr. Sledge, is this your number? Was this your number at that time?
All right. And would that be the only purpose of the cell phone records?
Well,
Or you plan to be using the cell phone records to show some things?
to ask him about numbers within them. to
Okay.
the extent That he remembers.
Okay.
If he doesn't, to ask him about specific
Sure.
persons and numbers.
All right.
And of course, we have, Agent Bernie later on who
Is going to be able to say whose number is whose, I guess, right?
will be able to apply it. Now,
Okay.
we have Detective Dennis who would be able to say, and ADA Sprinkle, who would be able to say what we determined was the owner of the
Okay.
accounts for each, the numbers that are
All
relevant.
right.
Please have Mr. Former ADA
Y'all
Sprinkle
anticipate, did the defense
who
anticipate objection
dismissed the charges?
to
Yeah.
that?
want him on the stand.
You just want Sprinkle to say Sprinkle again.
Yeah. Who wouldn't? And he looks like a hobbit. Everything is
Okay.
so
And
perfect
how
with
about
that
the
and that name.
398Y video being used with, I mean, if it's already in, then the evidentiary objection's been dealt with anyway, but we haven't, I don't know where that list is right now.
Put a 1 in the chat if love makes
And
you feel
he's
like
in the
you could do
video.
this.
He is.
Okay.
We're talking about the video with Mr. Zachary and Mr. Sledge. I don't think I've seen that.
Okay. If it's not, that will be 398Y.
Uh-huh.
And Mr. Sledge, I believe during his interview, he talks about that.
Okay. Is this like a music video?
No, it's a video, like a selfie video.
Okay.
Or someone filming.
All right.
and Mr. Zachary, threatening Kelvin Watts.
Okay. All right.
If there is, we can play that, it's not even long, it's about less than 5 minutes long, probably about 2 minutes long. If there is a specific objection to that.
Y'all all seen it? Is there a specific objection that you know of now? or that you know you might have?
Just want the instructions, I think that you talked about that we did, 105, Ms. Williams is not in that video at all, and it's up to the jury to determine whether that should be.
All right, well, I mean, I keep asking for an instruction or a proposed instruction, and so far nobody has been forthcoming with one. So, and I've told y'all until you get me something to consider, there's not much that I'm going, the burden, the onus is on y'all at this point, okay?
I think we,
So, and considering this is our last day of court before we bring the jury back on Monday, now would be the time to do it.
Your Honor, you should be receiving that shortly.
Thank you.
And Your Honor, with respect to the video, well, I'll just wait to see what limiting instructions, because it goes to count 1 against each of the defendants.
Right.
So I'll just wait to see what the requested instruction.
Okay. So a potential limiting instruction, but with regard to anything else about the contents of the video, y'all don't anticipate an issue? Okay. All right. Any other evidence for him?
There's two social media posts made by Mr. Sledge on the night that Donovan Thomas was killed.
Okay.
And they are, one is Mr. Sledge is that night around the time of the murder, he's watching the Patriots, and he captions it that he's watching the game, Let's Go Patriots. And there's another one where he is shown watching the game
Okay.
with his small child.
All right.
There is what we label Stacy Exhibit 399 Yankee. It's a video of Mr. Sledge. He is saying, if you go in the courtroom and tell, if you testify, it's not great. Basically, it's how do I say this? So you lie to your significant others, you lie to your family, and then you get in the courtroom and you tell the God's honest truth. Essentially, that's bad. I can play it. It's 13 seconds. I can play it for the court.
Well, does the defense know the video she's referencing? Yes, it's already in evidence.
Actually, Mr. Williams's video saying that is in evidence, not Mr. Sledge's.
Okay. Maybe not in evidence. 399Y Yankee.
I turn my microphone down. Just let me know if I need to turn it down more.
And I'll just
All right.
share it so we can-
Okay, we'll figure it out during a
Okay.
break too.
Share it via Zoom. All right. A sec. to get
While they're
Zoom
loading
open.
this, Delicates of Life, I just put
All right.
the response
You
from
lie
Fonnie
to
Willis.
your kids, you lie to your mama, but you get
In
in
the
the
chat.
courtroom and in the investigation room and tell them punk ass people the God honest motherfucking truth. Pussy ass.
That's it. There's a word he used, but yes, that's the extent of that video. And this, we'd argue, it shows the sentiment that YSL members have towards, frankly, towards, people telling them.
Okay.
Object to that.
All right.
That
And
may be, I think this video, it could be argued, shows Mr. Sledge's sentiments. Mr. Stillwell's not in that video. He's not speaking for Mr. Stillwell. I don't know. There was no vote to make Mr. Sledge the spokesperson for this group of gentlemen, and I would object. Mr. Sledge is not sitting here with us,
okay,
so I
has
don't
he-
know how that's a comment.
He already pled guilty, right?
He did.
Did he plead guilty to the RICO count?
He did.
Okay. Y'all can cross him on that topic. What about the 2 social media posts with him watching the Pats game? Any contemplated objection to those?
Hey, football
Okay,
starts
what
today.
else?
There's also a video that he posts, not a video, but a social media posting that he makes on June 24, 2015. Free little D, like right now. And that is, looking to share it.
Is he saying it, or is it just like a written post?
It's just a written post.
Okay.
It's just,
Okay. Anybody anticipate objection to that we need to deal with now?
I don't know specifically what she's oh, is that it?
on the screen is the post. Oh, and I need to zoom in.
I just don't know what the relevance is of some of these things. Like,
So 6/24/15, what's just happened? Why is he in? Why is the little D in?
This is
Which little D is it?
Demikian Darlington. And he has been arrested. I can tell you the reason that we're wanting the relevance of it.
Okay, what's up?
It's the urging of each member. We don't have just him. We have him saying free little D, free the other little D, free various members of YSL, as we have with other defendants that are currently on trial, where, for instance, when Mr. Winfrey was arrested, Mr. Williams had free Roscoe shirts, they're wearing it. So they're advocating for the release of their fellow gang members, and it shows their solidarity, their support for, and the existence of the organization.
All right.
I would more accurately, in my mind, say that he's posting free his friend, and to the extent that Mr. Sledge says he doesn't know Lil D from Mechanicsville, that's Demikian. That picture is of the Demikian Garlington, Your Honor.
Okay.
To the extent he says he doesn't know him, or he's not friendly with him, or I mean that maybe that would become relevant, but
Yeah, I'm going to permit it over a relevance objection to show or potentially show the issues that Ms. Love has said she would offer it for. And of course, y'all can argue that all this shows is he's concerned about his friend, but that's a topic for argument. I think it is relevant, though.
Your Honor, there's one issue that I failed to bring up earlier.
Okay.
Regarding a video of a plea, and we dealt with this earlier in the trial, and I know that we did some redactions. I would object if they're bringing it in to show that if it becomes an issue and that a plea was freely and voluntarily entered, going through the Boykin rights and things of that nature, I would understand. Going through the state's factual rendition and their of the plea and just their testimony and their story, we would object.
The factual rendition, unless you have him then affirm, yep, that's what happened. And unless he's now saying, nope, that's not what happened.
That part is
It all just
exactly what-
depends on.
That's exactly.
Okay.
Yes.
So yes, I mean, depending upon the reason that the plea might end up being potentially used. Yes, I agree with you. If it's to show voluntariness, then the factual rendition is not relevant, and I would not expect y'all to try to play that. If it is to say, dude, when you took your plea, you agreed that all of this is what happened, and he has in fact agreed, yep, that's what happened, then and that's what I'm pleading guilty to, and it's not an Alfred plea, then the facts would be relevant.
Right. And so we've heard creative ways to sort of distance witnesses from prior acknowledgments that
Yeah.
they've made. So some may have expressed a lack of an understanding, or some may have expressed feeling pressured. And then during their plea colloquy, they actually shut it down and were.
Okay, so yes, but understood. It's not necessarily all in, it is just going to depend upon the reason it's being offered. And just as with whatever the, reasoning for the phone call, and I'm not going to say this as to every little piece of evidence. This just needs to be how y'all operate going forward. At the point in time when you anticipate, oh, I actually am going to use this. I didn't think so before, but now I am, or whatever. You tell them so that they can, so that all of us don't have to be scrambling, okay?
Okay.
Advance notice to the other side about things that you know are likely to be evidentiary issues, so we can deal with them at an appropriate time and not be sending the jury out every 10 minutes.
Law school 101
Judge,
again.
When we can we will definitely abide by that instruction. And I guess we'll ask for more granularity, a little bit more clarification if in the middle
19
of
months.
questioning.
Obviously. And I mean, that's why we're kind of going through all of this now, is so that most of it you're already going to know in the middle of questioning. Here's how I can use this. Here's the part that needs to be redacted out, whatever. But, like for one of them, you said, I just really don't anticipate in any way using that. And then if you're like, oh, we're in the middle and we take a break at lunch, you tell them at lunch, at the beginning of the lunch, yeah, I'm going to use this after all. It's just as much heads up, as much advance notice as possible. And given that you are supposed to be providing all of the evidence in detail for, the first 30, and I think you're almost to the point where you're supposed to provide it for the next 30, this shouldn't be an issue. But, okay. Mr. Harvey,
We'll see.
you wanted to say something.
Yes, one other point, Judge. With the previous exhibit and this exhibit, we previously had a ruling and discussions about the commentary on these.
Oh, I can't even see that because of what's on my screen. But yeah, I don't think, unless the comments are relevant, let's not have those on there.
So
Now, sometimes the comment might be relevant.
But we don't know who's making the comment. We can't cross-examine the commenter. And we have had Judge Glanville rule that the comments come out previously.
Okay.
I mean, who is this that's commenting? 70 likes, one comment,
Okay.
come
All right. So
Harvey says the chat can't come in.
I agree with the prior ruling, and I don't know that this is how you were going to present it on the stand when you use it. This just may be how you got it now, but make sure before it shows up on a screen with a jury that whatever limits have been placed on this, you abide by them. I mean, I saw the slide from the opening.
Okay, Judge.
That had something on it that had been specifically talked about and ruled that you had better not in any way put that before the jury. And lo and behold, it's up there on the screen. Not going to get back into it, but that should not happen again. If you know that comments aren't supposed to be on here, you need to make sure before you throw any slide up. And I'm not saying that this was how you were going to use it. I know you're just giving this to us right now, but just make sure everything is clean to the way that it is supposed to be. Okay.
And to be very specific, so there's no misunderstanding, the comments, what the court has just said about unless there is a relevant portion in the comments, for instance, the witness on the stand comments about something else.
Okay.
And for those instances, I would do as the court has instructed and say, hey, these are social media posts. This one right here, I am going to attempt to keep in, and I'll share it as I'm going to present it. Right now, it doesn't have.
Nope,
Why do you
you're
need
not
to
going to share it
reiterate
as you're going to
this?
present it. You're going to share it with each tranche of 30 witnesses, okay? If you know oh, somebody has this incredibly, damaging, I want to use this comment, I'm going to use it with this witness. Tell them as you're going through your tranches of each 30 witnesses.
Okay, yes.
Okay.
Thank you, Judge Whitaker.
But the comment that is made by the witness, which is on the left side, that we would do on the screen.
Yeah.
You
Mr.
could have
Harvey
just said
agrees
nothing,
that-
love.
Yes, he's talking about the likes and comments and what have you on the other side. Those don't need to be included.
Okay.
We might have to do another
All right,
60-second
super.
vent.
Thank you. Everybody's in agreement.
So the next one, Your Honor, is the post on June 15th, 2015, where Mr. Sledge is saying free Jimmy Winfrey and FUXK12 and KANT, hold the real one down. And he tags Mr. Williams on the left side.
Right.
So this is absent the comments on the right. This is the post that we would.
All right. And if you already have that as an exhibit number, you can tell us now. Otherwise.
It's State's Exhibit 401 Yankee.
Okay.
And the exhibit number, as we have it listed, is up in the upper left corner, almost imperceptibly.
Oh, all right.
Quite see.
Okay.
Does the court want me to just keep going?
No, we don't want you to keep going.
I'm not hearing any objection.
The next one is State's Exhibit 402 Yankee.
All right, we don't, if you've got a series of free XYZ, free ABC, and they're all pretty much the same, then I don't need to see them all right now. They're all gonna be the same issue, and you can do that.
Okay. This is not saying free anybody, but it's saying happy birthday. to
Okay.
Mr. Stillwell.
Okay.
Stop putting me on fucking fake pages, cause I don't give a fuck, man. What y'all say, what y'all do. Anybody want to see me to? I'm here. I don't hide, and I do not run from fuck niggas. You did.
Your Honor, this is relevant, and we would seek its submission for you hear the comment, but then at the bottom underneath the photograph, it has NAW, FR, for real, 100, 100. And then the two little green snake emojis.
Yeah. Which are alleged to be a YSL gang symbol. Okay.
Yes.
Yeah.
We've already admitted the content, the group photo that is now labeled States 405 Yankee, but because of what Mr. Harvey pointed out, that we had taken out comments, I was not certain without looking back at it whether the YSL, FUXK, the rest love had been admitted, and for that reason, I sought to admit the whole post since this is the witness that made the post.
All right, well, you can go back and look and see. Let me ask y'all, with regard to these things that are electronic as we look at them, are y'all printing out a hard copy and using that?
No, so we are in fact giving to the court reporter and showing to the defense contemporaneously with publishing
showing it
to the
on the
jury
screen.
digitally. Yes.
Okay.
And
so I guess the reason I'm asking is, so whenever you used 405Y before, how do you now know whether it contained the comment at the bottom or not?
We have given the court reporter hard copies.
Okay.
That is not the case with all of the exhibits that have been tendered. We have, but that's how we know what.
So y'all can go back, well, you can go ask Ms. Weaver on 405, why does it contain the comments or not?
Right, we can go back and it won't be labeled 405Y. We have the list of the exhibits and we have the description.
Okay, well, whatever it was labeled at, let me ask you this. If it was labeled 205Z before, and now and we find out that it does in fact contain those comments, you're not going to re-tender it as 405Y, right?
No.
That's only if it doesn't contain the comments.
Correct.
Okay.
And definitely to the extent my colleague is expressing that the court may not understand me to be saying explicitly that we are printing our exhibits that we have tendered and shown digitally. And we have given to the court reporter the physical printout of any digital exhibit.
Okay, the physical printout as well as the digital exhibit, right? Or by the end of trial, you will.
Right.
Right,
For the
okay, that's
digital.
fine. And I know that Ms. Weaver, and whenever we get probably in a couple of weeks that the jury's gone, we'll take up, let's figure out what evidence is actually in and out. Maybe that's what we'll do that week. Not the whole week. We'll get lots more done than that. But I do know there is an issue with regard to a couple of defense exhibits because they were only shown, I think, on a laptop, and we'll just have to sort that out at some other time. But we do need to think about going forward. If you're walking up to a witness and showing them something on your laptop, you might need to take a screenshot of what's on that laptop so that then the court reporter knows what it is. Okay. All right. What else?
Nick said he got a call about his luggage, and I
this
wanted
is
him
a
to see
similar-
Dublin Mug's chat
All right.
before he heads
All
out.
right. So I'm going to basically,
So I'm going to
Thank you,
catch up, but I wanted, we'll put it on
Thank you,
1.25,
Dublin.
but that way you can speak.
Yeah, thank you. And thank you for having me on for a bit. I will try to do recaps on my channel, but since I only have my phone, I can't do it with live. I can't live stream the trial and so I'm having issues. So
Well,
thank you
it's
for
not a
having
problem
me
at
on.
all. We are happy to have you. I am so sorry about your luggage. That is a nightmare. And I know you got a call you got to attend to for your luggage, and I hope it's like good news about your luggage.
So do I. It's been
Everybody
4-letter word
send good
disaster.
luck. Good luck to Nick.
Thank you. I have to go. I will do a recap later today.
Good luck.
Oh, I can now say afternoon because it's afternoon for me as well as you.
I know we're not like 8 hours or whatever apart.
Yeah. Okay. Thank you. Bye-bye.
Good luck.
rule generally, unless you think that there is something particularly, oh gosh, I think that there's going to be some other kind of relevancy or 403 objection to something. The posts that are just seeming to show
That was a
is
weird camera angle.
posting about gang life or indicating gang insignias or anything like that. Those would be relevant. And if you think there's some kind of 403 thing as to something, then pull that up. But I don't need to go through every little bit of evidence. I want to be hitting the evidence that you think the defense is going to have an objection to that we need to hash out beforehand.
I don't, so
Okay.
there are 3 videos
Mhm.
that are also social media postings. I
Okay.
don't see anything that would be 403 there. For instance, 416, Stacy Exhibit 416 Yankee has Mr. Sledge. It also has Mr. Williams and other alleged associates or members of YSL in it. And they are sort of just congregating it.
Okay.
I can since I've shared it, I can let defense look at it. It's labeled in the shared document as well.
All right. Well, and ideally, again, after they've got the big list with the 30 and all of the exhibits, then they can do their homework and they can actually tell me, like Mr. Short did for Mr. Zachary's statements, hey, here's what I find objectionable about that. So once y'all got that, y'all can do that with everything and it'll be more smooth. All right. So, but you think that pretty much for Mr. Sledge, after what we've discussed, you'd be good to go, and the defense
I-
likewise. Okay.
I do. I have shared with the defense just the case that is like the printouts from Mr. Sledge's federal case. I
Okay.
don't foresee, I'm not going to try and tender that as evidence. There may be a portion of it that I reference or need to reference, if depending on how he testifies, to refresh his memory or something, but I'm not going to try and enter his federal case as evidence. And I think that's it.
Okay.
Mr. Sledge. And his certified copies of the conviction, his proffer, his factual acknowledgement, the physical documents, those we have labeled as states 394.
Okay. All right. I've gotten the proposed limiting instruction now, and Mr. Matthews, you are requested in my other courtroom for the trial calendar. You know what that issue is? So can you run up there to the judge handling that case real fast? We'll recess I'm probably just going to stay here, but we'll recess for 10 minutes. It shouldn't take longer than that. And I'll take a look at this proposed limiting instruction. All right. And then we'll come back.
Okay, so we're looking at the limiting instructions when we come back, I guess. These poor attorneys with their scheduling conflicts. And then, okay, so thank you so much, Heart of Inspiration. So this is really, this is so nice. So Heart of Inspiration sent a super chat to say, let's get the likes up, everybody. She's going to give 10 memberships if we get to 1,500 likes. So really cool if you hit those like buttons. And I think if you chat in the chat, YouTube is more likely to gift you a membership. It like looks for people that are actually participating in the channel. So if you're looking to try to get a gifted membership, it seems to prioritize people in that way. And make sure your gift settings are turned on so that you can receive a gift. You can do that by clicking the little money symbol next to where you chat your chat message. So thank you so much, Heart of Inspiration. We'll keep that going. Brina says had asked earlier, this is a little bit ago, but we can recap everything up to this point. So Brina says, can you give us a recap? I just got on. Honestly, this morning was so productive. I mean, we got through the rest of Zachary's statements. Atkins was really holding it down, keeping it efficient. Short was keeping it efficient. A lot of the time, right away, they said, look, we agree on that. We don't even need to debate it. We agree with whatever, either redacting it or not redacting it. We're in agreement. But there were a few. There was one big win for the state and one big win for the defense. Really relating to I know one of them was about the weapons, like saying that he carried 223 on him. And Max Sharp tried to object and say, well, it's not clear if he's saying he carried it that night or if he's saying he carries that type of gun, weapon, ammunition generally. And there's a distinction. And the state had won that one. So that was a pretty significant win for the state. Of course, they'll be able to cross. Max will be able to ask that same question of the jury. And a lot of the other things really across the board are, yes, state, that can come in. I'm not going to bar you from bringing that in, but you can only bring it in if you lay foundation or if you're trying to show that your witness on the stand just said something inconsistent. So it's really a recap of the morning. They did some housekeeping. Whitaker, the defense was a little bit late too because Bruce Harvey still hadn't submitted his proposition for the 105 limiting instructions where, don't consider this for all of the defendants, only consider it as it's relevant to a particular defendant or defendants. But they just sent that now. That's what judge is reviewing. And then when the court came back from a bathroom break, a comfort break, convenience break, Love is asked, did you turn over this list of 30 witnesses and the evidence you plan to bring in through them? And she's like, I know, I sent them part of it and I was typing it, I was working on it just now, which is a no. She didn't turn it over. The same thing that she's been asked to turn over like 4 times in the last week and a half. And then she announces that after we just finished getting all the Zachary statements prepared, so that way we can, on Monday, if Copeland doesn't want to testify, we're prepared to put Zachary on the stand and get the ball rolling without wasting time. After we finish that, she comes back and she says, well, we want to bring Sledge before we bring Zachary. And she said that it's Zachary, Sledge's statements. They're not so voluminous. It should be done today. But if she's the one arguing them, I don't know. Do you think that even if it's voluminous or not, that Love will get through her arguments on the statement she wants to come in? We already just saw how long it took her to try to argue why she should be able to bring in social media comments. And not only just bring them in, but that she should be allowed to ambush the defense with them. If a witness is on the stand and I decide that I want to ask them about a comment on the screen, or they say something that might relate to the comment, then I would want to be able to show the comment. And the judge snapped back at her. Like, listen, no, if you know or think or might use something when a witness is on the stand, it needs to be provided to the jury. The defense. You need to give the defense notice. And you need to give them digital copies and the screenshot versions of what you plan to use. And Love still tried to push back against her. And Whitaker said, no, I've already seen what you did during opening statements, when something came in on the PowerPoint slide that you know was supposed to be excluded. Somehow it was still on there anyway. We're not going to do that. So you did miss, I would say, if there's anything exciting worth watching, if you go back right to when we came back from the morning's first recess. So I have it marked at this point in time, it was about 50 minutes back from where we are right now when they come back from that last recess. And Love is making her scramble arguments to try to continue to ambush the defense with whatever she wants to bring in when she feels like it. And now we're on our recess again. So I think that's a recap for you, Brina, and probably everybody else who came in late. So thank you so much. Danielle says, Love throwing someone under the bus is an idiom means to criticize, blame, or punish someone, usually when they are vulnerable, in order to gain an advantage or avoid blame. You're reaching. And you would think Love would understand what throwing someone under the bus means, considering she seems to do it quite often. I don't really feel like I've seen Atkins throw someone under the bus. Hilton, I don't know. I think Hilton, when she's dealing with a difficult witness, she kind of just stumbles and tries to ask them again. When she's trying to make an objection, she tries to make her arguments rather than point blame on someone else on her team. But yesterday alone, we heard Love, and I'm sure the chat can back me up here. We heard Love blame her legal assistant. We heard Love blame Agent Bernie because he's so busy thwarting murders out here on the street that we can't get this information from him. This copy of this affidavit that has existed for a while already. We can't get this affidavit from Agent Bernie because he's thwarting murders. He's busy. Then it seems like she shooed Atkins out of the room to go figure something else while she sat down. Yesterday alone, we saw her throw people under the bus. We're going to start needing to use the bus emoji. But it's a bit asinine that she doesn't know what throwing someone under the bus means. So thank you so much, Danielle. Moses Dupree, good to see you. Moses says, Love isn't prepared because she didn't have to be under Glanville. Love, skibidi toilet riz, Glanville. Yeah, I agree. And you guys have commented too, she can't use the hand signs. So thank you so much, Moses. Nana Misty says, ADA Love has taught me so well how not to do the job. She is an idiot. And we did that poll. Seeing Love do this, do you think you could do this kind of work? And people were like, yeah, I think I'm capable, lots of ones. And then someone said, Love makes me not want to do this. Like, it's demotivating, unmotivating. Thank you so much, Nana Misty. Delicates of Life, when I saw your comment, I had tried to respond with the doc in the chat. I'll put it there again. Delicates of Life had asked, did Fani Willis use case law when she was arguing about cell phone data in response to, I think it was Steve Sadow's motion in the Trump RICO trial to introduce, the defense wanted to introduce an expert, or not an expert, someone that was going to read the reports of cell data that showed possible locations of, Nathan Wade, Fani Willis, who may have been near each other, using Nathan's location and different records. And Fani Willis had filed a response. This is the doc right there in the chat. And she didn't really use case law about the data itself. Her focus where she used case law was on the arguments that this is late disclosure, so it shouldn't be able to come in. And then this is also, this is really a Daubert issue where this should be an expert witness that we should be able to qualify, and it's too short notice to be able to go through that. And so in that document, she cites different case law, but it's not really case law backing up her third argument. Oops, and did I use the wrong link? I think I linked to a folder, so let me double check. Let me know if this new link works. So there we go. And I'll pull it up while we wait. But you can kind of see, you know, a lot of these citations for these first arguments are all about the late disclosure and how the witness should actually be qualified as an expert witness and not just be able to speak on the reports. So all this bold, all this case law, all these paragraphs that are indented are citations somewhere. And we get all of this stuff cited here. So Ammons v. State. But when we get to this argument about, where is it? It's like right at the end. This is pretty long. When we get to the argument about inadmissible and having little evidentiary value, was not filed in good faith and is simply another attempt to garner media attention. So the value of the cell phone records. We just rely on exhibits, a New York Post article, an email from Steve Sadow, a tweet from Citizens Free Press. We don't have any case law for this argument. So she made the argument that it has no value, but she didn't back it up. So there's your quick answer on that. We'll flip back over here. And then thank you so much. Hope you guys have fun if you want to revisit that document about, you know, someone in Fulton County not wanting to rely on cell location data. Marlena Mack, I wanted to pull this up earlier. So when they ended up showing the two videos, Marlena Mack had said right before they popped up, well, I'm posting hashtag free YSL too. And I wanted to pull this up when Love was making the argument that she wants to be able to bring in social media comments. You play around, Marlena, you're going to have Love trying to introduce you at trial. She's going to be like, look at that comment there, Marlena Mack. You know, she's posting the hashtag that's relevant. It says YSL in it, so it must be relevant, and we should be able to talk about it in front of the jury. So thank you so much, Marlena. Cassandra Durkin says, I have worked in the legal field in New Mexico as a criminal/civil investigator, a paralegal. Wow, that's like a lot already, and you still have more. And a district court clerk. ADA Love makes me never want to step foot in a courtroom again. You have a resume here, and then hearing Love just makes you like, no, I don't want to do this at all. Those are some cool positions to go through. The investigator stuff sounds kind of cool. I wonder, do you think there are significant differences between criminal and civil investigations and how you have to, you know, maneuver through something like that? I don't know. Cool food for thought. Thank you so much, Cassandra. Moses says, who got a love to English dictionary? Oh, man. I do think a lot of her word salad is just to buy time. So that way hoping the judge will just be like, all right, whatever, stop talking. Here you go. Here's what you're looking for. And I'm glad that Whitaker isn't all the way with it. Sometimes she does let it fly, though. FFS says, just me, or she takes notes from Atkins yesterday and using a whole lot of hand gestures, trying to make herself look not. I did feel like that. I did feel like Love was doing more of this today. And I don't know, is she mirroring Atkins? Did she like watch a chat? Because we commented a little bit on, you guys were saying there's like air traffic control, the signaling. But what if Love was watching and looking at feedback on social media? Because I saw it on X. I saw it talked about in other channels. I was watching Infamous Sylvia's live stream yesterday. And you guys had mentioned like all over the place. Atkins is, you know, we'd rather listen to him. He seems like he's more concise. He seems like he's actually making an argument. What if Love was sitting there instead of doing the work she's supposed to do and watching what was said on social media and was like, how can I be more like Atkins? I think you might be onto something, FFS. And I don't think everybody sits and looks on social media to figure out how to curate their own demeanor. But I do think Love is hyper-focused on how she comes off and that she might be inclined to do exactly that. EDW Raptor. Guys, you know the drill. If you see EDW Raptor, put the little dinosaur emoji in the chat. EDW Raptor gave 5 gifted memberships. That is so nice. You guys know I love gifted memberships. Make sure you say thank you to EDW Raptor. Drop a dinosaur emoji. We've got the buffering emoji, the cart, the bus. Can do some raptors. Yesterday we did a lot of duck emojis because Judge Whitaker said you need to disclose to the defense all of your ducks and your ducklings. All of it. Don't just think that this duck's not important. You plan or might use it, disclose it to the defense. So now we need some dinosaur emojis in the mix. Thank you so much, EDW. Mahadi De Jesus, thank you so much for your support for like this whole week that we've been doing these streams. It's really much appreciated. Mahadi says, I would like to see Steele and Miss Love to work their issue out as pros and role models. It was good to see Catnip again. Yeah, I'm so sad that Nick, like, guys, I really hate flying. And like I feel that flying a long time overseas is already aggravating enough. So then to see that Nick, who's been covering this trial from before day one, is suddenly in a position where his laptop's stuck in lost luggage is just, like, that sucks. That's terrible luck. And so great to have him on. He can come up anytime as long as, you know, he's available. But really just unfortunate situation that in the middle of this, especially hopefully by Monday, he gets his stuff back because Kenneth Copeland could be on the stand. Like, Nick should be able to cover that. So always love for Nick on this channel and all the other creators as well. I think this is an interesting point to see Steele and Love work it out. And it's one of those things where I feel like if Love tries to extend an olive branch, whether it's genuine or not, and Steele doesn't want to accept it, some people could, you know, think that's unfair of him. And it kind of becomes, I don't know. Do you guys know what I'm getting at? Sometimes apologies become a burden for the person that the apology is being delivered to. And there's pressure on the other person to accept it. And I kind of feel like that's the situation it would be. So I wouldn't be surprised if Love feels like she needs to patch something up. She'll strategically extend an olive branch. I think Steele is so far scorched earth that he will not want to accept that olive branch. But if they could, it could be a good role model for other people trying to enter the profession and learn how to deal with interpersonal conflict in the courtroom. So great food for thought, Mahadi. Thank you so much. And thank you for the love, Carrie. Carrie says, thank you for all your hard work. Good to see you. Happy to see a Carrie in the chat that isn't Carrie Morrissey. I was tuning into Potentially Criminal was covering yesterday the response from the state, really the special prosecutor Carrie Morrissey, in the Rush trial, but relating to defendant Hannah Gutierrez-Reed, because she's looking for a new trial after what happened with the Alec Baldwin trial. And I didn't get to catch the full reading of the document, but boy, it seemed like Carrie Morrissey was making some weak arguments. It made me feel way more favorable to Hannah Gutierrez-Reed, and I'm just so glad to see a Carrie that's not Morrissey. So thank you so much, Carrie Colton. In a second, I'll grab that link to that stream if you guys want to see what's going on in the Russ possible retrial motions. Iron Rabbit gifting memberships. Good to see you, Iron Rabbit. So we got to get the bunny emojis too. So Iron Rabbit, thank you so much. I appreciate that. I know, look at you guys. You guys are always so nice in the chat. Yeah, and you guys are also saying, I see a bunch of dinosaurs and no, he won't accept it, talking about Steele and the apology. See, look, you got a new picture already, recused Judge Glanville? Is that the baby carrier? Like from The Hangover? Is that where this picture's from? He said, I'm going to make you testify. I'm going to carry you to court, Kenneth Copeland. Shout out to recused Judge Glanville. And there we go. We get the love for Iron Rabbit too. Oh yeah, there's 2 different rabbit emojis. There we go. Oh, sweet. Thank you, Drea. Let me pull this up on YouTube so I can see. StreamYard doesn't let me copy and paste text, so we can look at these proposed. I see the camera wiggling a bit. So maybe we'll get right into it, but let's see if we can pull this up. Look at all the bunnies and the dinosaurs in the chat. It's funny because as an emoji, the rabbit looks bigger than the dinosaur. And crispy bacon with the Yoshi as the dinosaur. That's a good double use. Okay. Found the link. And thank you so much, Drea. Okay, so this is a ton of case law. This is going to be a ton of case law. So where do we get... And no wonder it took them a while. I thought they were just going to like submit a page of what they want to say. Okay, actually, hold on. This is a different motion then. So I clicked the wrong link. So motion to limit witnesses due to undue delay, waste of time, and or needless presentation of cumulative evidence. And this is coming from Weinstein and Jay Apt and Katie Hingerty. That's not Jay Apt in the courtroom, right? He looked different during opening statements. Right? That's somebody else that's sitting in the court where Weinstein's usually sitting, right? So we've got that. This might be too long to read during this recess, but we will read it during lunch, right? How's that, you guys? And then... Dre, I think the limiting instructions, if you have it handy on your copy and paste still... Oh, wait, no, I got it. Okay. I was like, why is there 9 pages about a limiting instruction? Yeah, so Drea, the link I'm clicking for the jury instructions is actually Diamante Kendrick's motion. And thank you for pulling these. Okay, this is hilarious. So this motion's actually from March 2024, but it still applies. Oh, that's true. So that's not a new motion, you guys. This is from March 19th, 2024. But it's hilarious. Motion to limit witnesses due to undue delay, waste of time, and or needless presentation of cumulative evidence. And what's the remedy they're looking for back in March? They want this court under Glanville to provide a detailed witness list by April 15th. April 15th. Where are we now with Judge Whitaker still asking for a witness list? We still do not have it. And then also to make a finding of whether each witness on the detailed witness list will likely cause undue delay, a waste of time, or be cumulative, and for those witnesses so determined to meet one or more of those 3 criteria be barred from testifying. So this was a request back in March to turn this list over by April 15th. And Love just told us she only submitted part of it today. So Drea, I think that was the wrong link, but it was a hilariously awesome throwback, very relevant to what we just talked about. And then thank you. So Drea, we have the proposed limiting instruction, and it's 1 page. So since it's a Twitter image, we'll go here. And this was just submitted at 10:45 a.m. this morning. I instruct you that some evidence may be admissible as to some of the counts or some of the defendants. But, is this... Okay, so I instruct you that some evidence may be admissible as to some of the counts or some of the defendants, but not admissible as to other counts or other defendants. In that regard, evidence related to certain alleged acts specified in count 1 of the indictment may be admissible against those defendants on trial charged in that count. However, I remind you that in order for you to use such evidence against those defendants not alleged to be involved in the counts under your consideration, you must consider whether the alleged acts for which the evidence is being offered have been proven, beyond a reasonable doubt, to be part of the overall scheme alleged in count 1. Likewise, evidence of a person's prior statements that may be different from those admitted here at trial may be used by you to evaluate the credibility of the witness testifying. but not as proof of the matters asserted or against others not alleged to have been involved in the events being testified about. That is, prior inconsistent statements are offered for the limited purpose of determining the credibility of the testifying witness and not to prove the truth of the statements made. So this line is really the puncher at the bottom. And then the next page is just the signature. So shout out to Joseph Babb. And this is Joseph Babb on X. But there you go. Look at that. I love when something's one page and we can read it on a recess. And that shouldn't take Whitaker too long to read. Maybe she's got to look at the cases that are cited in it. But yeah. And yeah, we're calling motions in lemonade. Rooster, thanks for gifting a membership. Love that. And is that a horse in your picture? Your name is Rooster, but you have a horse in your picture. Is the horse named Rooster? Well, thank you so much. Let us know about the horse. Yedat says, and thank you so much for the 1999. Love said he was thwarting murders. The hell she think he's Batman. I'm glad Judge pushes back against the state, though. Chat thinks she need to hammer harder, and she could. I think there's some things that she has given more grace to the state, and the state is asking for more. So there's been more opportunities for her to give grace to the state, but she seems to more than 50% of the time of those asks give some grace to the state. When she doesn't give grace, she does seem to go like scorched earth, flaming hammer, like, no, we've already told you, 0 more chances. And then you're also saying here to continue this chat, she needs to hammer. The chat seems to think they still need to hammer harder. They still not doing themselves any favors with how much grace she keeps giving. Yeah, so giving the grace. There you go. But I think exactly that. I think the state's asking for more, and more than 50% of those asks, she hasn't said no to the state. She's sometimes given, maybe this can come in. I'm not going to redact it. I'm not going to outright exclude it. But it can only come in if you do X, Y, Z. So you still have work to do. But other times she's like, all right, it's fine. No big deal. So I do see there's issues where she could have made the decision the other way, but she chose to go in favor of the state. And I think it was giving grace rather than just, I don't know. But I think that grace, the patience might be limiting. So thank you so much again, Yedat. And then FFS says she comes off as stupid, unprofessional, unprepared. I just think I don't think she really even tries to make arguments. I think her argument is often, I think it should come in, so it should come in. And here are some other words that, if the defense has already made their argument of why something shouldn't come in, or why they want to move for a certain ruling or instruction or whatever, it's like she takes pieces of their words and will say, I hear their argument that X, Y, Z, but I disagree that it's X, Y, Z. Pause. Buffer. Oh, we've already had a ruling from the previous judge. And then she'll look for another explanation to give. It might be relevant because it goes to show that there's an affiliation here. So she's got like these 2 main things that she leans on. It should come in because it's relevant under some co-conspirator statement exception to the hearsay rule. Or there was a prior ruling, and maybe we're not sure if there actually was a prior ruling, but she insists that there was. Or 3, the other one, and Hilton's made a lot of these arguments too, to be fair. But we need to be able to have this ready in case we need to impeach a witness on the stand. And part of that comes down to their own witnesses that they plan to call are unreliable. And they're calling them strategically. If they can impeach them on something, they also get to play these prior statements. So it sucks because some of those arguments can be valid arguments, but I think the state makes a lot of those arguments because they want those videos in and not because they truly believe that, I just think it's poor strategy. I don't have an explanation for it other than that some states don't allow you to call a witness just for the sake of doing that. And I think states that do that, they see the potential for a prosecutor like Love to use such a tool, to use impeachment as a way to introduce evidence that ordinarily wouldn't be admissible. But here in Georgia, it's allowed. So Yeah, lots of word fillers. Has Love actually followed one of the judge's rulings and the times to have all the stuff in yet? I don't think so. And that's really where I'm getting frustrated because this judge likes efficiency so much. So you would expect that if her one ask is efficiency, productivity, let's get things together. Why isn't it bugging her a little bit more that that's the thing she's asking for is the thing that the state keeps brushing off? So and then FFS also says it's no longer an olive branch situation. So going back to, what if Steele and Love like reconcile? They come back to peaceful terms. Mahadi had posed that question earlier. But FFS says it's no longer an olive branch situation. She continuously bashed him without any merit and went unchecked except by him. I certainly wouldn't accept it. And I think a lot of people feel that way. And I think it would be different if, I don't know if Hilton's a good example anymore because she was part of that ex parte where, we're tracking people, we're keeping an eye on people, we don't trust the defense. But maybe somebody else on the prosecution team, if they were told by Love, hey, I think the defense is in cahoots, Melnick and Steele are working together. And that other ADA, a random ADA, said something that accused Brian Steele of that because they heard it and they trusted their superior, Love. Now, if someone like that came back around and said, look, my bad, I didn't mean that, I get that it's not true, I'm sorry, do you accept my apology? I think Steele would be like, yeah. But if Love is the originator of the theories, of the rumors, it's just a different ballgame. So I don't know. I totally feel if I accepted an olive branch in a situation like that, it would be with the terms of, I still don't like you, and I'm only doing this so we can be productive in doing our jobs. But I don't like you. And I don't dislike a lot of people. I can probably can't even think of people off the top of my head. I just don't tend to, I don't know, have rifts with people. And then Brigetta says, what about the juror that was in the courtroom? So it was the courthouse. And I don't know why they were actually there, but it's possible, maybe they had other business to attend to. Or one of the things could be, what if they need to say, look, I moved. I'm not here. I can't sit on this case anymore. I'm letting you guys know. Can't keep doing this. So if it was something like that, we'll find out on Monday, I'm sure. But they were not in the courtroom. That was something I misspoke yesterday. They were in the courthouse. And then thank you so much for the super chat, Brigetta. They are on a recess, Shamina, so, and it's crazy because they'll probably end up going to lunch soon unless she pushes lunch back. But they are on a recess because she wanted a chance to look at the proposed jury instructions that Bruce Harvey's team just sent over. So, we've got all the emojis in a row here. And yeah, great point, Deirdre. So Deirdre here says Carrie Morrissey has been a prosecutor. So in the Russ case, she was brought on as a special prosecutor because I think she has a private practice now, but she's also worked as a prosecutor employed by the attorney's office. So Carrie Morrissey has been a prosecutor. That's why she's used to letting Brady slide. She's done dirty stuff. Carrie accidentally, in quotes, listened to all the attorney-client convos. When she got caught, blamed the jail. Yeah, it's a big problem. It's a huge problem. In Florida, we have several major cases where that's going on. One is, Shayna Gardner, I think is her name. And I think that's further north in Florida. And then Courtney Clenny. All the laptop charges were dismissed because the state attorney's office told their filter team they didn't instruct their filter team properly and were snooping through privileged communications to try to find someone discussing some cover-up or wrongdoing. And the judge is like, okay, you're arguing that there was a commission of a crime. What was the crime? And they're like, we need more time. So like 2-3 months go by, so much time is wasted. The Clenny murder trial is probably it is pushed out to 2025 now. And all because these prosecutors thought that they could possibly maybe find something incriminating by looking through the attorney's communications with the Clenny family. Like, just crazy stuff. And it only got caught because it got caught. That's not always caught. We trust these taint and filter teams, whatever you want to call it, we can say the word taint, to do their job. But then you hear these situations where the prosecution is telling them to do their job incorrectly. How do we know? Also, Cop City is having an issue with that too. I think Siri Shada Jimenez is one of the attorneys representing one of the co-defendants in the Cop City case, also in Fulton County. And there's attorney-client privilege issues, arguments going back and forth there too. It's a common thing. It's dirty. You know, we see Love asking for reciprocal disclosure. We want to know everything you plan to do. And then a prosecutor could look at things they're not supposed to look at just so they know they can better arm themselves. It's like being in the locker room of the opposing team. Just crazy stuff. The Rush trial in general was some crazy stuff. And then Brina says, the state is committed to doing trial by ambush. Yep. I totally agree. The state is committed to doing trial by ambush no matter what the judge says or what deadline she gives. Love is running this trial by stealth and slow talking. Syllable soup? Oh my God. Syllable soup is so good. I've never heard that before. Did you come up with that? Guys, I love syllable soup. Like, I'm picturing the actual alphabet soup, but syllable soup. And now that's exactly what I'm going to think of when Love does one of the buffering arguments to try to make a case for why she should be able to use trial by ambush. That is great, Brina says. Thank you so much. And then look, Heart of Inspiration. And we can put hearts in the chat for Heart of Inspiration. Gifted 10 memberships. That's so sweet. You guys make sure you say thank you. Gifts are fun. It's an awesome way. It's support to me, but it's something fun for the chat to do. So that's why I love it. It's like a best of both worlds thing. So totally appreciate it. And let's see. There we go. All the hearts. There we go. And the green ones too. Look at that. The co-conspirator green hearts. Yeah, a lot of love for syllable soup too. Look at that. All the love for Hearts of Inspiration. And did you ever start your true crime and trials channel? I know you're busy. I know you do a lot of stuff. Let me see. You're almost at 10K subscribers on your main channel, Hearts of Inspiration. Oh my gosh. Okay. Okay, Heart is almost at 10K subscribers, you guys. Super motivational content. Does a lot to, deal with being more productive, keeping yourself aligned, keeping yourself focused. So we will have to know when you do your trial channel. But until then, we're going to get this one to 10K. No, I'm so sorry to hear you got in a car accident. That is not fun at all. At all. So I hope you're doing well. Like tons of love for you. And I don't think, yeah, it does feel like a long time. I don't think she gave us a time for this, did she? She just said recess. Yeah, I don't remember. Yeah, I'm not saying that we might get a third venting session today. We'll see. We'll see how many more arguments Love is in charge of. Probably if she's in charge of arguing against these limiting instructions, it might be time again. And we haven't needed one. Has anyone felt like we need a vent session for Atkins? Okay, yeah, she did say 10 minutes then. Okay. Yeah, definitely 10 minutes have came and gone. We probably could have read the whole March motion, the March 2024 motion. about that witness list that they wanted sent over to the defense by April 15th. That was never sent over to the defense. Syllable soup. Yeah, we got emojis for that too. We can do soup emojis when it's syllable soup time. Oh yeah, that's true. So maybe that's taking a bit longer because Keratin Matthews had a scheduling conflict. It is pretty productive that they can just like, hey, we got a message that you need to deal with something. Yeah, I don't think they're just going to turn this into a lunch recess, but it's surprising that they didn't just... Maybe she didn't look at the clock quick enough. And I'll check. Kathy Roussan is actually, like, her updates as far as trial clock. She always gives us an update when, oh, they won't be back until this time instead. So let me see if she said anything. If you guys are joining, so hey to Queen Bentley and hey to Trey. You didn't miss much today. Very productive morning. They got through like 15 or 16 different redactions and finished the Zachary stuff because it was Atkins and Sharp doing it. And then after that, we kind of went downhill on productivity. Love got yelled at a little bit, and she still didn't turn over that witness list. And now we have a recess while Keratin Matthews has a scheduling thing to resolve with another judge, another trial he's working, and to look at Bruce Harvey's instructions. Okay, so they are doing lunch, you guys. We are going to do lunch. We've got some time to fill. We're looking at 1:15. Let's see. No other motions. And shout out to Drea for always bringing the motions and sharing the links with the chat. Yeah, so we're going to be on lunch till 1:15. Shout out to Miss Sylvia. And kind of as always, everybody already knows, most people already know Miss Sylvia. But in case you don't, that is her YouTube channel in the chat. No, oh my gosh, Aries Goddess. Love is Olive Garden's unlimited soup and bread and salad. Ah, stop it. This was good. Aries, this was really good. I'm waiting to see. Yeah, there we go. I see the chat. Hearing your joke. That one is very good. And then was there anything interesting do you guys want to rewatch? Love kind of getting yelled at today. Is there anything you guys want to rewatch? We got an hour and 15, just over an hour and 15 minutes to kill. I got to eat my protein bar, my little granola bar. I got to duck out and turn my camera off and munch a little bit. All right, so yes to rewatching earlier today. Okay, so I think that'll be easy to find because it was right when they came back from the first. They only took one recess besides this one, right? I guess we'll know when we see Love standing up. Dun dun dun. Okay, so this is the first recess. All right, and then they come back and they do some housekeeping. So we'll play through that. I'll go eat my protein bar and come right back to comment with you guys. Thank you to Marcus Miller. Marcus Miller, thank you for gifting memberships. Everybody shout out MM in the chat. And let's get to where this actually starts. So we're coming back here. I appreciate you, Marcus. She Loves Fantasy says the power that comes with law enforcement from beat cop to elected DA, right? Because they're all the state. It's all like government, the state. Those are the people that prosecute you. Corrupts. It would take weeks to address the many issues. Yeah, and they would never be addressed. And then there's different issues in different areas, different laws, different statutes. So you're absolutely right. Thanks so much for the support, She Loves Fantasy. And G-Lander, I think Shard's doing most of the recent arguments for two reasons. I think he's well-versed in these statements. Earlier we heard that, I think with Sledge, there are really three core statements that they need to look at, and the defense has only turned over, the state has only turned two over to the defense. But Shard seems to be somewhat familiarized on his own accord with some of the underlying stuff. So I think it's a skill that he's good at. He's thorough with it. So, you've got multiple co-defendants. The sixth counsel probably divvy up the tasks, right? And sometimes it's mostly Shannon Stillwell that's inculpated potentially by some of these statements. So it's also to represent his client and what he's being accused of and what these statements might lead a jury to believe if they're able to hear it about his client in particular. So two reasons there, I think. And then let's see. Yeah, we get the Raptors here. We got MM. There we go. Look at all the love. Thank you so much, you guys, for appreciating people that do the gifting and the super chats. It's really nice. And then again, if you want to get a membership, make sure you hit the dollar symbol, the money symbol next to where you type. And there should be a settings option where you can turn on the ability to receive gifted memberships. If you get a gifted membership, you're not going to get billed for it. It won't renew and charge you for something. It'll just end when the 30 days ends, unless you choose to renew it manually. Or you get gifted another one. And then AI Designs. Hold on, I got to pull up YouTube because I can never see the super stickers unless I open YouTube. So what do you have on the screen? You guys can see it and I can't. Oh, we got the trumpets. It's marching trumpets with a lemon and a lime. When I had to pick an instrument, trumpet was what I tried. I didn't stick in band for too long, but trumpet was my instrument of choice. And then I switched over to chorus or choir because we had to do one or the other back in elementary school. My brother, though, he is great with jazz music, piano, trumpet, trombone, saxophone, all of that. Well, saxophone mostly for the jazz. But he's so good. He can just start playing something when he hears it. So, totally a cute sticker that you picked. Thanks so much. And we're going to play this. This is when they came back. I think the mic took a bit to come on, so.
All right.
And to clarify, this is from earlier in the day. I should make a banner. Rewatch. There we go. So there's the banner so nobody gets lost and confused if they come in while we're replaying this. And Sherry Aguilar, look at all these gifts today. This is 50 gifts. So 50 people in the chat, I think, or something close to that number, have been gifted memberships today. And now their name is green and they can use the Mario Kart emojis. So appreciate you guys so much. And in the chat, you guys, keep the party going.
All right. If y'all have just now gotten the evidence that is gonna go with witness Sledge, I don't know if y'all are ready to tackle that right now or.
It can't be, because it's still sending and uploading. So I'm on Dropbox trying to.
All right, well, what all is it? Because, presumably they've gotten it all before in Discovery anyway, right?
They definitely have, and I can do that.
Yes.
I can address, Mr. Sledge gave a prior statement that's can be played on evidence reviewer, following his arrest for the 2015 alleged shooting of houses. He was arrested as well as Mr. Zachary.
Okay.
I can address that. And there was one on what Mr. Adkins sent. There was one jail call that was identified, and I can address that as well. I don't know if there's more, but his statement I can address, the jail call I can address.
So those two, they have, he's correct. identified those and given them to those. The statement is the statement we mentioned earlier. And the jail call is that Mr. Shard is correct in those. And if we are ready to respond to whatever it is that they bring up while we're sending the rest of it.
Okay, the prior statement he made in 2015, he's brought in regarding the ag assaults, and he is questioned, he's Mirandized, he gives a statement, he denies any involvement. He later pleads guilty.
Okay.
Or offered, I'm not sure. He pleads somehow, he resolves it short of trial. He's just denying being there. So I don't know under what circumstances that statement would be used to impeach any testimony. I suppose he acknowledges that he knows Mr. Zachary. So I guess if he said he doesn't know Mr. Zachary, I guess that could be used to impeach him, but it doesn't seem to be a statement that would be used to impeach him or would necessarily be played. His jail call, I've listened to it. It's essentially him. He had a preliminary, he was charged with the murder of Donovan Thomas by Detective Thorpe. The state has since determined that he is not responsible. He had a prelim where no probable cause was found. After the prelim, he calls his significant other. I'm assuming it's a significant other. It sounds like it from the context. And he basically talks about the testimony at the prelim. He speculates about who witness 1, 2, and they used codes in the prelim, witness 1, witness 2, witness 3. He speculates about who that could be. And he basically says, it sounds like witnesses 1, 2, or 3, and, or some combination of within those 3 people really threw Shannon under the bus.
Okay.
So he's commenting, he's speculating, he's commenting about testimony he heard from a detective about what witnesses told the detective, and is just giving his commentary. It sounds like people really threw Shannon under the bus. I have no idea why anything from that phone call to his significant other would be admissible in this trial.
And Judge, the phone call would only be necessary if Mr. Sledge said something contrary to what he's indicating in the phone call. And I think a broader context, a broader sort of description of that phone call and what he says is necessary. So a few things are going on. Mr. Shard is correct. He's there's a prelim. He's talking about stuff that has happened. What is most important in terms of the preliminary hearings are that Mr. Sledge is, he's privy to information that is given in other preliminary hearings of other YSL members. And he's aware that during his own, they are talking in terms of witness 1, witness 2, witness 3, rather than giving names.
Right.
What he says is, Lil D told, and Lil D is the witness that we've just finished listening to, Mr. Zachary. And he said, I can tell Lil D told because of, and he gives the information that was given by witness 1 or Lil D. He said, I can tell witness 1 is Lil D because he says this. So the fact that as he's discussing with his significant other, the information that he has learned while he's been in jail with other YSL members and in court, and he is not asserting that so-and-so lied or on Shannon. He is saying he threw Shannon on the bus, or they told on this particular person. That in conjunction with his factual acknowledgments in his plea agreement that he made when he entered a guilty plea in this case, we believe it establishes, one, the nature of you do not tell. Two, he has knowledge that people did tell, and he is not saying this didn't happen. He's not saying this person just flat out lied. There's no way. And it also explains indirectly why certain things may have happened. By certain things, this part is just an argument that would be made later. But if I were to make a statement in closing arguments that, of course, Mr. Zachary changed his story, everybody learned that he told, and he knew that everybody learned that he told, and now he's being looked at as a rat. So the call that Mr. Sledge makes and the content of that call are necessary for a number of reasons, and they become very relevant when put in the context of other evidence that we will be introducing at trial.
Okay.
So we can play the call for the court. We have it. It's a single 15-minute call.
Fulton County Jail. This call is subject to recording and monitoring, and your location information may be collected and used by corrections and law enforcement. Tablet.com. During special moments as .net to learn more.
What you be telling Kwame for her to be doing all she be doing that?
Man, I ain't even talked to Kwame. I seen Kwame in the courtroom with Tip today. I swear to God, I ain't even talked to Kwame. I been in the courtroom today with Tip. I was shocked when I looked back. Only thing what made me look back, cause when they first started calling the charge out, that nigga peanut them dad punched the damn thing and got up and walked out. So folks did miss you today, man.
You know, Derek called me and told me everything.
What did he say about the bond, though?
He said,
Yeah, I'm sorry, but that is entirely too muffled for me to understand what they're saying. I'm happy to listen to it at lunch if I need to, but until I can figure out how to hear it through Zoom. Or, you know, if y'all want to, sometimes attorneys will bring another speaker, but if I need to hear what's being said, I can't from there. Sorry.
So, I do have things, but I'd rather test it and then, well, I can try and test it, but I can send it to the court.
I mean, if there's
And then I think what we'll do is we'll fast forward to the part where Love is like, I want to bring the comments in, even though you say that I shouldn't bring the comments in. But before that, Smiling Wolfette had said she sent something to me by email. And this might be outside my knowledge, you guys. But she's asking, how is it possible, or how is it allowed, that a grand juror, so a grand jury is who says, they look at the indictment and they say, all right, you know, there's enough here. They're the ones that decide if something can go to trial. So how can a grand juror be on the grand jury if there's a conflict of interest? Curtis Whitaker, different from Judge Whitaker. Curtis Whitaker was represented by the state ADA, Christian Atkins, the guy sitting at the state's table that's been doing a lot of the arguments today. And she said she sent it to Weinstein's office. But it seems like it could be the same Curtis Whitaker that's on the grand jury. Now, I'm not sure if this actually if they would say that this was a conflict of interest, and or if it's something that the defense should have already raised an issue about. But Smiling Wolfette did the research here. So she had pulled up First Citizens Bank v. Trust Company v. Whitaker. And here you see on the left, defendant Curtis Whitaker, represented by, oh, is this a different attorney then? Hey, I have Jay Atkins here, Smiling Wolfette. So this might be a different attorney. So it might not be the conflict of interest. Because this is a different name here, unless I'm reading something wrong on the page. So this might eliminate the problem in its entirety. Because it wouldn't even potentially be a conflict of interest if it's not one of the ADAs on the case. But let me know if I'm looking at it wrong. And then with that, I want to go back to, I do want to find, it was a little bit after this. We'll know because Love was standing up a lot. And we'll see the social media posts on the screen. It was somewhere around one of these videos. It knows we're looking at Love and starts doing the buffering symbol. Yeah, and then so apparently Atkins is new to the case. But I'm thinking, I'm not sure it would really even be a problem if that was Christian Atkins that represented someone that ends up sitting on a grand jury. They'd have to really show, I think, demonstrate that, you know, there's a reason, like Christian Atkins was known to the juror as being part of this case when they were making their grand jury indictment decision. And then also I'm sure there'd be issues as once the case started to move along, the defense might have had the opportunity to look at something like that and raise an issue then. So I'm not sure even if it was Christian Atkins that represented him that it would have been a conflict. Well, let's just watch these two videos then. Let's just start from when they start playing the video. We're close to it, so we'll start from here.
That he makes on June 24, 2015, free little D like right now. And that is, looking to share it.
Is he saying it, or is it just like a written post?
It's just a written post.
Okay.
It's just,
Okay. Anybody anticipate objection to that we need to deal with? No.
I don't know specifically what she's oh, is that it?
On the screen is the post. Oh. let me do-
I just don't know what the relevance is of some of these things. Like,
So 6/24/15, what's just happened? Why is he in? Why is the little D in?
This is.
Which little D is it?
Demikian Darlington. And, he has been arrested. I can tell you the reason that we're wanting the relevance of it.
Okay, what's that?
It's the urging of each member. We don't have just him. We have him saying free little D, free the other little D, free various members of YSL, as we have with other defendants that are currently on trial where, for instance, when Mr. Winfrey was arrested, Mr. Williams had free Roscoe shirts, they're wearing it. So they're advocating for the release of their fellow gang members. And it shows their solidarity, their support for, and the existence of the organization.
All right.
I would more accurately, in my mind, say that he's posting free his friend. And to the extent that Mr. Sledge says he doesn't know Lil D from Mechanicsville, that's Demikian. That picture is of the Demikian Garlington, Your Honor.
Okay.
To the extent he says he doesn't know him or he's not friendly with him, or I mean that maybe that would become relevant, but
Yeah, I'm going to permit it over a relevance objection to show or potentially show the issues that Ms. Love has said she would offer it for. And of course, y'all can argue that all this shows is he's concerned about his friend, but that's a topic for argument. I think it is relevant, though.
Your Honor, there's one issue that I failed to bring up earlier.
Okay.
Regarding a video of a plea, and we dealt with this earlier in the trial, and I know that we did some redactions. I would object if they're bringing it in to show that if it becomes an issue and that a plea was freely and voluntarily entered, going through the Boykin rights and things of that nature, I would understand. Going through the state's factual rendition and their of the plea and just their testimony and their story, we would object.
The factual rendition, unless you have him then affirm, yep, that's what happened. And unless he's now saying, nope, that's not what happened.
That part is.
It all just depends on.
That's exactly.
Okay.
Yes.
So yes, I mean, depending upon the reason that the plea might end up being potentially used. Yes, I agree with you. If it's to show voluntariness, then the factual rendition is not relevant, and I would not expect y'all to try to play that. If it is to say, dude, when you took your plea, you agreed that all of this is what happened, and he has in fact agreed, yep, that's what happened, then that's what I'm pleading guilty to, and it's not an Alfred plea, then the facts would be relevant.
Right. And so we've heard creative ways to sort of distance witnesses from prior acknowledgments that they've made. So some may have expressed a lack of an understanding, or some may have expressed feeling pressured. And then during their plea colloquy, they actually shut it down and
Okay. So yes, but understood. It's not necessarily all in, it is just going to depend upon the reason it's being offered. And just as with whatever the, reasoning for the phone call, and I'm not going to say this as to every little piece of evidence. This just needs to be how y'all operate going forward. At the point in time when you anticipate, oh, I actually am going to use this. I didn't think so before, but now I am, or whatever. You tell them so that they can so that all of us don't have to be scrambling, okay?
Okay.
Advance notice to the other side about things that you know are likely to be evidentiary issues so we can deal with them at an appropriate time and not be sending the jury out every 10 minutes.
And so, Judge, we can we will definitely abide by that instruction. And I guess we'll ask for more granularity, a little bit more clarification if in the middle of questioning.
Obviously. And I mean, that's why we're kind of going through all of this now, is so that most of it you're already going to know in the middle of questioning. Here's how I can use this. Here's the part that needs to be redacted out, whatever. But, you know, like for one of them, you said, I just really don't anticipate in any way using that. And then if you're like, oh, you know, we're in the middle and we take a break at lunch, you tell them at lunch, at the beginning of the lunch, yeah, I'm going to use this after all. It's just as much heads up, as much advance notice as possible. And given that you are supposed to be providing it, all of the evidence in detail for, you know, the first 30, and I think you're almost to the point where you're supposed to provide it for the next 30, this shouldn't be an issue. But, okay. Mr. Harvey, you wanted to say something.
Yes, one other point, Judge. With the previous exhibit and this exhibit, we previously
He gets angry here.
had a ruling and discussions about the commentary on these.
Oh, I can't even see that because of what's on my screen. But yeah, I don't think, unless the comments are relevant, let's not have those on there.
So
Now,
sometimes the comment might be relevant.
But we don't know who's making the comment. We can't cross-examine the commenter. And we have had Judge Glanville rule that the comments come out previously.
Okay.
I mean, who is this that's commenting 70 likes, one comment?
Okay.
You know, come
All right. So I agree with the prior ruling, and I don't know that this is how you were going to present it on the stand when you use it. This just may be how you got it now. But make sure before it shows up on a screen with a jury that whatever limits have been placed on this, you abide by them. I mean, I saw the slide from the opening that had something on it that had been specifically talked about and ruled that you had better not in any way put that before the jury. And lo and behold, it's up there on the screen. Not going to get back into it, but that should not happen again. If you know that comments aren't supposed to be on here, you need to make sure before you throw any slide up. And I'm not saying that this was how you were going to use it. I know you're just giving this to us right now, but just make sure everything is clean to the way that it is supposed to be. Okay.
And to be very specific, so there's no misunderstanding, the comments, what the court has just said about unless there is a relevant portion in the comments, for instance, the witness on the stand comments about something else.
Okay.
And for those instances, I would do as the court has instructed and say, hey, these are social media posts. This one right here, I am going to attempt to keep in, and I'll share it as I'm going to present it. Right now, it doesn't have.
Nope, you're not going to share it as you're going to present it. You're going to share it with each tranche of 30 witnesses, okay? If you know oh, somebody has this incredibly, damaging, I want to use this comment, I'm going to use it with this witness. Tell them as you're going through your tranches of each 30 witnesses.
Okay, yes.
Okay.
But the comment that is made by the witness, which is on the left side, that we would do on the screen.
Yeah. Mr. Harvey agrees that, yes, he's talking about the likes and comments and what have you on the other side. Those don't need to be included.
I was in agreement with him.
All right.
You were not in agreement with him. She does this all the time. It's so frustrating. And I can't imagine what it's like to deal with her in like a real life situation. Like imagine, where do you want to go to eat tonight? Like, I don't know, where do you want to go to eat tonight? And I say, okay, we can go to Cheesecake Factory because we're going to talk about Cheesecake Factory. And Love will be like, quiet, buffering. Well, actually, you know, I just want to say that we still want to be able to make a stop at the convenience store on the way there. We want to take a pit stop and go there. So I don't really know that we should like go to Cheesecake Factory, because we should instead go to the convenience store and then go to Cheesecake Factory. And then you'll be like, okay, well, I'm fine with doing that. Well, we can stop and we can also go to Cheesecake Factory. Well, that's all I was saying. I was agreeing with you. Like, it's just like, she makes everything seem like a disagreement just because she wants to do something extra. And then God forbid, I'm like, well, we can't stop at the convenience store because it's already 9 o'clock and Cheesecake Factory closes at 10 o'clock. Well, first of all, the problem would be she would argue with us until 10 o'clock comes and goes and we'd miss dinner anyway. It'd be closed. But she'd have to find a whole excuse to act like it was her decision that we could go to the convenience store after we go to Cheesecake Factory so we get there on time. It's like she needs the argument to always be her win, even if there was no argument to begin with. Like, it's just so frustrating. It's so stupid. But guys, if you guys are coming in late, what happened today? What did you miss? These are really the best parts that we're rewatching. And do you guys want to see Bruce Harvey late? I love that moment. That was my favorite moment today, where Love tries to interrupt him because Love wants to be able to introduce random comments from random people on the internet if the witness says something relevant to this person's comment on the internet.
The point where you're supposed to provide it for the next 30. This shouldn't be an issue, but okay. Mr. Harvey, you wanted to say something?
Yes, one other point, Judge. With the previous exhibit and this exhibit, we previously had a ruling and discussions about the commentary on these.
Oh, I can't even see that because of what's on my screen. But yeah, I don't think, unless the comments are relevant, let's not have those on there.
So
Now, sometimes the comment might be relevant.
But we don't know who's making the comment. We can't cross-examine the commenter. And we have had Judge Glanville rule that the comments come out previously.
Okay.
I mean, who is this that's commenting? 70 likes, one comment.
Okay.
You know,
All right. So I agree with the prior ruling, and I don't know that this is how you were going to present it on the stand when you use it. This just may be how you got it now. But make sure before it shows up on a screen with a jury that whatever limits have been placed on this, you abide by them. I mean, I saw the slide from the opening that had something on it that had been specifically talked about and ruled that you had better not in any way put that before the jury. And lo and behold, it's up there on the screen. Not going to get back into it, but that should not happen again. If you know that comments aren't supposed to be on here, you need to make sure before you throw any slide up. And I'm not saying that this was how you were going to use it. I know you're just giving this to us right now, but just make sure everything is clean to the way that it is supposed to be. Okay.
And to be very specific, so there's no misunderstanding, the comments, what the court has just said about unless there is a relevant portion in the comments, for instance, the witness on the stand comments about something else.
Okay.
And for those instances, I would do as the court has instructed and say, hey, these are social media posts. This one right here, I am going to attempt to keep in, and I'll share it as I'm going to present it. Right now, it doesn't have.
Nope, you're not going to share it as you're going to present it. You're going to share it with each tranche of 30 witnesses, okay? If you know somebody has this incredibly, damaging, I want to use this comment, I'm going to use it with this witness. Tell them as you're going through your tranches of each 30 witnesses.
Okay, yes.
Okay.
But the comment that is made by the witness, which is on the left side, that we would do on the screen.
Yeah. Mr. Harvey agrees that Yes, he's talking about the likes and comments and what have you on the other side. Those don't need to be included.
I was in
Okay.
agreement with him.
All right, super, thank you.
I was in
Everybody's
agreement with him.
So the next one, Your Honor, is
And then I loved this comment here. So Jermaine Cox says, Love's a known liar and she's unlikable to the jury. The jury's already seen what, like, not just me, but I think everybody in the chat is talking about. Now, that's a great point, and this is something, you know, maybe let Love keep doing this stuff in front of the jury. Like, Whitaker is laying it down, like, I'm tired of hearing this. Stop trying to do that, Miss Love. But if it happens during trial, there might be things that the defense just lets her do because the jury will dislike it. I mean, if we have, and this is where I'm going to default to, I think it was Smilin' Wolfette that pulled this clip of what the AI chat summary, what YouTube's AI is using to summarize what you guys in the chat think about what's happening in this live stream. This is what it says. Viewers are commenting on how ineffective the lead prosecutor, specifically the lead prosecutor. It knows that we're not talking about Atkins. It knows we're talking about Love. How ineffective the lead prosecutor is in presenting her case against the defendants. Many people are noting that they could do a better job than she is, and that her lack of organization, rhythm in her speech, and failure to provide a clear and concise presentation are harming the state's case. So shout out to the chat, because you guys made YouTube's AI understand exactly what you're thinking, really across the board, like probably 99% of you. I kind of want to say 100%, but I'll say 99. And it's exactly what Jermaine's saying here. The jury could get the same read that we are. So even if she continues the BS, it's frustrating. She shouldn't really be allowed to, but it kind of hurts her more than it might hurt the defense in most cases. So great food for thought there. Love that AI summary, so thanks for sending that over. And we've still got half an hour. I mean, we could keep watching some clips. Those are really the interesting ones to me today, you guys. We replayed them already. Anything else interesting you can think of today that you might want to get a second watch on? Let me know in the chat. Fran Drew, love the picture with the Dora the Explorer haircut. Sends a peach sticker. So this might be impeaching. We're impeaching or impeaching. It might be peach for a butt, using peach instead of saying the word butt. It might be James and the Giant Peach. I don't know, but I appreciate it. Don Allen says, has there been a ruling on Weinstein's motion for a mistrial? No, not yet. And the state has until tomorrow to respond. So we won't see a ruling on that until probably Monday. But the state has until tomorrow to respond. There's no court tomorrow, so we can get together. We can congregate and maybe, you know, get the same type of live stream going tomorrow with a summary like this when we read the state's response. We'll see. But that's exactly why she hasn't ruled on it yet, because the state, I think Shard had filed his motion, his recent motion, renewed motion for a fair trial on Friday that just passed. And then Doug Weinstein filed his addendum on Monday. So the state deserves like a time period to respond. Whitaker gave them till this Friday. We'll see if they do it and how well they do. And then once she gets the response from the state, she can decide to make a ruling. So that's why we don't have a ruling on those yet. Thank you for the super chat. G. Lander says, Love is a doublespeak sidewinder specialist. Yeah. Hearing it again, it's not like she said much more. It was basically her panicking to try to say, well, I still want to be able to do whatever I want to do whenever I want to do it. And not really having a basis to justify that. So something yada yada, comments, witness relevant. Let me say those key words. And maybe the judge will go for it. And thankfully the judge didn't. Because sometimes she has been kind of generous with, all right, I'll allow it. It is Ramon says, how many jurors need to say not guilty to acquit? Just one. Just one. Just one. Well, and maybe not to acquit for a mistrial. But, so if the jury can't come to a conclusion, They're going to say, like, keep trying to figure this out. Okay, guys. Pretend we're in deliberations. You're a juror. You've been here for like 2 years doing this. And then every time you say we can't come to a conclusion, we can't come to an agreement, they tell you to go back and try again. Do you think you'll try any harder? I honestly feel like it would be an impossible task. If I have questions and I'm not clear on something, I wouldn't know how to send a note to the judge to say, look, we want to revisit this person's testimony. Can we see the transcripts from when that witness was on the stand? Can we listen to this recording that was played? I wouldn't even know what to ask for because there's too many names. It's not presented clearly. So if there's anything that we were unsure about, but maybe we could get into agreement on if we review that particular relevant piece of evidence back in while we're doing deliberations, right? That happens in trials. You get a juror question, they want to look at something, suddenly they come out with a verdict. So whatever they looked at, it might have helped them get over that last hurdle to come to a unanimous decision. How do you know what to ask for in this case? How do you know what to ask for? And I think it's a bit more difficult. Jurors also want to bring justice for a victim. I do think juries want to say, well, there's enough here. They wouldn't bring this case for no reason. So I don't think that necessarily means they're all going to walk in there and say, not guilty, this case was a mess. Because I do think most people will say, you know, people probably, if there's this much going against them, maybe there is some there. And that might be a situation where they sit there and they say, all right, well, what can we say yes on? We don't want to say yes on everything. But out of like these 60 different babies, which ones can we split? Which one can we split? Because we've got a lot of choices. Yeah, kill me now would be my reply if you had to keep going back there and sitting there. Oh my God. Jim would send a note that says, Your Honor, we want to hear the last 931 days of testimony. Somebody out there's like really appreciating that $25 a day and the free lunch. They just want to keep dragging it out. Oh my goodness. Smiling Wolfette, and a lot of people are saying there's zero way that I could convict. And I hope you guys don't take what I'm saying as I think that jurors like to look for a way to bring justice as me saying I would go and look for a charge just to say yes to. But I do think when you have 12 people in a room, some diversity in there of ideologies. Some people trust police. Some people trust detectives. Some people dislike detectives. And that stuff may have been questioned during voir dire, and, you know, you strike who you think is strategic to strike. But I do think there's always going to be somebody in that room that thinks, I'd really have to think about why we sat here for 200 days if there's nothing here at all. And I think that's part of the state's strategy, is just flood them, drown them in things. Who cares if they can make sense of it? Because surely they'll feel like if they're drowning in evidence, even if there's no coherence behind it, they'll just say, yeah, this probably happened, sure. And juries are supposed to find that the elements of each charge were met, and that the state proved it beyond a reasonable doubt. But just because juries are supposed to do things, jurors are supposed to do things, doesn't mean they actually do. So it's a crapshoot. It's unpredictable. Yeah, and like Rob Hoff, I think that's where I sit, is juries have a bad habit of compromise verdicts. So while as much as I want to agree with the defense that they're probably winning in terms of the major charges, and I guess the flip side is some of the minor stuff, you know, a lot of it could count as time served. So what's the difference, right? Just get it over with. But, you know, I do think the defense is right that they are winning as far as credibility on these big charges, but that doesn't mean that their clients, the jury will go back there and just say no down the whole, I don't know how many pieces of paper their deliberation forms or jury forms are going to be, but down the line, like 50 pages, 60 pages, 70 pages, like, no. That's a big mountain to climb, to get the jury to say nothing at all. So we can keep playing. This is a replay. We still don't have any activity. They're still on lunch until 1:15. And great point. So this looks like talking about Miss Love. Not Too Crazy says, I don't even think she realizes she's lying. I believe she does it so often without thinking, it just becomes her truth. And then shout out to now, so I gotta get your name correct because I still want to say your old name. But S Satchel here says, just got back from buying food for my cat. So here's a lunch for another cat. You know, I ate one of these. I didn't think they'd be very good. I ate all my Kind bars. So today I had like a blueberry pastry crisp. I think it flips on the screen, so it might not actually show you. But it's like Kellogg's. There's a blueberry pastry crisp. It's kind of like a thin Pop-Tart. It was pretty good. It was pretty good. So thank you so much. I did also put rice on. I put the rice cooker on while I was on my little break while we had the video playing. Because I'm going to have rice and pernil later. And then I think I just want to check the chat consensus if you guys want to keep playing anything. And you guys say going over the motion. Do you mean the instructions? You guys want to go over that again? The Harvey instruction? Let me know if that's what you want to go over, because that's the only motion I had seen so far today. So yeah, I think that might be what you guys mean. We can go over that again. Oh, you guys want to go back over the March one. So we're getting yes on the instructions, but also the March one. So let's go over the instructions, and then we might actually have enough time to do that 9-page one from March. But while I do that, when we do the March one, can you guys like repeat in the chat every so often that, hey, remember this is a flashback for March? I'll verbally remind people too. But thank you so much again, S. Satchel. So nice. And shout out to the cat, the other cat. And then Yedat says, at least she's taken 2 weeks to rule. Rather we like her ruling or not. Glanville would deny 5 minutes later without the state having a written response. Yeah, because he doesn't need to see it. He already knows what they're going to argue or knows that he would agree with what they argue. So that's a very good point. And thank you for the super chat. So let's pull up this limiting instruction again. And you guys know me, I personally think that the last line was really the most pertinent, but let's get this giant on the screen, hide this banner. So this is the proposed limiting jury instructions that was filed today at 10:45 a.m., and it's why we had that recess earlier. So, I instruct you that some evidence may be admissible as to some of the counts, or some of the defendants, but not admissible as to other counts or other defendants. So in other words, what this means, guys, is they're telling the jury that not everything that you're seeing is being admitted as evidence for the counts as alleged, all of the counts in the indictment, or against all of the defendants. It's just since there's enjoined defendants here, we have to get through all of it to get through all of these counts that may only apply here or there. In that regard, evidence related to certain alleged acts specified in count 1 of the indictment may be admissible against those defendants on trial charged in that count. However, I remind you that in order for you to use such evidence against those defendants not alleged to be involved in the counts under your consideration, you must consider whether the alleged acts for which the evidence is being offered have been proven, beyond a reasonable doubt, to be part of the overall scheme alleged in count 1. Likewise, evidence of a person's prior statements that may be different from those admitted here at trial may be used by you to evaluate the credibility of the witness testifying, but not as proof of the matters asserted or against others not alleged to have been involved in the events being testified about. That is, prior inconsistent statements are offered for the limited purpose of determining the credibility of the testifying witnesses, and not to prove the truth of the statements made. And the reason I think this bottom statement is so important isn't just because that's something that should be considered. That's an instruction that just makes sense. It's especially relevant here because of the way that the state relies, and we've seen them try to rely on inconsistent statements as a reason to bring in different evidence. So an extra reminder that when we see something, a witness on the stand, oh, well, you know, I did this because of that. Well, in this interview with the detective, you actually said something else. So now we're going to play this whole clip so the jury can hear what you said back then. That is used so often in this trial. It seems like we're going to continue to see that with Kenneth Copeland if he takes a stand. We're going to see that with Zachary. We're going to see that with Sledge. And it's a great reminder since it's so common. It's like the bulk of this case, this trial. Hey, jury, reminding you that those inconsistent statements, when you see that video played back, the purpose is for you to determine whether you think that witness is credible, but not about whether or not that what's being said in those statements is actually true. So this was turned in by Bruce Harvey and Miss Westmoreland. We don't have the second page here, but this was it. It says this 8th day of August, and then the next page would be the signature and everything. So that was what we got today at 10:45 a.m. And let's see. Yep, this is a redo of the Harvey motion. Well, the limiting instructions. And then, let's see. Good to see you, Biff. So, if I'm a juror and I found out all they have is this, LOL. And yeah, change from 10 minutes to lunch break. And then let's see. Well, and wait 1 minute says, people, you're not watching the real case just yet. Go on with your life for now. I mean, I like motions. I like arguments. I like these kind of off days, these housekeeping days. It's a bit of attorney sparring. The attorney sparring hasn't been that ferocious with these statement redactions. You know, I think Atkins and Shart, you guys have heard me say it 3 times in the stream. I think they've been professional about it. But I do like paying attention to the days like this, which aren't the actual trial days of testimony. I do plan to cover Monday because I expect that we'll have some sparring over what's going to happen with Kenneth Copeland taking the stand. And then let me pull up the other, you guys wanted to go back and look at the March motion. Let me see if I saved that in my history because I closed it. Okay, so this is going to be the one from March 19th. March 19th. It's not new, but it's relating to something that Love is still being asked to do, and she has it. And then motion to limit witnesses due, and this is so tiny. This is so tiny. There we go, a little better. The motion to limit witnesses due to undue delay, and I gotta get my banner up, because otherwise people are gonna be confused. Let's say old motion from March. There we go. So, the defendant, Diamante Kendrick, by and through his undersigned counsel, without waiving any other rights to which he is entitled, files this motion to limit witnesses due to undue delay, waste of time, and or needless presentation of cumulative evidence, stating the following. Now, if you've seen any one of those 3 things happening in this trial, whether you've paid attention from the beginning or like since June, put a yes in the chat. As this court has broad discretion to exercise reasonable control over the presentation of witness and evidence, the court should use that discretion to prevent this trial from stretching into 2027 due to the presentation of cumulative evidence causing undue delay, poor decision-making by the jury, as well as harm to Kendrick and other defendants. The U.S. Supreme Court has explained the critical role of the trial judge in a criminal case. Here's a paragraph. Our cases have consistently recognized the important role the trial judge plays in the federal system of criminal justice. The judge is not a mere moderator, but is the governor of the trial for the purpose of assuring its proper conduct and of determining questions of law. A criminal trial does not unfold like a play with the actors following a script. There is no scenario and can be none. The trial judge must meet situations as they arise, and to do this, must have broad power to cope with the complexities and contingencies inherent in the adversary process. To this end, He may determine generally the order in which parties will adduce proof. His determination will be reviewed only for abuse of discretion. The judge, this is in bold, the judge may refuse to allow cumulative, repetitive, or irrelevant testimony, and may control the scope of examination of witnesses. If truth and fairness are not to be sacrificed, the judge must exert substantial control over the proceedings. And that's from Geters versus United States. And then the state, after originally proposing a witness list of over 700 witnesses, has a list of over 400 witnesses it intends to present at trial. To date, the state has presented approximately 40 witnesses since presentation of witnesses began at the end of November. And we are reading this as a March 19th, 2024 motion. At the present representative rate, it will take until approximately October 2026 to complete the presentation of the state's witnesses. Thus, the present trial will take well into at least mid-2027 to complete. This is simply untenable for the remaining 15 jurors. There we go, 15 jurors at this point in time, in March. Or the defendants who remain jailed and without bonds, and the presentation of another 360 witnesses by the state would cause undue delay, would be a waste of time, and would amount to needless presentation of cumulative evidence. Now we have a footnote here. This footnote here says, here we have the situation described so clearly by Judge Bertelsmann in his oft-cited 1986 decision on limitations imposed at trial. The judge remarks with this insight, it would seem that early in the career of every trial lawyer, he or she has lost a case by leaving something out, and thereupon resolved never again to omit even the most inconsequential item of possible evidence from any future trial. Thereafter, in an excess of caution, the attorney tends to overtry his case by presenting vast quantities of cumulative or marginally relevant evidence. In civil cases, economics place some natural limits on such zeal. The fact that the attorney's fee may not be commensurate with the time required to present the case thrice overimposes some restraint. In a criminal case, this is bolded. In a criminal case, however, the prosecution, at least in the federal system, seems not to be subject to such fiscal restraints, because, the government can keep the train going. And the attorney's enthusiasm for tautology is virtually unchecked. So, tautology means, using too much, you keep going. Let me double check. You keep bringing a bunch of stuff. Oh, a logical combination of sentences that is always true, regardless of the truth or falsity of the constituent sentences. So they keep going on with this belief that they would be best off if they continue to overtry their case, bring in as much as possible, because that's better than leaving something out. Because maybe I've lost a case because I think I left something out. So they keep doubling down on that belief. And we left the footnote here. So as put so succinctly by the Third Circuit Court of Appeals, courts need not allow parties excessive time so as to turn a trial into a circus. After all, a court's resources are finite, and a court must dispose of much litigation. In short, the litigants in a particular case do not own the court. And that's Duquesne, right? We're going to say that's Duquesne Light Company v. Westinghouse Electric Corporation. Likewise, the prosecution here does not own this honorable court. Oh, did they back in March? Did they back in March? What do you guys think? And remember, March 19th, 2024 is what we're looking at right now. This is where this is coming from. And I do see the super chat. So FFS, can we please hit on the Jaina versus DV? So a directed verdict, really the stage of the trial is one of the key distinctions there. So a directed verdict is something that would happen at, for example, in this motion that we're reading right now, they're guessing that, hey, if they want to call 400 more witnesses, the state would still be calling their witnesses through October 2026. At that point, they might finally rest their case in chief. Now, when that happens, the defense could motion for a directed verdict. That means the judge would be able to say, look, based upon what's been presented so far, it's not sufficient to prove the elements, so I'm, going to dismiss this case or dismiss maybe certain counts because there just isn't enough evidence, and we've already seen all that the state is going to present. They've rested their case in chief. So at that stage of the trial, you'd be dealing with a directed verdict. But if you're talking about the judgment notwithstanding verdict, we actually get a jury deliberating and a jury rendering a verdict. And I think there are some civil and criminal distinctions here. Let me see if I can type. Because in the criminal realm, with a judgment notwithstanding verdict, for example, if the jury comes back with an acquittal, a judge can't just go and enter a verdict that suddenly ignores that acquittal and decides, all right, here's a judgment of actual guilt. They're actually guilty. But what they can do is, if for some extreme misinterpretation of the law, there's, the verdict returned is just completely outrageous. This should only be used in a limited circumstance. A judge could decide to enter a separate judgment instead of what the jury has actually returned on a specific count or all of them. And it's extreme. I don't really know. I know of any cases offhand where I've seen this actually happen. But it's a way for a judge, after a verdict has been rendered by the jury, to say, well, you know what? Actually, we're going to set aside this verdict. We're going to do something else. And you might see, I think people file motions for this type of thing, but it's typically not granted. It's typically like, well, if you have an issue with it, take it to the appeals court. So, and honestly, I've read some motions to set aside a verdict where the judge actually underscores, like, hey, maybe this specific issue could be a good one for you to raise with the appeals court. So really, to me, the biggest distinction is the stage of the trial where this actually takes place, because one is when the state rests their case, and the other is after the jury has already rendered their verdict. So there's your two distinctions there, summarized. I'm not a lawyer. I'm not a lawyer, but that's my understanding of those things. And then Jake Capo says, I'm buffering. And then, I don't know if you have any... You did miss some good drama. We replayed it recently. If you want to go back about probably 35 minutes from where we're live right now, if you're currently caught up live in real time with me speaking right now, and you want to go back about 35 minutes, you'll see us start playing clips of Love standing up and Bruce Harvey making some arguments. And in my opinion, Love is pretty much told to sit down and shut up for lack of any better way to characterize it. Yeah, and you guys don't want to see any more Love. Nope, whatever has been outstanding for motions on a mistrial is still outstanding. The state has until Friday to respond to that. She could find a reason to dismiss the case, and it doesn't need to be in relation to a motion for a directed verdict. But I think that's an extreme circumstance. I don't suspect that will happen unless we have something undeniably egregious happen yet again with the state. But it wouldn't really be an acquittal. It would be a dismissal, which would say that there was no verdict. So because this is a jury trial, it's really in the jury's hand to find the guilt or to acquit, or a combination based on all the different charges, the counts that they have to decide. But she could decide to dismiss because something comes up. She could decide with a motion for a directed verdict, there's not enough here, we're going to dismiss the case. But I don't think she would get in trouble if she just said, coming back from break today, I just think we should give these guys acquittals. So she can't do that. So. And then let's see. Continue this motion. Let's see. Remember, we're looking at a motion from back in March. We are all the way back in March 19th, but it's really relevant because it's dealing with, the state trying to introduce and use cumulative evidence, repetitive witnesses, and cause these undue delays and stretch the trial out unnecessarily. So I think we're down here. This honorable court has broad discretion on the presentation of evidence and should limit the introduction of duplicative or unnecessary witnesses by the state. As noted by the Georgia Supreme Court, OCGA 24-6-611A2 provides the trial court with broad discretion to exercise reasonable control over the presentation of witnesses and evidence to avoid needless consumption of time. That's Newman v. State. The Fifth Circuit, the predecessor to our 11th Circuit, has also recognized the ability of a trial court to limit the number of fact witnesses at a criminal trial, where those witnesses' testimony would be cumulative. We've heard this argued a couple times, maybe a couple times today, but I think I heard it once today, but yesterday as well, where like, we want to play these statements, but we've already asked detectives on the stand about these statements. So I'm going to argue that it's cumulative. And in some of those arguments, the judge said, all right, we're going to strike like 1 or 2 lines here. Most of the time she's saying, if there's a reason that there's a different way, maybe an inconsistent statement, then maybe we can play this clip again. But there has to be a reason for it to be played. So, and I think that's a big difference because Glanville was just kind of like, we'll deal with the issue later. Wouldn't even say that. And that was from Chapa v. United States, which was upholding the limitation of the number of fact witnesses a defendant was allowed to present to testify to the efficacy of his treatment methods. Furthermore, this court can limit evidence under Rule 403 of our state's rules of evidence. Relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Thus, there's also a basis under Rule 611A2 or Rule 403 for this court to exercise reasonable control and discretion in requiring the state to limit its witnesses to eliminate witnesses that would cause undue delay, waste of time, or be a needless presentation of cumulative evidence. And then here it says, Mr. Kendrick is not requesting that this court limit the number of witnesses that are crucial to the state's case. Speaking to the federal rules of evidence, Rule 403 does not mean that a court may exclude evidence that will cause delays regardless of its probative value. If the evidence is crucial, the judge would abuse his discretion in excluding it. And now, this is, sometimes you want to clarify that you're not asking for too much. So this footnote here is saying, we understand that there will be a lot of witnesses that have something with probative value to bring to the table. We're not asking you to exercise and lean in our favor and abuse your discretion just to keep those witnesses out. It would make sense to bring them in, and we would agree to that. But all this other nonsense, bringing in 3 witnesses to attest to the same fact, the 2 witnesses at the rental car company, like, why do we need 2 of those people to come and testify? That would be something that maybe Judge Whitaker would have used her discretion differently than Judge Glanville did. So the motion continues, it has never been supposed that a party has an absolute right to force upon an unwilling tribunal an unending and superfluous mass of testimony, limited only by its judgment and whim. And that's MCI Communications Corporation v. American Telephone, so AT&T. Analogous to the sought-after relief of limiting the number of fact and expert witnesses brought by the state is the recognition by the U.S. Supreme Court and the 11th Circuit Court of Appeals of the ability of a trial court to limit the number of character witnesses that may be presented by a criminal defendant. The Supreme Court has noted that the district courts are invested with discretion to limit the number of character witnesses and to control cross-examination. And then it's United States v. Benefield, quoting Michelson v. United States. If a court is within its discretion to limit the number of character witnesses for a criminal defendant whose life and liberty are at risk, this court can surely limit the presentation of witnesses by the state who would be cumulative or cause undue delay. And then Fong Fu v. United States. Hold on, what is that case? Because we'll pin that. Oh, it's a double jeopardy case. And we're going to Wikipedia it. So Fong Fu v. United States was a Supreme Court ruling that upheld the protection from double jeopardy by the federal government. While the protection from double jeopardy did not get incorporated to apply to the state's government until 1969, because this is going back to 1962, the Supreme Court ruled that the Fifth Amendment to the United States Constitution prevented the federal government from bringing a defendant to trial twice for the same charge. In this case, the court ruled that despite the error of the district judge, the Fifth Amendment protected the defendants from facing a second trial for the same charge. So, and this is where we get a gray area, right? Because sometimes even though it seems like a retrial would mean the defendant's got to face another trial for the same charge, double jeopardy doesn't stick. It didn't stick for Y&W Millie. But it is a great case name. It sounds like a movie. Amy Charlene, thanks for becoming a member. And then, yeah, so Don Dada, I saw you joining late, but it looks like others have already given you the instructions. So if you're still watching this live, go back about 50 minutes at this point, and you'll be able to see Bruce Harvey say, "Excuse me," because Love's trying to cut him off. And you'll see Love get chastised again, but not really held to any smoke and fire for doing the same thing she always does. Okay, cool. So maybe this is in it. So the court acknowledged that the trial judge's action in acquitting was based upon an egregiously erroneous foundation. And you might be, let me go to like Justia or something. Okay, cool. So we got the paragraph you're quoting here. So the petitioners were tried under a valid indictment in a federal court, which had jurisdiction over them and the subject matter. The trial did not terminate prior to the entry of judgment, as in Gorey v. United States. It terminated with the entry of a final judgment of acquittal as to each petitioner. Okay, so there we go. That's kind of key context too. So the trial, they already had a judgment entered, and the judgment was of acquittal. So the Court of Appeals thought, not without reason, that the acquittal was based upon an egregiously erroneous foundation. Nevertheless, the verdict of acquittal was final and could not be reviewed without putting the petitioners twice in jeopardy and thereby violating the Constitution. Yeah, so there you go. And interesting. This is not the same last name Whitaker here. But look at the bottom here. One of the judges just happens to be named Mr. Justice Whitaker with 2 T's. I was like, wait, hold on. This is an old case. But wrong name, different spelling. But yeah, so this is a bit more clear cut of exactly what we think of double jeopardy, right? The jury already said you're good. They rendered a unanimous decision, and in this case, we're acquitting you. You've been acquitted. We can't just retry you because we didn't like that the jury decided to acquit this person. So get back over to, and we're almost back from lunch, so I don't think we're going to get through this full March. Remember, it's March 19th, 2024 motion. But let me drop it in the chat. So you can read it in full. And I think because we're coming up on the time here, we can look at the remedy. And a lot of this was case law anyway. We weren't that far off. Yeah, I think we could probably speed through this. I have the sound up, so we'll hear. But yeah, so courts outside of Georgia and the 11th Circuit have recognized the impact on a jury of lengthy trial merit consideration. For example, as the 7th Circuit has approvingly quoted, exceedingly lengthy trials lead to reduced concentration. And Miss Sylvia says that, you know, there's like one that seems to take notes, but some don't seem to really be paying attention. I don't blame them. This is a long trial. Would you guys be able to concentrate? I mean, even in the chat when we're dealing with these, this isn't testimony, right? But it's still something going on in the courtroom in front of us. But when we see these arguments about should this be redacted or should it not be redacted, it's like, oh God, this is boring. We don't even know what quotes they're talking about. So just think if you were sitting and you're stuck there and that's all you could do. You couldn't just pull out your phone and check out the comments. You didn't have a chat to keep you entertained. Like, we have the chat and that's a blessing. So exceedingly lengthy trials lead to reduced concentration and recollection of events on the part of all participants, particularly witnesses and jurors. In very long cases, exhaustion may diminish everyone's performance. The quality and representative nature of the jury may be reduced by the fact that many citizens, often the most competent, are unable or unwilling to take the time to sit for cases lasting weeks or months. or years. And that's a great, great point. United States v. Warner, quoting Gordon Van Kessel, adversary excesses in the American criminal trial. In Warner, the court also notes that jurors became overwhelmed by the volume of evidence and numbed by its repetitiousness. Their attention flags, their minds wander, the witnesses, there were more than 100 in the trial of the two defendants, get mixed up in the jurors' minds or forgotten. The profusion of exhibits makes the documentary record unintelligible. And we know that there were a bunch of issues with how the exhibits were filed anyway. The new court clerk had to come in and correct some stuff. The impressions created by the closing arguments are likely to wipe out everything that went before. And remember, closing arguments aren't evidence, but they're the last thing you hear. Jury comprehension has been found to diminish after a mere 20 days of trial. Finally, and not meaning to belabor the point, the court in Warner wisely notes, so now jurors imagine mental state after 6 months, bearing in mind that memory loss and the psychological or cognitive problems of jurors in a super long trial compound the first problem. The difficulty of recruiting competent jurors for protracted trials. A less intelligible trial is heard by a less capable jury. The longer the trial, moreover, the likelier jury misconduct becomes. The jurors become bored, impatient, irritated. The judge's instructions against discussing the case before the jury retires to deliberate becomes increasingly irksome and likely to be disobeyed. And this is a great way to put this, right? Because if jury misconduct sounds like big, malicious, egregious violation of what you're supposed to do, but here the misconduct is just an inability, and an understandable inability. Something that we kind of expect that the jury won't be able to pay attention, have patience, not become irritable. It becomes the improbable possibility that a jury could actually not engage in misconduct. I want to use that word lightly. I'm not saying you guys get it. But it becomes almost impossible to expect that these things won't happen the longer a trial goes on. While the state puts on its case, witness by witness, Kenneth, spelling error, and the other defendants sit in jail, their lives on hold, the clock ticking on their lives, second by second, minute by minute, hour by hour, day by day, month by month, and maybe year by year. Meanwhile, the risk of a confused jury, unable to comprehend a years-long trial, only grows. Wherefore, Mr. Kendrick respectfully requests that this honorable court, 1. Order the state to provide a detailed witness list by April 15th, 2024. This was submitted on March 19th, 2024. For those who joined the chat late today, can anybody that's been here all day tell us if Love submitted this witness list that she was ordered to? Did she submit this today when the judge asked if she had submitted it yesterday like she was supposed to? Can you give an update to the people that joined late? So they want a detailed explanation of the expected testimony of each respective witness and an explanation of how that witness's proposed testimony is not cumulative of proposed testimony of other witnesses, nor causing undue delay, nor a waste of time. And B, make a finding of whether each witness on the detailed witness list will likely cause undue delay, a waste of time, or be cumulative. And for those witnesses so determined to meet one or more of those 3 criteria to be barred from testifying. So, respectfully submitted on this day, March 19th, 2024, Jay Abt, Douglas Weinstein, and Katie Hingerty. So, great thing to do a flashback to. I'm sure you guys have answered in the chat. They did not meet that limit. Yeah, she gave some of it. It wasn't complete. She was still working on it, and she was working on it in court this morning. So, and then Susan, great point. Then she changes the order of the witnesses that Judge Whitaker has been asking about all week. We actually want to call Sledge, and we have no court tomorrow, so we have to get through Sledge's statements today. Even though we've been working on Zachary because we said like 2 or 3 times that he was going to be the witness we call if Copeland doesn't testify. I think the court is afraid, I think the state is afraid that Zachary might not testify either. I don't know. I don't see it back, so let's see. There we go. Thank you, guys. And we're not mute. It's not me that's muted, so I think they don't have audio on in the court. They're almost back. There we go. There we go.
I think had sent over something. Then there were two things, I guess, like an initial and then a revised suggestion from the state. Has anybody else sent anything?
And Judge,
Oh, wait, no, that's not.
Oh, they muted again. They muted us again. So I can't wait to see how the state wants to change Harvey's instruction. They're gonna be like, can you take out the inconsistent part?
suggested instructions sent by the state dealt with the.
Right, Mr. Copeland, how to handle Mr. Copeland's thing.
Yes,
Oh.
I have a response with respect to Mr. Harvey's request. but
Okay,
not
if you
a-
want to email that to Ms. Persfield?
It's not a suggested response, suggested instruction. It
Right.
is a response that we should not give an instruction and the
Oh.
reasons why at this point.
Regardless, I haven't seen it, so if you want me to.
I was gonna orally, but I can.
Okay, that's fine. If it's not in writing, that's fine. I thought you were, I maybe misunderstood you. I thought you were saying you had sent something over. But no, if you just want to orally say, here's why I don't like Mr. Harvey's instruction and why we shouldn't give one, that's fine. I think if we do give it, we need to work on it. And I'd also like to maybe sort out from Mr. Harvey. I'm trying to find it. There it is. So there's the kind of limiting concept about RICO versus other counts, but then there's also included in the same instruction, hey, here's how you might consider prior statements. And are you just proposing that I give some general instruction like this at one point and then we move on? Or I'm not sure what you're proposing.
Okay. When, for example, we have Mr. Copeland on the witness stand, we've spent an inordinate amount of time going through his prior statements.
Right.
To weed out those portions that may or may not be admissible. But the point of the prior statements is that he is being impeached
Right.
from his testimony at trial. And if it is impeachment evidence, then it can be considered with regard to the credibility of Mr. Copeland and for the act in question, but not for any other purpose. That is, I guess, my point. And, you know, we just got a potential witness list with exhibit descriptions.
They got it.
Which includes the captions impeachment, impeachment, impeachment in some of the categories and some of the exhibits. And I know those are potential depending upon what the witness testifies about, but we're clearly in impeachment territory with Mr. Copeland. So I understood Your Honor to say, look, this may be admissible against everybody because they're all charged in count one. And that was the first part of my proposed instruction. That's what I understood you to say yesterday. And I don't really have an argument.
You know what? Thanks for bringing that to my attention because you're right. I guess, yes, during this exercise,
Yes.
I guess at some points I've been thinking about, okay, substantively speaking, how does this come in? And you're right. If we're thinking about certain of these things as coming in only if they are prior inconsistent statements, then yes, you're absolutely right. So yes, thank you.
Well, that's why it was kind of
Okay.
joined together.
Okay, so I guess, thank you for that clarification. And then also what I'm asking is, are you suggesting that I just give this general instruction to the jury, you know, basically whenever we restart the trial on Monday? Or are you saying before each kind of thing comes in,
Well, I don't necessarily know whether you need to do it beforehand. And that was the old rule prior to the new evidence code. And I think the old cases, and they were old cases from like 1990.
can you try to speak into your mic?
Oh, I'm sorry.
I know it's a lot to do at once.
The
but-
old cases were from like 1998, and they said you got to give it beforehand. And you said that yesterday. Boy, I think you got to give it beforehand. And I don't think that's the rule anymore. And I think if you look at the new proposed jury instructions for the Superior Court jury instructions,
Yeah.
it says, and I'll quote, note, new code section requires the judge to give limiting instructions when applicable on request. Probably better to give if applicable, whether requested or not. Now, if witnesses are not impeached by prior inconsistent statements, then it's unnecessary to give it. If they're impeached after, and there's a prior inconsistent statement that may be admissible, I think after that evidence comes in, not before, because you won't know necessarily.
Sure.
You can say, this is admitted as impeachment, and it goes to the credibility of this particular witness. That's my request.
Okay,
That's why
so,
it's in two phases
well, yeah.
or two
it-
paragraphs.
Yeah, as you proposed it, that's kind of what I'm trying to sort out is they are two different topics. Do you want it as just
Well-
one big instruction or? And no, I don't think that it's appropriate every time a witness is impeached to say, hey, this might be impeachment, or this is or was impeachment, and here's how you consider it.
Well, it may
And not talking necessarily to kind of impeachment evidence, but sometimes there's other evidence that comes in for a limited purpose.
I agree. And I have asked for instructions when I thought, and the state has objected, and they've said, look, it comes in against everybody, and I understand their argument, and I could probably give the same argument that I know Ms. Love is going to stand up and give.
Yeah.
But I have asked for those instructions. And when evidence comes in as impeachment, I'm going to ask for the instruction and have it limited to that particular count and that particular person.
Your Honor, I would.
Yeah.
Just as to Mr. Harvey's words regarding evidence that comes in as impeachment, I'm hearing, and I'm aware that he may not be saying it as I interpret it, but this makes the second time once he previously, before Your Honor began presiding over this case, once he expressly said impeachment evidence cannot be used as or is not substantive evidence. And I wanted to just make clear that under our evidence rules, impeachment evidence is in fact in the form of a prior inconsistent statement. A prior inconsistent statement is substantive evidence, not just impeachment evidence. So to the extent that Mr. Harvey is asking for any kind of limiting instruction, because we ask or we admit a prior inconsistent statement that is impeachment evidence, I would object to that, because that statement now becomes substantive evidence that is admissible, not just for one person or to, somehow attack the credibility of the witness on the stand, but now it becomes substantive evidence of what is stated, of what is given in that prior inconsistent statement. And because each of the counts in this indictment are alleged as overt acts in count one, and everyone is charged in count one, a limiting instruction based on Mr. Harvey's interpretation or assertions regarding inconsistent statements and the acts alleged regarding, or who is alleged to have physically committed the acts, would not be proper. The response that I have to the overall requested instruction he has, it makes it, it goes into it a little bit more, why it would not be proper, but just based on what he has just said, we would object to that, primarily because an inconsistent statement is substantive evidence.
All right. Well, with regard to the beginning of your paragraph 1 that doesn't concern prior statements, that I think.
Thank you, Mrs. Hemp.
Is meant to concern the RICO count. That needs to be much more specific. So maybe if you could endeavor to make it more specific as to, if I'm going to give the jury an instruction, I want them to actually benefit from it. So, let's talk specifically as to RICO, and then I guess I am asking, prior statements aside, as to the RICO issue and then the substantive counts issue, is your proposal that I say this once, hey, these people are charged all in count 1, which is RICO. Certain people are charged in other counts, other people are charged in different ones, and we can be specific about it. But as you hear all of this evidence, keep in mind that it can all be considered against everybody with regard to your determination of whether the state's made its case on count 1. But it can only be considered as against the defendants who are charged, as to everything else.
All right.
And give that once, or give that, I think give that once, because otherwise it's, okay, now I don't know if we're going to very cleanly break each time from, all right, this is counts 2, 3, and 4. Now we're done with that. This is counts 5, 6, and 7, so that I could separately charge each time.
But the jury has to make the determinations as to the predicate counts. Did the state prove that first place?
I know
this predicate count. Did they prove this predicate count, and that anybody else may be a participant or should be? That conduct should be imputed to anybody else. That's the issue.
That's the whole concept of a conspiracy in RICO.
I get it. But when you are admitting inconsistent statements.
All right. Now, I don't want to talk about inconsistent statements right now. I'm talking about how to handle the RICO count and what should be limited with regard to that. Okay, we'll get to the inconsistent statements in a minute.
We will try to make it more specific and resubmit it. If that's what I understand.
All right. Yes, and then do you all think that and I know you don't want one at all from the state on how they should consider other charged crimes against everybody as for RICO, but not against everybody as for guilt to that crime itself. But assuming I'm going to give one anyway, is the best way to do it a one-time, let me explain this to you and how you consider it, and not every time we move to a potential different crime. I'm leaning that way. So I'd like for y'all to try to craft something that way. So anything else on that?
Just to say that broadly, to give an instruction at any juncture other than the end as it relates to the RICO count and how it should be considered would be confusing and premature because it would be incomplete. Especially the way that we've seen it in Mr. Harvey's proposed instruction. So just as much as the court is asking, how are we proposing instructions be given on, during or throughout or at one time at the end? Our position is that regarding this topic, at the end, at the very least, one time at the end, and we have more to say that we can put in writing in response to Mr. Harvey's.
Okay, well, I don't think it's particularly helpful to have the jury not have any idea how they are supposed to be considering and evaluating this evidence while they're listening to it. And I know they're not deliberating on the evidence until they all get together at the end of the case. And I know that they are not making any kind of determinations about it until they're deliberating together at the end of this case. But as they're taking it in, it might be helpful to have them know how to be conceptualizing it. And if this were my trial from the outset, yeah, it would be pretty bizarre for me halfway in to be like, oh, hey, by the way, here's an instruction about it. I would have done it before now. But if I'm going to do it, it's not that weird for the first time they see me while I'm telling them other things anyway to say, and hey, this might be helpful as well. Here's something that you need to think about, and here's a way to think about it. So what I mean for that is, and I mean, I think I'm making the decision anyway. I think the appropriate way to do that is to give that instruction once and then give it again at the end to remind them, but not throughout the entirety of the trial each time we move from one set of crimes to another.
So Your Honor, I'm going to let Mr. Atkins address part of what the state's response is. And then if the court will permit me, I just have to say a little bit more after he addresses the first part. Go ahead.
Your Honor, I just wanted to highlight that I think an important thing to consider, because there seems to be conflating the concept of relevant evidence and admissibility at trial with every defendant being charged in count one, the RICO. Evidence of, for example, Act 39 we talked about, Mr. Winfrey. If the jury finds that overt act was made by Mr. Winfrey, that is relevant evidence to their overall determination. And so I think any instruction, if the court were to give one, I think, as the court alluded to, it needs to illuminate something in the jurors' minds, not confuse them, but explain something. With every defendant having count one, there's no defendant who's not charged with that. So all of the overt acts which track the indicted counts, if someone is not mentioned in evidence presented in Act 39 and defendant X is never mentioned, the jury never hears any evidence of that specific defendant, that evidence is still relevant when they're deciding count one for that defendant who was never mentioned in said act. And so and of course, RICO trials of this nature, the jury instructions, they take a lot of heavy lifting legally and thought. And the case law makes that clear that what instructions the jury are given it's very important to be clear and concise because it's naturally with so much evidence it's important to get those instructions right. And so I think that is just an important thing to keep in mind of relevancy versus admissibility. And some of things in regards to relevancy, if they're admitted by this honorable court, any argument can be made at closing of why it is not tethered to their client or why the state didn't prove count one. And I just wanted to share that because I think it's important when thinking through this and to ensure as well, given the endeavor of jury instructions at the end of trial, that whatever we instruct the jury now, we don't want to instruct them something different later after a more fleshing out of all of the jury instructions, because of course, jury instruction as a whole are what's considered from appellate courts in terms of if one specific instruction was proper or improper. And so I just wanted to highlight that for the court while we're thinking through this.
Okay.
And Your Honor, I just wanted to tag on to that, that I heard Mr. Harvey reference predicate acts, and I wanted to just emphasize how overt acts are not necessarily predicate acts, and we don't have to have any predicate acts in this case. And Mr. Harvey's instruction that he's given the court so far is just wrong in that it implies that evidence introduced under count one is not something that can be introduced against every defendant. Just to follow up on the admissibility or relevance distinction Mr. Atkins just made. The other point that I wanted to make is that understanding the court's inquiry and concern about instructing the jury and making it clear for them how they are to consider evidence as we go along. My question regarding the instruction that Mr. Harvey has proposed is what problem exists right now that we are trying to solve with the instruction? And my answer to my own question is that there is not one at this time prior to the close of the evidence that requires us to give the type of limiting instruction that Mr. Harvey is requesting. Right now, as it reads, his instruction it's misleading and it's confusing.
Well, yeah, it is not particularly helpful at this point in time. It's a start because he at least said something.
Yeah, and he said
So,
they're
which is what I've
rewriting
been
it.
asking everybody to do for the last week and a half. But yeah, no, it's not what we're going to use. It is not particularly elucidating, but it is at least something. So thank you for that. At least.
Love is arguing something that the judge said rewrite.
I'm sorry. I didn't know whether you're done or not.
I was just going to point out that his instruction, it sort of implies something, but that proof of a substantive RICO violation is not an element of the conspiracy violation that we've alleged in our indictment.
Well, and I mean, in all honesty, nothing about this even mentions RICO, which is what we're trying to clear up for them. So it needs to be much more specific and targeted also. I mean, this is just general amorphous,
Well,
not helpful.
that,
Sorry.
I understand, and it's very hard to pinpoint. I think it's extremely difficult. And in that sense, please don't quote me. I agree with the state. First time in my life, perhaps.
Yeah, probably so.
But I think what the state is doing is conflating the gang charges, because if these go to the gang charges as well, then I want you to instruct the jury every time gang evidence comes in that the mere participation in illegal activity with a gang member or gang members does not, as a matter of law, constitute gang activity.
Right. It's got to be in furtherance of the gang. And I will give an instruction to that. It will not be every time gang evidence comes in. That'll be an end of the case
But
instruction.
that's what's being conflated here. We're getting RICO evidence, we're getting gang evidence, and it's coming from the same witness. And that makes it very difficult to parse out, given that kind of.
That's why we're going to have really good instructions.
And Your Honor,
I agree.
The gang is the enterprise that is charged.
I understand.
We're trying to 101 law
So
school the judge.
Let's get something much more specific than this. Now, on the prior statements thing, sometimes they're only impeachment and sometimes they're substantive evidence. So it's not true that every time a prior inconsistent statement comes in, its only way that it can be considered is as to the credibility of that witness. It's not true.
I concede a split in authority. The 11th Circuit specifically says that impeachment evidence,
Okay,
prior
so-
inconsistent statements are.
Are they talking about Georgia evidence or are they talking about their own? So then it doesn't matter what federal courts say about it.
But it's the same rule. It's the same rule. And I get it. I conceded that. I'm conceding. I'm arguing. It's the same rule. It is the exact same rule. The Georgia courts have specifically said we're adopting the 11th Circuit. So I think there's some disagreement, but I concede the Georgia rule. But sometimes it's still just impeachment.
Sometimes.
So, and, the state has said several times, both in their exhibit description and today when arguing to Your Honor, that's impeachment evidence. If we may just want to impeach them with that. And that would go to the credibility as to that act. And Mr. Nichols is not charged in that act. So I think, and again, I agree, it's very complex and it's hard to parse it out. And I think it's difficult for us in the court. I know it's difficult for the jurors.
All right. So with regard to prior statements, it's kind of whether we're talking about a witness who's testifying or it coming in some other way. But when you're impeaching a witness who's testifying with prior inconsistent statements, it's substantive evidence when it comes in. So, all right. Now there's the other issue of the jury instruction I am going to give. And obviously one jury instruction I'm going to give, we had discussed before and it's, and I had read it out, but upon further consideration of some of the motions that have been filed since that time, including the kind of new spin on Mr. Stillwell's motion for a constitutional and fair trial with requested relief, and just considering some of the motions that have been filed, I think by Mr. Williams since, I am actually reconsidering and have reconsidered and made a different decision about, at one point I had said I was going to just say disregard any comment about any of the actions of the lawyers. And I'm going back to the proposed instruction with that. And I'm going to say that may have been disparaging of any of the lawyers
Ooh,
in this
win
case.
for
Because, I mean,
Steele.
it is a fact that on the record, some things were said about certain defense counsel that
Wow.
anybody who's an attorney would consider disparaging, unprepared and unprofessional. So I'm going to address that and seek to cure that by just using that actual word. So that has changed with regard to my just general opening instructions about being the new judge on the case. Now, we have to decide how we're going to instruct the jury about what to consider and what not to consider as to Mr. Copeland's testimony. Now, this assumes, this assumes that Mr. Copeland decides to testify. Obviously, if he decides at this point, you know, on Monday not to take the stand at all, then it's a pretty easy instruction because it's disregard everything you heard from this witness. But if that's not the case, then does anybody have a proposal for how we are going to, and I think that's what the state had sent something on. And has the defense had a chance to look, and is there, I think Mr. Williams maybe has just sent over his proposed instruction, which hopefully everybody has gotten. All right.
Yeah, that was I agree, MG Law. But I think it's interesting she reconsidered it. Kind of seemingly randomly right now. Did she finally read some context
So
and get caught up to
Mr.
speed?
Williams' motion, his language, that looks pretty good to me. Obviously, we don't need to include the case law sites, but I mean, that looks like a good thing to sort of work from. Now, one thing I guess I was asking, but not very clearly yesterday, was it seemed like there was kind of a fairly clean break between the topics that were covered before the recusal motion and the topic that was covered after the recusal motion. And that being, I think, like on the one day, the question opened with, all right, now let's turn to the murder of Nutt or the murder of Donovan Thomas or whatever. And that was after the recusal motion had been filed. So was there any discussion of the murder of Donovan Thomas with Mr. Copeland prior to the recusal motion? Because it would be pretty easy to also say, not just with regard to dates and times, but anything about the Thomas murder, disregard, if that only came up after the recusal motion was filed.
Your Honor, with respect to any reference, I haven't had a chance to listen to all of it and read all of the testimony that and all of the questions that Ms. Hilton asked of Mr. Copeland. But I can say that so I at this time, I would ask that the court not instruct the jury as to disregard any specific subject, because.
Well, I'm wondering, so I mean, y'all have had the point of getting y'all all the testimony was, well, one of the points was so that you could look at it.
Yeah, I mean, I'm not saying I haven't looked at it. I'm looking for and reading it.
Yeah, so I mean, if there is kind of a break in terms of subject matter as well, that'd be an easy thing to instruct on. But does anybody know the answer to that?
So
you do? Okay. What's the answer?
I misspoke yesterday, but there were video portions of Mr. Copeland's statements on early morning hours of January 11th, 2015, as well as January, I think it's 21, 2015, played for the jurors. They were small. They were like, quote unquote, real impeachment.
Right.
After that, though, after the motion to recuse was filed, is the wholesale playing of various recordings. So I don't think that it would be appropriate to say disregard everything. I have all my notes. And I have the transcript.
Okay.
But he did discuss things that you're talking about. He did discuss his relationship with Mr. Williams, his relationship with Donovan Thomas, with Mr. Kelvin Watts.
Right.
So
Yeah.
he was getting there.
Okay, but if it's all that sort of background relationship stuff, that's not the murder of Donovan Thomas. That's all the background. So what I'm trying to sort out is, had there been any testimony about the actual, here's the night of the murder stuff before the recusal motion?
So Judge, it's, when you say about it, in as much as it's relevant to the issue of the murder itself, that's the reason why I was asking the relationship between parties and all of those kind of issues.
That's not what I mean, and we can be clear about that. I mean, the night of the murder, the what happened, how the murder went down.
I think it's safe to say that as far as Mr. Copeland is concerned, the specifics of the night of the murder information or evidence was given post-recusal motion.
All right. Is there anybody that disagrees with that? All right. Thank you.
Specifics of the night.
Yeah, we need the Jeopardy music. And also, what do you guys think here? Marlena Mack said, Woody can help by testifying and putting on the record in front of the jury what was said in the meeting, what he knows about the car, what he said about Jeff on his Instagram. And I agree. I think Copeland, in his entirety, his entire existence, no matter what he does, could be a positive for the defense. And then also, has Woody followed the instructions for a sworn witness? I don't think they read it to him on the last day we still had court and he was there. But I mean, he's been all over social media, so I'll let the chat decide. Has Woody followed the instructions for a sworn witness? And honestly, has the state been cautious about him being a sworn witness while they did certain things? So thank you so much, Marlena. And then thank you for the keep it up sticker with the avocado. We're going until probably like 5:30 or 6 today, I think, because we don't have court tomorrow. So Whitaker's going to want to make sure she gets everything sorted out. But thank you for the super sticker. I also love this emoji request, buffering the vampire slayer from G-Lander. And then RC and Left Coast Mana have both become members. You guys know the drill. Now you have Mario Kart emojis. You got to choose your racer. See who wins in the chat. And FFS is imagining watching the cat live stream of the YSL trial in the year 2038 on witness 236.
And Your Honor, would the court consider the state's position that in characterizing any evidence in any way, it could imply to the jury that certain other evidence does not fall into that category? So in other words, any evidence of the night of the murder, I'm not certain how the court will be instructed.
I'm not either. That's what we're supposed to be tailoring today. That's what I wanted y'all to be giving lots of thought to. But yeah, no, I want to tailor it in such a way that I don't mislead the jury about anything. But y'all all agree that we have to tell them to disregard some of it. And I mean, yeah, maybe the cleanest thing to do is, XYZ date, but people don't normally think about their lives in, June 3rd. Okay. I know exactly what June 3rd had to do with, unless it happens to be their birthday or something like that. But so, yeah, I mean, I'll consider all of what you want to offer me, but okay.
Personally, I'm not speaking for, I went by my notes as well as a transcript. But my notes have more things, I guess, they were my notes. But I don't have anything specifically talking about the Donovan Thomas murder before Mr. Weinstein filed the motion to recuse. I do have like a January 11, 2015 interview by Detective Thorpe of Mr. Copeland.
Yeah.
Is admitted over objection, and it was played from 3:29:46 to 3:30:13. And I have to go back and remember what that was about, but I have little things like that, but I don't have any specific.
That's very helpful. And I knew there were a couple of small snippets of videos played. So if you've actually got the timestamp as to what parts were played, then it's easy enough to have somebody look at those snippets and see what it covered.
Can I announce now or?
Yeah.
So everyone can check. I have States Exhibit 378Y, as in Yankee, B as in Barry, 6, and these are the time slots, 6:46:34 to 6:46:44, and that's the January 28th, 2015 interview.
Okay.
And then I have the January 11, 2015 interview marked at States Exhibit 358A as in Elisa, and it's at the time I just said, which is 3:29:46 to 3:30:13. That's what I have. And then I have nothing else about specifically his interviews after the killing.
Okay, 3:29:46 to.
3:30:13.
Okay, thank you.
And that's at 358A as in Elisa.
All right, and I think that's our review had only revealed those two, anything from those two videos also. All right, anybody else have a different recollection about either more videos or the specific topic of the night of the murder having come up prior to the recusal motion? If so, please let me know. All right. Silence. All right, turning back to Mr. Steele's proposed instruction. You're saying that as to collecting their notes, they're going to be sealed for the record. Why not just destroyed? And I don't even know if your mic's working right now. We might need some more batteries, but.
I was given more batteries, but this should be working, I hope, anyway. I just, from doing death penalty cases, that we don't destroy anything, but we don't get to look at it. The court can look at the notes, I guess, but it goes under seal. That's how I've always been taught.
I mean, why would there be any relevance whatsoever, even on appeal, to what jurors might have written down about something we then take from them and tell them to disregard?
I understand. This is just how
Okay. I mean, if it were a death penalty case, I would do it that way, but.
I'd have to look at the law though, but.
Okay, well.
But I can't answer your question other than, yes, I understand at the end of the case.
All right.
No one gets their
Frankly,
notes.
I don't need to tell them what I'm doing with them anyway. So if I do seal them for the record, I'm not going to tell them that. If I'm going to destroy them, I might tell them that. But so if you want to give me a law on that, great. All right, now, one other thing that I propose to do, because we're telling them there's this chunk of testimony from a couple of days that y'all need to ignore entirely, disregard entirely, don't give it any consideration. What I propose to do in addition to instructing them on that is to then do some version of, and Ms. Pursfield found a case that was pretty recent where a court had done this when they were having to say, ignore all that evidence, disregard it. They actually kind of said, and if there is anybody who thinks they can't, let me know. And I would propose to do that whenever I give this instruction. So that if there are jurors who are like, no, man, I just cannot do that. Once I hear it, I can't unhear it. Then we can know that. We can excuse those jurors. And I mean, I guess if it's 8 jurors that say that, then we might have a mistrial, but better to go ahead and figure out from the outset, as far as I'm concerned, can you do that? Instead of just being left with, oh, they're presumed to do it. Okay, so thoughts on that? But it is an appellate court case. Ms. Pursfield, do you have the site for it? It looked like a pretty good idea to me.
Judge, that is Davis, Davis, the state, and that is at 307 Georgia, 746.
Shout out to Miss Percival.
I don't have a pinpoint, but I believe it's towards the.
Yeah, it's towards the end. It's either the last or the second to last topic that the appellate court addresses. And it even includes the instruction, and I may look at that and maybe borrow some from that as well. So y'all can take a look at it too. All right.
Do you guys want to do a poll, a mistrial poll?
And do y'all all agree that if Mr. Copeland decides on Monday he is not going to testify, that everything he's said so far gets disregarded?
No, Your Honor.
No, you do not?
No, Your Honor.
Okay. How, all right. I'd love to hear it, but I'm not sure how that's going to work unless everybody agrees to it, because nobody's going to get to cross-examine him. So if y'all all are like, yeah, every one of us wants everything he said recusal motion, super, stipulate to it. I don't have a problem with it, but otherwise tell me how that's going to work. Actually, does everybody want every bit of what he said pre-recusal motion?
Yes.
No. Okay. Then how do I let them consider anything that everybody doesn't agree to pre-recusal motion when nobody's going to get a chance to test him further?
So
One solution starts
Judge,
with an M.
There is the issue of what Mr. Copeland wants to do, what he decides to do.
I know.
He may later on, if, change his mind.
Sure.
And so I would just ask.
Shout
the
out to
court
Sentinel with
allow
5
us
gifts to the chat.
Think about what the court did.
Okay, y'all, I have been asking you for the last week and a half to think about it and to get together on it.
Specifically, if he chooses not to testify, because we were earlier, the court had said that regarding his decision not to testify, there were limitations as to what remedies existed.
Yeah.
And the court said that if we found case law to present it to the court. So
Okay.
I have been looking at that issue, and before I present the court a specific case, I want to make sure it's on point. But I'd like the ability to present that.
Here's the thing. It's Thursday. We are
You
not
should have
having
already
court
checked.
Friday or Saturday or Sunday. I'm bringing the jury back Monday. So
So understanding that, well, all that I'm saying is that even if the court brings the jury back Monday, and on Monday, Mr. Copeland chooses not to testify, Monday would be premature to tell the jury to disregard what he said, because he may change his mind on Tuesday, and then he comes in on Tuesday, and they have to now consider what the court has told them to do.
Undisregarded.
Right.
Yeah, well,
So I would ask that,
well, let me ask you this. Assuming that we have him in before we have the jury in and he says, I'm good to go, put me on the stand, which he will not say in that way, but we still at that point need to say, as to the 13th, 14th, whatever, disregard that, right? I mean, that's the time to say that, right? Yeah. Okay. So I hear you. It may be that he says one thing on Monday, which is throw me in jail. And then by Friday, he's like, I don't like jail. I want to come testify. Then, yes, they get to consider what he said on the 7th through the 12th or 10th or whenever it was, 12th, I guess. But I don't think we leave them hanging in the meantime.
in the same way that sometimes we have to break from a witness if the witness gets sick.
Yeah.
They get sick in the middle of state's direct. It would be not yet right to say disregard.
Okay. What does anybody on the defense side of the aisle think about that?
Oh, two things, Your Honor. First, I think Your Honor indicated that you want to make sure that jurors are able to follow the instructions. And so I don't know how we're going to be able to, without telling them to disregard, make sure that they're able to disregard the instructions. Secondly, if there's evidence that they're not supposed to be considering, I don't want them to be evaluating other people's testimonies further on in this trial while still considering something they're not supposed to be considering.
I think so too. I mean, it's not ideal, but it may not come to pass, but I think that at the point in time when it appears to us, if it appears to us that he's not going to testify, we need at that point in time to say, discard everything you heard from this witness. And then if he later says, you know what, get me out of here, I want to testify anyway, then is when we say, okay, I know I told you to disregard it before, but he's available again to testify. So here's what you can consider. The rest of it, we're picking up from wherever. I just think that's the best we can do. So.
I'm still looking at that issue. Just
Okay, well, I mean, that's fine if you come up with something.
I'm panicking, Your Honor.
All right. Okay, so have y'all yet gotten together on if he does not testify, what parts everybody agrees they want? Because there were clearly some parts that everybody wanted. Yeah. Or are you just, because y'all were all like, oh yeah, there's some good stuff in there. So if y'all all agree to it, fine. If you don't, also fine. Probably none. Sure.
Thank you, Miss Mandy, for the raid. Hey to everyone coming over from Miss Mandy Reacts channel. Everyone say hi in the chat. Happy to have you. And this is crazy. So the jurors have an out. You guys are thinking of, oh, wow, this is a big difference from yesterday's poll. So now 70%, well, now it says 69%, nice. 69% are saying mistrial now because of these new comments. 30% say no mistrial. And now this type of an out, if it's based on the jury, it wouldn't be because of prosecutorial misconduct, but it would still be a way to get a mistrial. We just saw in that March motion there were 15 jurors remaining. Did the juror that moved, were they relieved in April? So that means there might be 14. So there's either 2 or 3 alternates left. So if 2 or 3 raise their hand,
After consulting with all parties on the defense side, our position is that if Mr. Copeland elects not to testify, we're going to ask that all of his testimony be struck.
That's
I've
fine.
had the opportunity to cross-examine, obviously, and so that would be our
Okay.
position.
All right, thank you.
Yes, ma'am.
Okay. Okay, I think Mr. Steele, you were going to get me some case law on, what was it on? Something.
I assume it's the statute of limitations.
Yes.
I have a whole brief on this, Your Honor, but
Okay,
in the meantime, if the court wouldn't mind looking at State versus Conjo, it's C as in Colette, O, N as in nice, Z, O. It's 293, Georgia Appeal 72. It's a 2008 case. And they talk about,
okay.
it's in,
All right, I'll take
there's
a look at
also
that.
there's also a federal case that's on point, and I have to find it. I know it happened. It was a lawyer charged with money laundering. It's in God, it's in Maryland. The trial was a district court in Maryland, so it would be, and my mind's gone. What circuit would that be? I can't think of the
If it's in your brief and you can point me to
I
your
can.
brief, that works.
Can we just get that brief?
I'll send it to everybody.
Is this something new that has not yet been filed?
No.
Okay, yeah,
And I don't know if I filed it, but I argued it. So I have all the relevant cases.
okay, great.
And Your Honor, with respect to just the argument that Mr. Steele makes, as it relates to, as I understood his argument is that, broken down, that the jury should look at the dates of the acts that are alleged. And if they only find that the state has, one, proven beyond a reasonable doubt acts that have been alleged further than 5 years before the indictment, that the state has failed to meet its burden. The problem with that is that in a RICO conspiracy, overt acts do not have to be a crime, and they do not have to be racketeering activity. So proving the act beyond a reasonable doubt is not a thing, for lack
Not
of
the
a
right
better.
standard.
Right.
Not a thing. Okay, I'll take a look at the case law.
And second, Your Honor, that's breaking apart the whole of the RICO, and that's not the way that that's not the law.
Okay.
In fact, and I'll get the case, there's a specific case, I'll get it for the court.
All right.
It is the last date, the last overt act. So we have to prove that at least one, the existence of the enterprise, and at least one person committed one overt act. If that overt act, that last overt
Right,
act
is within the RICO statute of limitations.
Yes,
Yes.
that is what we're looking,
Which may be what the nuance of the case is that as you just described it, it would be true that if the only thing the state proved, let's assume that for whatever, I don't know if it was a federal or a state RICO, but let's call it a 5-year statute of limitations. And if they had only proven overt acts, all of which were before 5 years, then none of the overt acts would have fallen within the statute of limitations, and therefore they would not have proven their RICO charge. And that may be what that case stands for. I don't know. I'll read it. I think I followed you. I may not have summarized your argument well, but I think I understand what you were saying, and that may be what that case is saying. Okay.
77% would take the out.
What I'm going to propose at this point is that we recess for about an hour, at which time I would like for you to all put your heads into these proposed instructions and then come back with, something to work from that is whatever y'all want me to consider as to each of these things. And let's try to finalize what I'm going to say on Monday. Okay. So we'll break till, let's break till 3:30, which is an hour and 10 minutes.
Oh, they're taking a long recess here, you guys.
Yeah.
Oops, Steele.
Yeah, sure.
We've raised this a lot of times. It's been overruled.
Okay.
But I just want you to, because it's going to come up, God forbid there's an appeal. I don't want the court to feel like we sandbagged you.
Okay. I don't want to feel like that either.
So I'm giving a copy of the case, if I may approach.
You may. Thank you.
Your Honor, on the copy that I've given, and it's United States versus Vendetti, VANDETTI 63, that's wrong, 623 F second 1144. It is the Sixth Circuit 1980, and the copy I've given this honorable court and the state, it's on pages 3 through 4. And then there's another case that I have copies, I have to find them though. It's State versus Thomas, which is THOMAS. And it's 364 Georgia Appeal 148. It's in Division 2. It's 874 Southeast 2D 195. That's 2022. And that's citing to a case that we've all cited a lot. State versus Jefferson, JEFFERSON, 302 Georgia, 435, 807 Southeast 2D, 387, 2017. The Jefferson case and State versus Thomas deal with a guilty plea of a non-testifying co-indictee in a conspiracy gang case. The United States versus Vendetti case deals with a jury verdict on a co-indictee who did not testify. The reason I bring this up to you is it won't have any effect on Mr. Sledge because he's testifying, but the state has successfully over objection brought in, I'm just remembering Mr. Winfrey, but I'm confident they're going to try to get in Mr. Johnson's client, I can't remember, Eppinger, EPPINGER, et cetera. And I just believe that that's a confrontation clause violation.
All right. And where in, you said pages 3 and 4?
Yes, it's in division on page 3 on the right-hand side.
Okay.
And it starts at the very first full paragraph to determine whether the testimony.
All right.
That's in the Vendetti case.
Thank you.
No, thank you. And it's a lot of it. They summarize, they've in the Sixth Circuit summarized on page 4, specifically the first full paragraph on the left-hand side.
Okay. Thanks.
No, thank you. I just wanted to use the time.
All right.
Thank you.
So, Your Honor, we have three instructions. Would the court mind just laying them out so that everyone is clear?
So I think the most challenging one is going to be any sort of a 105-ish limiting instruction on how they are supposed to consider evidence as to the RICO count versus as to the substantive count of the indictment that might be an overt act alleged in furtherance of the conspiracy, which I assume, like, for instance, a few of these defendants, but not all of them, are charged with the Donovan Thomas murder. I assume the Donovan Thomas murder is an overt act in the RICO count. An instruction that clarifies for the jury that when they're considering all of the evidence on the Donovan Thomas murder, it is okay to consider that against all of the defendants, because they're all charged with RICO, when considering whether the state has established guilt, their guilt on count one, each individual defendant's guilt on count one. It is not, however, something that they need to be thinking about when they're deciding, okay, who's guilty of this murder? Mr. Williams is not charged, for instance. So they shouldn't be thinking, is Mr. Williams guilty of this murder that he's not charged with as a murder conviction? And I'm not necessarily explaining it well. That's why I'm asking y'all to come up with it.
So would the court, within this, and I know that I think this is what the court is asking is, but within the context of that type of instruction, would it not be necessary to have or to give to the jury the elements, like we would need to go through the elements of the charge to say how, when you say consider, like how they are to follow that instruction without being given the elements of each charge, how will they know how to?
So I don't know if maybe the way to, or the place to look at it to begin with is where in the pattern jury instructions, there's a pattern instruction about, sometimes things are considered for limited purposes or against some defendants and not others. But I'd like for us to get more specific than that, because if that's all I say, that is really not helpful, because I haven't said, and so here's what you do consider it for as to this person or that person or this count or that count. So work on that. And then, what I'm saying about how we handle Kenneth Copeland stuff. And I'll go ahead and look at these two snippets now that I've got timestamps and see, and y'all can do that as well if you want to make sure that you agree. But that's what I want y'all to be working on. Okay. All right, so we're in recess till 3:30.
Okay, so we have a lengthy break. We will read the joint motion that the defense filed for the jury instructions that Judge Whitaker said, look, if 8 jurors say, all right, I can't disregard or unhear what I heard, I would, let those jurors be excused, and then we would have a mistrial because we wouldn't have enough jurors. Now, a lot of people in the chat over the last really 2 weeks, but some people even predicting it as soon as the ex parte meeting came to light, that when the jury comes back, it's going to come down to the jury. So very interesting, chat away about your thoughts on that. A lot to talk about there. I do want to, again, shout out, Sentinel had gifted 5 memberships, and right around the same time had sent a super chat saying, there is the out. We did a poll. 77% of people that participated in the poll said they would take the out. they would be gone, which we only have 14, maybe 15 jurors left. That would get us below 12 if 77% of them say, I can't unhear what I heard. So thank you so much, Sentinel, for your support. Kathleen Bryant became a member. Thank you so much. G-Lander had said, and this is while we were looking at the March 19th motion by Diamante Kendrick's attorneys, that it's unfair to the victims' families to have such a long trial go on this long. You know, you don't have closure. A lot of families come into the courtroom and you know, it's an active part of their lives while the trial is ongoing. So imagine, as a family member, this goes on for 2, 3, 4, 5 years. Like, definitely a strain on the victims' families as well. Especially if it ends up in a result that doesn't tell us much of anything. So thank you so much, G-Lander. And then we got some from Negringo here. Says, coffee, great channel, excellent coverage. Appreciate that. You know, I get thirsty on these chats. Left Coast Mana says, Judge is just building the mistrial by letting Love dig that hole deeper and deeper. Do you some of Love's rambling or buffering, however we're referring to it now, I think, oh, did Law & Crime, there we go. I think she's a little unnerved by hearing the judge herself say, you know, the juror attrition, if we lose jurors, because they can't unhear stuff with Kenneth Copeland. I think that's got Love rattled. And it's something that, you know, at least a mistrial on that grounds would kind of cover her butt a little bit, because it wouldn't be a mistrial on the grounds of prosecutorial misconduct, but it would still be a mistrial, and that's not great for her. Now, the other thing is the defense has also said, if Kenneth Copeland chooses not to testify at all, we want to, you know, get rid of everything from June 7th. All of it. Anything that Kenneth Copeland has gotten us, we want to get rid of all of it. And I think that's very strategic, especially today, for the defense to say that. We know Brian Steele wanted some stuff to come in because it was exculpatory, but it's a bigger ask to ask the jury to disregard everything Copeland has testified to or done on the stand than it is to say, you know, disregard everything after the 12th, though that like one long video. It's a bigger ask, and it would be a greater chance that more jurors could say, I can't forget that Kenneth Copeland exists in this trial, rather than I could probably forget that last video because I wasn't paying attention anyway. So very strategic, in my opinion, on the defense to come together and agree we would be willing to strike all of it if Kenneth Copeland decides not to testify. So lots of layers going on there, lots of moving pieces. Thank you so much, Left Coast Mana. Jimmy Fingus says, Love clearly has not listened to Woody's DA diss track. I don't recall. That would be too funny. Don't give him ideas. He might actually do it. Thank you so much, Jimmy. Mrs. R, you had come in right at the time we were talking about this jury instruction and what to do with Kenneth Copeland. So you said, oh my God, Kat in chat, I had missed all day and have missed everything. What major did I miss? Evidentiary rulings, state wants to change the order of the witnesses they're calling, of course. Bruce Harvey wanted to introduce the 105 limiting instructions on, he's calling it count 1 of the act, and Judge Whitaker is kind of hearing him out, but wants him to be more specific in terms that a layperson on the jury could understand. So explain to them RICO rather than just calling it count 1, and give us another written proposition for proposed jury instructions. For limiting instructions on the consideration of the evidence as a whole versus as it relates to a specific defendant or defendants and specific counts. And then recently these jury instructions, as we just summarized a few minutes ago. So you did come in right at the right time for, I think, maybe the most interesting part of the day. Thank you so much, and happy you're here now. Dito says, Love is scared she'll get thrown off the case, and did get a bit of a lashing by the judge yesterday. She needs to take a back seat. I absolutely think this morning was way more productive, and then this afternoon has been a lot more arguments from Love, except that moment where she said, I'm going to defer to Atkins here to make one argument. We got a break from Love for that one small bit of time. But other than that, like, this afternoon has mostly been her arguing, and it's just not, it's not sticking, it's landing. Sometimes she's making arguments that nobody was countering her on. So I agree with you. I do think she's scared she'll get thrown off the case, but I do think she just has a general over prioritization on what people think of her, or if people think that she's wrong about something or that she's not right about something. So scared of being thrown off might be a part of it, but I think she's just caught up in having a knee-jerk reaction to the possibility of being wrong. So I agree. Taking the back seat seems like a much better strategy. Marb, the producer, says, Miss Love sounds like a 3-year-old explaining what they did wrong. Every time she talks, it makes me want to run into a wall. No. Oh. Okay, guys, do we need to do a 60-second all caps vent? I'm not going to put it on the screen, but go ahead. You guys have 60 seconds to type in all caps anything you need to vent about. I think it might be time, because we don't want people running into walls. Get it out of your system. Princess Waku says, this is a cop-out for the state. Pathetic. Yeah, could be. I think it's a cop-out for sure. I have a problem. One of my biggest issues today with the state was Judge Whitaker said, hey, regarding Bruce Harvey's limiting instruction, we're not going to give this every time the state wants to impeach a witness and wants to introduce evidence to impeach somebody. But maybe we'll give it right when they come back. It might not be that weird to suddenly give them this instruction mid-trial because I'm also new to them. So if I just tell them a bunch of stuff all at once, it'll fit more naturally and not just seem kind of random. So we tell them now, then we can give them the limiting instruction again at the end before deliberations. And Love got up and started arguing against her as if she was willing to let this limiting instruction go in all the time. But I think almost, I feel like every day I feel like certain things are a cop-out for the state. And when I say that, I don't just mean the DA, also the investigators, the police. The things that we've heard, like, I don't have the reports anymore. You know, the approach of trying to make a case against somebody in a way that would fail a victim who deserves justice, and in a way that would fail a defendant who might not be the one that committed the crime, who may be innocent. I think we've seen these cop-outs all along of, I don't have the thing that I was supposed to do my homework on. I'm late. I still didn't do that thing. Oh, I only did it partially. So, thank you so much, Princess. And Kedrick says, she's not keeping her word, Kat. It's starting to be more and more recesses. Yeah, and it's just like, I kind of see that there's things that need to be reviewed, case law, whatever the case may be. She wants to look at the things that were filed to them before, you know, just discussing it and not knowing what she's talking about. But this is the day before she wants the jurors to come back. So she's taking these long recesses today. We haven't gotten through, unless I missed it, we kind of suddenly segued. Did we finish Sledge's statements? I feel like she wanted to segue and address something just before she didn't address it. And then it piled into 3 or 4 new lines of conversation. We come back with a jury on Monday. We have these recesses. Are we going to get these things done? So, yeah, I don't know. She's got to get it together. Otherwise, what if they have to push back Monday from being the day the jury comes back? So thank you so much, Kedrick. And then SJK811 became a member. Thanks so much. You have Mario Kart emojis now. And I had also gotten CashApp. So Juanita Hamilton, thank you so much, said $5 for I love your channel with the cool face. Appreciate that. I actually got that early this morning, but I always forget to check CashApp. Sorry. Marcy Mitchell sent $20 for the Thug trial. Great reporting with the sunshine emoji. So thank you so much, Marcy, if you're watching right now. And then we have one from Satin Blades, and I'm not sure if you're still in the chat. I feel like you might be Cash Money Cass. For the $15 said, I'd love to sketch this trial live. So, oh, and it says signed, Cash Money Cass. So I saw the name and thought so. If you are still in here, Cass, I tried to tag your name earlier in the chat through YouTube, and I didn't see your name pop up. But if you want to do some live sketching, that would be awesome. I can send you the StreamYard link and you can sketch away. That'd be really, really cool. So thank you for the super chat, but also love the idea. But who would you draw? Would you draw Love? We need the back of Love's head with her arm extended or Atkins' arm extended. That'd be super, super cool. And do you guys think that the judge changed after lunch yesterday? A lot of people commented that live yesterday. I saw a few comments mentioning the same thing. Like, it seems like Judge Whitaker, we had this lunch break, and then we come back and the demeanor has shifted a little bit. So, oh, and for our chat rules, hold on, I gotta click the invite link. You know, sometimes that messes up. All right, it didn't freeze. So this link in the chat, and I don't know if you meant now, but I can drop the link if you want another time, whenever you would be ready. But just in case now, if you want to, there is a StreamYard link, Cash Money Cast. And then while we figure that out, so disparaging comments, yeah, we gotta, what do we consider disparaging? We've all been clowning Miss Love, Glanville, etc. Yeah, I think if we were doing these things in the courtroom, we would have been sanctioned the way that we talk in here sometimes. Even though we do try to follow, you know, the mods do a great job laying out, you know, don't signal to YouTube that we're crass and not following terms and conditions in here. Appreciate you all and the mods for holding it down. But yeah, if we said some of these even mild things like, Your Honor, the prosecutors are speaking in word salad. We don't like them. They're annoying. They're rambling on. They're buffering. I don't think it would fly. I don't think it would go over too well. And then do you think with the judge revisiting the jury instruction for the disparaging comments, with her reconsidering that language, she said it is in fact on the record. Do you think that change is coming about because she went and looked at something she didn't have the context to before? Is she becoming more aware of the things that she said, hey, that's not bad enough, or we're moving forward from this issue, we're moving on? Do you think she's looking at this context and going, oh, dang, wow, didn't know that that's actually as true as the defense said it was? Because she's giving hints that she's going back and looking at the record, different transcripts. And that might not mean she'll make a different decision than most of us yesterday were thinking, no mistrial, this is moving forward. Her looking back at the record might not mean she's going to suddenly want to declare a mistrial. But it might change where she leans, especially with those two outstanding motions, with Max Shart, constitutional fair trial, with a remedy possibly being mistrial with prejudice, and then Doug Weinstein. He had filed a supplement to his motion for a mistrial. So she's still got a rule on those. And then Miss AB, thank you so much. Good to see you. Miss AB says, not forgetting about the unfortunate deaths of the people mentioned. This trial was poorly put together. There is no way juror members can erase all that they saw and heard. The judge gave many outs to the state. It's over. Yeah, that's actually a great point. So people forgetting about the stuff that's been mentioned, right? That's finally a chance for the jurors. And I'm going to move this because it's blocking. That's finally a chance for the jurors to have their way out. But when you compare it to the number of outs or the things that the state has gotten a pass on, should we be critical of the jurors having that out? Should we be critical if Whitaker says, all right, 8 of you say you can't forget Woody, so since 8 of you are excused, we don't have enough jurors to continue? So this, you know, by necessity, it's got to be a mistrial. And unfortunately, I think maybe the state could benefit from that, because they could come back and put their case together a little bit better. They could, not would. They could. But yeah, I appreciate you, as always, Miss AB. Great food for thought there. And then All For Sure also became a member. Thank you so much. And then exactly, Miss AB again, thanks for another super chat. No trial is ever perfect. And I think that was actually some great stuff. We got to look at that March 19th motion filed by Diamante Kendrick's attorneys, where they mentioned that lawyers, and in their writing, it was prosecuting attorneys, But lawyers can get caught up in this idea that if they miss one piece of evidence, that's why they lost a case. And then when they lose one case, they try to correct in reverse to the extreme where now they insist they have to bring everything in. They can't miss anything at all. So just pile it in there. And that's not strategic. It's not a perfect way to present your case. So you're right. No case is ever perfect. No trial is ever perfect. But maybe a mistrial for manifest necessity of not having enough jurors where there would be a retrial unless there's arguments against that. And I'm sure there will be. But if there is a retrial on those grounds, it could be an opportunity for the state to clean it up, get it together, and stop worrying about missing something by just not presenting every single sentence they've ever read in this case file. Don Dada says, let's get Judge Judy. Looney Boy 221133 says, if she doesn't grant the mistrial, she's definitely now onto the conduct of the prosecution. They will stumble into a mistrial moving forward. And there's like a couple ways it can happen, right? The jury, maybe one of the witnesses says something crazy. It's a little bit unpredictable what could happen moving forward. And it doesn't mean that those things that could also be another reason for a mistrial will become a mistrial granted. But definitely, the state needs to use more caution, I think, moving forward. No, but if there was a mistrial, the right to a speedy trial, the clock would reset. So speedy trial would become a right again of the defendants while waiting for the new trial to start. So you would have speedy trial issues on the table. It would be, they have more than 30 days to restart the case. But can you imagine if the state was given 30 days to restart their case, what they would show up with on day one? I see some Judge Simpson love in the chat. Shout out to Judge Simpson. The Adventures of Chloe and Daisy say Judge Simpson wouldn't allow any of the prosecution shenanigans. And let's take a look. Let's look at these proposed jury instructions. Joseph Papp had shared them. That's a link if you want to pull up, and it's one page. It's just going to be one page. And it came through at 1:28 p.m., but it's a joint motion, so all the defense counsel agreed on this. They said, all right, we're down. We agree. We're on the same page. So Jeffrey Williams and the rest of us, by and through their undersigned counsel, hereby files this joint motion for jury instruction in the above referenced case. In support of this motion, this is so funny. It says, Mr. Williams et al. Show as follows. Mr. Williams is innocent of all charges. They didn't add the rest in here. They just say Mr. Williams. Brian Steele. So Mr. Williams is innocent of all charges in the above referenced indictment. Mr. Williams respectfully requests this honorable court provides the following instruction upon the return of the jurors to the court for trial. Ladies and gentlemen, you are hereby instructed to separate and give to the court for sealing, for the record, any and all of your notes that were taken on the afternoon of Wednesday, June 12th, 2024, at or around 3:30 p.m. and beyond. This would include when you were last here on Monday, June 17th, 2024. Also, you must erase from your mind any matter that occurred from the afternoon of Wednesday, June 12th, 2024, at or around 3:30 p.m. until you were excused from the last time you were in court on Monday, June 17th, 2024. This includes any motions, testimony, rulings by the former court, statements of the former court, questions and answers by witnesses, and the like. And they're giving two case law here, which is interesting that they're putting case law in the instruction to the jurors. But I don't know, is that unusual? Or is that normal? I need an assist. So C. Propst v. Morgan and Mayor v. Alderman of Savannah versus Batson and Cook Company. So we all respectfully request a hearing on this motion, and we got to hear some oral arguments so far. This is where Judge Whitaker said, hey, if 8 jurors decide they can't erase everything. Oh wait, court is over. Hold on, Kayla, what do you mean court is over? They're not coming back? That judge wanted the jury back on Monday. Next week, jury's coming back. Let's see, I'm looking for an update from Kayla here. Oh, is court over? No, they're on another recess. The judge has to keep calling these recesses today. And it's not quite a short break, you guys. They said till 3:30, so it's an hour-long recess. We had a long recess this morning before lunch. Mostly because she's trying to look at filings. So sorry, I read your question as a statement, but now I see it's a question. I would have been like, there's no way Judge Whitaker is happy if she has to close up court for the day because there's too much to deal with. She wants these jurors to come in on Monday. And then Nancy New says, they rushed to indict everyone before having the evidence and didn't consider anyone choosing the right to a speedy trial. Yeah, I agree. And can you imagine if, like, right to a speedy trial, there's going to be bond arguments. I wonder if they would try to issue different pleas, new pleas. And maybe their pleas would involve terms that would change testimony, change the strategy of their case. It's just a lot. And Miss AB says, changing judges was the best thing that could have happened for this trial. It's usually pathetic that it had to happen. It's actually pathetic that it had to happen to begin with. Yeah. I agree. I mean, it'd be interesting if the jurors came back and it was still Judge Glanville. At least when they're coming back, they can kind of say, like, maybe we're not going to be told why, but something happened. Like, the judge has changed. So that's a big deal. We could kind of understand why a judge change would mean we're gone for 2 months. Yeah. My bad, Gwennon. But thank you so much, Nancy New, and to Miss AB. And I don't see any, other filings or anything like that. But I know they're trying to figure out cleaning up these instructions that they've got to give the jurors. So, let's see. I don't know if anyone wants to come up. Anyone wants to share their thoughts? We can do a little panel until we come back at 3:30. Nope, we still have the 2 outstanding mistrial motions here, PETA, from Weinstein and from Bruce Harvey. Not Bruce Harvey, Max Shart. So we've got those 2 outstanding mistrial motions. One is really a motion for a fair and constitutional trial with a mistrial as remedy. And then I think there's only 2 or 3 alternate jurors left. I know they were only 15 as of March 19th. I feel like we lost one in April. So that would mean 14 at this point. So 2 alternate jurors. So, but yeah, if anybody wants to come up, same rules on screen as in the chat. Keep it clean. Don't get me like booted from YouTube. And we're only going to do this until court comes back. So if anyone wants to pop in and share their thoughts. Really on anything. Like, what do you think of this judge? What do you think about the jury? What do you think about Kenneth Copeland and if he's going to come testify or not? And OG Cappy, thanks for the super chat. If the mistrial happens, will Thug get a bond? So it's not an immediate or a gray or a black and white yes or no. If there's a mistrial, he has a change in circumstance where he could renew his motion for bond. So there you go. And Star, you're a familiar face. Let's get Star up here. So Star, you are here with us. Hello.
Hey, Kat. Thanks.
Good to see you over here. I see you on, I think maybe Miss Sylvia's channel. But good to see you here.
Oh, yeah. No, thank you for allowing me to come up. I just had a few things. The first one, I'm just wondering, is there any law around jurors and the length of time that they have to be on a case? I was trying to look myself. I couldn't find a definite answer, but I was just wondering
Do you mean like a minimum time?
Yeah,
or a limiting maximum.
Or a maximum in this case.
So I think, were you on the stream when we looked back at the March 19th motion earlier today, where it was really just talking about the length of trials and how a juror can't possibly concentrate for a long trial. It didn't give an explicit, delineating, here's the numerical time frame, right? 2.5 years is too much, but 2 years and 4 months would be fine. but it did say at some point it becomes impossible. And a lot of that was due not to a delay like this, which is probably an extreme circumstance, but due to the state wanting to present all these cumulative witnesses, all these kind of wasteful
Things,
you
yeah.
know, yeah, the same person testifying to the exact same fact that we've already heard and wanting to call 700 witnesses, even parsed down to 400. There's still going to be issues of cumulative testimony, stuff like that. So
Yeah,
that was some case law in Supreme Court, quotes from the Supreme Court.
because
So
I was wondering, like, just you know, as an example, just say you're a woman that has been a part of this jury for how long this has taken. I don't know. I'm trying to think of something. I'm going through like IVF. I say, you know, this is stressing me out. You know, it has caused me to not be able to go through this process, whatever the case may be. Like, as a juror, do you have the right to like seek counsel to say, hey, I can't be on this case for this length of time due to X, Y, and Z?
yep, and I think the difference there, rather than a case law that's just about a like absolute time period, is you have it as change in circumstance, right? So you can come and present that and say, look, I'm having a hardship. I can't keep seating this jury. So that would be why. And I can imagine, can you imagine? I can imagine being stressed out as a juror that's getting paid $25 a day,
Yeah.
not knowing when I can return to my regular job or get a new job if I don't have one currently.
Right.
Of course, like
What
my
if you do
intestines would be stressed
DoorDash?
out.
What if you did like DoorDash or Uber or something? I don't know, just like jobs that would require for you to have to be available to, you know, sufficiently be able to make a living. Like, I don't know, it's just ridiculous at this point. But I think with her kind of making that ruling about, you know, if the jurors come back and say that they cannot unremember everything, that I don't like that ruling.
77% of the chat said they wouldn't be able to unhear.
I wouldn't be able to unhear either, but it kind of puts them in a place to, I feel like, okay, it's a mistrial, but then they're able to come back.
Another retrial.
Yeah, and I just think that that's crazy. And then with the defendant still have to sit while all of that is happening.
Yeah, and I believe the state's going to absolutely say they plan to retry. I have Black Butterfly and Heart of Inspiration here. Let's do a 4-person panel. Bring them up. I think those are all familiar names. Right, let's see. Let me make this I don't know how to, does this make it 4? There we go. So, hello to Heart of Inspiration. Hey, Black Butterfly, and Star, you're still on here, just so you know.
Hello, how are you?
Thank
Good.
you.
Heart of Inspiration, you want to give us your thought first?
This is a whole hot mess. Like, I'm so torn. I understand why Judge Whitaker doesn't necessarily want to just do mistrial. I think probably A, it's because these jurors have been sitting so long. B, she still does technically report to Glanville. I mean, I know she came down on the side of, you know, like holding prosecutors accountable. And I think that that's amazing. I'm glad to see her doing that as like coming down on that side as a jurist. But I just don't see at this point how this trial gets fixed. Like, it can't, especially by her saying, okay, wait, they made disparaging comments about, like, she's I think finally getting it. She's finally like, wait a minute, wait. Like, after hearing and seeing enough of this stuff, I don't see how this, and if I'm a juror, I can't unhear. What else do I need to unhear now? You know, now
you
my
have to
mind's
unhear
gonna
the
be
most
like,
exciting witness.
yeah, he was like the most fun. So why am I gonna just forget him? You know, and also I'll be honest with you, I don't think, not that the jury doesn't take their role seriously in what they're doing. I think it's just absolutely insane to expect that these people have not heard anything about all of this in 2 months.
Exactly. Not to cut you off, but I was thinking of something. Like, let's just say you're not watching TV, you're not on YouTube, whatever. But if you just go to your local gas station to get gas, paying gas, boom, the local newspaper is right there. And this has been all in the news. You can't cover your eyes and say, I didn't see the I don't know, the Daily Post. For me, it would be the Detroit Free Press. I'm pretty sure there's like an Atlanta newspaper. You're just paying for gas, and then the newspaper is right there. You're gonna see it.
You're gonna see it. I mean, we've had how many cookouts have we had since then? The family's talking about it at the cookout. Let's not think that the family don't know that you're sitting on this jury. Like, come on now. It's gonna happen. It's going to happen. And I don't know if I'm this, but then does this then with Judge Whitaker, does she then say, I'm going to dismiss this with prejudice due to prosecutorial misconduct, because we would not be in this situation had we not gotten the ex parte? Had that whole thing not happened, amongst other things, but we'll just go there, we would not be in this position. This is crazy to me. I've never seen anything like this.
And on national TV or national YouTube, whatever we want to call it.
Yeah. Actually, thank God it's happening that way.
And then Black Butterfly, what do you think?
Well, I just wanted to I want to go back to Woody. And I don't know if everybody remembers, but I remember when Steele said, I'm going to ask him. So I'm one that feels like, I don't know if if everybody else noticed, but before Woody came on, she said that she was, one of the things that she wanted to know is, was he coerced? So when he got up there, she never asked him that. So, but Brian, before all of this happened, and Woody, like, was it like a week ago, whatever, he said he's going to ask him. So when he asked Woody about that ex parte, because it's from the way Brian made it seem like it's fair game. I think that there's going to be a change in events when that part goes on. So I am waiting for Brian to cross-examine Woody for if for nothing else but for that. And I think that's going to be a game changer. The other thing I wanted to say was that I feel like she did go back and listen, and she found the best of all evils to change her position, because I think that they also listened to the court of public opinion, and it didn't look all that good yesterday. So I think she just found the best of all evils and said, okay, I'm going to give him this. I mean, it's still a win for the defense, but I really think that like it wasn't a good look yesterday. And then all of a sudden today she comes back and changes her mind. And that could just simply, I should say that is simply my opinion. I'm glad that it happened, but I don't know if it came from the heart, or was it just like, okay, let me find something, because yesterday wasn't a good look. I don't know.
I think she got the most heat yesterday compared to other days. Like, I think yesterday was when I saw the most commentary, like trying to watch the chat and just summarize everything is, all right, this is it. She's keeping the trial moving forward. She's going to find a way to excuse the stuff that happened. There's clearly not going to be a mistrial, even though, the sentiment, she's not going to call it, even though I think there should be a mistrial. And that, I saw that the most yesterday. So I think you might be onto something. And public confidence is a piece of the puzzle, right? You need to have public confidence in the system.
And remember when what is that lady's name? The one who decided to remove him. She didn't admit that he did anything wrong. She just said the appearance. So they're looking at how things appear. So I think that okay, they are looking at how the public is viewing, not just the judge, but that whole judicial system, across the board, from Fani to the DAs to the judges. It's not a good look across, internationally and nationally. It's just not looking good. And they know that it's like all eyes on them. So I really think she just took the best of all the evils and just chose that one. I'm glad they got it, but I don't know, if that was really something that, I think they just did it for the look. But
Like a
Kat, I do need
neutral
to
middle
ask
of the
you.
ground. Yeah.
I don't want to keep running my mouth because I know I'm not the only one here. And I know we only got but so much time. But do you remember them having a discussion about the coercion and that they were going to ask Woody, and she never asked him?
No, and I think that might be because she was trying to divert away from Kenneth Copeland sitting there and saying, the state told me not to do two things.
What I'm
She didn't
trying
want
to
to
say.
acknowledge that second part. So I think she forgot the plot because she was like, oh, what? I didn't hear
I'm
that thing
sorry.
you said.
hmm
So I
And
think she tried to re-steer the ship there.
she re-steered the ship. So my thing is, and then it would have taken this whole thing to a whole nother level. And she wants to try this case. And I think that they took that break and everything else. I think that she just made a conscious decision not to ask that question. But I swear to you, because I even rewatched, I've watched that part 3 times. One of them it's fresh in my brain because I watched it this morning before everything else, everybody else started, showing. And I rewatched that, and I rewatched Kayla. And can I say one more thing? Everybody was bashing Kayla. When I rewatched Kayla, she did not do I think it was that more the anticipation. So if you watched it the first, just while it was going on, you had a higher anticipation. But when you watch it, just rewatching it, she did a very good job, in my opinion. She stuck to what she came there for. So that was another thing. And that's it. I'm gonna shut my mouth. And thank you for
Well, I
having me.
appreciate you. I appreciate you a ton in the chat too. Great insights always. And
All right,
positive
thank you.
masculinity. We've got you in here,
Hey,
positive masculinity. What's going on?
hey, g'day. Is my mic okay?
Yeah, we can hear you.
Sweet. Yeah, what Black Butterfly said about Kayla, yeah, I watched The Lead Attorney where he rewatched everything. And the second time round, yeah, she was right. That Kayla was a really good witness. So she wasn't as bad as we were all out on her.
I think Kayla got the ball rolling on some things that maybe people didn't take her seriously when she said them on the stand, but once the defense did better on redirect questioning in that moment than they did when with direct when Weinstein was asking the questions. I think once we heard certain things get said, the defense had better questions to come back and ask. And then of course the state's witness that followed the rest of the day kind of substantiated everything that Kayla was trying to tell us, that some people were, she's not spitting it out. She's not saying it clear enough. She's not saying it flat out. But I do think she was ultimately extremely, extremely helpful to the defense, especially for Woody to take the stand the next day and say the exact same thing everybody was waiting to hear.
Yeah, Kayla, she was in a really hard place because she's got all the obligations to her short-time client, and then she has to tell the truth, and then she doesn't have to divulge too much. And then she's got her reputation, like all the lawyers in the land are watching this, and she says the wrong thing, that could be the end of her career. So it was stressful for anybody to be on the stand, but for a lawyer, and then for it to be live, yeah, that's the sort of stress I don't think any of us could understand.
Yeah, you're right on it. I know Heart of Inspiration has a channel, Positive Masculinity and Star and Black Butterfly. Do you guys have a YouTube channel?
I don't.
I have one that I made up a long time ago with a friend of mine. We never launched it. But you know what? I feel like, but I feel like I don't have enough time in my schedule to dedicate, to make it, to make a difference where, I would get the views. I wouldn't be able to do it enough because I'm too busy. But I'm glad you asked me that because I wanted to give you a hats off on your show. It's a lot of people that they show the trial, but it's not as much interaction as your show. Even with Law and Crime, you can go in and interact with people in the chat, but actually have a host that actually, play by play, gets everything going. You get us pumped up and motivated. And I really, really, I'm hooked now to watching the trial on your channel.
Well, thank you so much. I really try to bring that in from what I like in other chats. Like anything I try to do here is something I like and enjoy as an audience member somewhere else. That's really so sweet of you to say.
She's knowledgeable. That's a key part, like actually knowing what you're talking about.
And you guys are reminding me.
And you're credible, and you know what you're talking about. Thank you, Star. I'm glad you completed that part too. Yes, true.
I wanted to say earlier, they mentioned that, well, unless it's an Alford plea, and I never got a break, they were speaking, but guys, an Alford plea is when you plea out, but you don't actually concede to guilt. So that was a long definition from like 2.5, 3
Yeah.
hours ago now, and I was
That's
waiting
great.
for a moment and I missed it, but
That's
I wanted to clarify that term.
I wanted to add one more thing about Judge Whitaker that I noticed from the very beginning. She, if I remember correctly, and you guys can correct me if I'm wrong, I do believe she did a stint in the appellate court. And I noticed, because I watch a lot of like Supreme Court, or listen to, because you can't watch it because it's federal, but I listen to a lot of Supreme Court cases and other like district appellate court cases. And I noted where there's a panel of judges, right? And so I noticed a lot of the questions, how she was phrasing it, how she would like give them case law and then ask them to either rebut or is this what you're thinking, was a lot like an appellate court judge would do. So part of me still holds out hope that she's just trying to see how much of this case and how it's been tried up until this point, like how much would be appellate court fodder should she let it go forward? And what would an appellate court say? I'm hoping that that's what she's thinking and that she kind of is grasping this thing's going to get overturned. And is it fair if I know kind of in the back of my mind, this is going to get overturned for some really good legal reasons? Do I just cut bait at this point and say,
Yeah,
you
or
guys
let
did
it go for
not
2
do what
more
you needed to
years.
do? So
That's a
what I'm
great
kind
point.
of wondering.
Put a 1 in the chat if you think this is Whitaker is thinking with an appeal brain, appeal minded. And a 2 if you think she's just wanting to keep this trial going. It has nothing to do with the way she's thinking about it. She's just determined to keep it going. So we'll see what the chat thinks.
Can I get my vote? I think that she's doing everything. She knows it's gonna. I think that she's doing everything based on with her appeal eye, and I believe that she's just letting the state um sink themselves. She's giving them a chance because she wants to be in my opinion, I didn't like anything yet about yesterday, but I have not changed my opinion about her being a fair judge. I didn't like yesterday at all. But is she fair? I think she's fair. I think she's fair. I think and she's transparent. Um and my thing is that I don't think anyone would be able to stop those statements from those guys. And as bad as we don't like it and we don't like what they had to say, I don't think that it was any way possible that she could say, okay, no, don't bring it in. We didn't like it. We didn't like it, but I don't think that it was anything against the law for her to bring it in. I really don't. Um, and I think that she is gonna, I think that she's giving them a chance to sink themselves after she's made a statement, her final ruling as far as, this is gonna be it. But guess what's gonna happen? Because she said that, l- I don't know if it's my best is on Love, right? But it could be any of them. But somebody's gonna slip up because if you notice, they are, and I will reiterate this, I've been saying, I think I told Miss Sylvia the same thing when she was on. They are so ill prepared. And what happens when you're not prepared is you open yourself up for so many mistakes. And trust me, they are going to make more mistakes, and it's nothing that they're going to be able to do in order to stop this mistrial. We may not get it now, but we're going to get it because their behaviors, they're not changing their behaviors. Look what she told Love. She still didn't come back today with all of what she was supposed to have from even earlier this week, from yesterday, from this, from that. Because Love is I think she cannot, she herself can't handle this load of a case because she's just not dedicated enough. I don't know what she does when she get off from work, but it's not this. You could tell. She doesn't even have the most easy things. Did she ever give, and let me ask you this too. I got a mouthful, but did she ever give her the list? Remember when she said itemize each and everything?
She
Has that
apparently
come
sent
out
it
yet?
after lunch. I thought she sent it after lunch, but I know
But
she said it
remember,
wasn't complete yesterday.
right,
And
she told
it
her
could
last
still be
week.
incomplete. It could still be incomplete right now.
She told her last week she told her to have that last week.
And
And
she
she
was
still
told to
doesn't
have
have
it
it.
in April.
I'm trying to tell you, I don't know what she does when she gets off from work, but this trial is not it. This lady does not have anything she's asked for. She's ill prepared, or even she's ill prepared or she's overwhelmed. One of the two, I don't know, but she's going to mess up. Mark my words. She's going
Yeah,
to
I
mess up.
agree. If whatever pass Whitaker wants to give right now and say we're moving forward, that there's not going to be a shortage of the state messing up once again.
No, and I think it's just granted it is a matter of time. It's so much of a waste of time though. Like I would already be incredibly mad if I was on the jury. But I'm going to be even more ticked off. I don't know. Like I can't even, this is just beyond my comprehension what's happening at this point. But I would have thought that she would have already called a mistrial by now, unless she just really, really needs to dig in and make sure that, unless she wanted to be sure that she had all the facts or as many facts as she could get. I think she honestly thought she could fix this thing. And I saw in the chat some calls for immediate review. Doesn't and a call for an immediate review or leave to do that have to be after she rules on? So she hasn't ruled on the mistrial motions yet. So doesn't it have to be after that they then can request immediate review? So we're not even at that point right now.
But the thing about it is, wouldn't it be? Oh, sorry, Kat.
No, go ahead.
I was going to say, but is it possible that what she has enough to mistrial without prejudice versus with prejudice? So what is the point of doing it without repeating all this stuff all over again and having those guys sit who knows how long? Instead, she
has
probably
nothing to do with right now. We saw what happened with Judge, what was it, Summers out in New Mexico with the Rust trial. Like, she has more than enough at this point with all of the shady crap that's happened. She can dismiss this with prejudice.
Okay.
She has more than enough. It might feel, but I don't know.
Okay, I'll take that.
I'm thinking no judge wants to announce a mistrial, especially with this. I think it stains them. I think that the jurors will give her the out. I think she's playing with a lot of cards and playing a lot of hands, and that's going to be her first thing. I'll get on the stand today so that she can't totally f it up, and then jurors will give her the out. She can wash her hands.
Yeah, but
who in there? Is that Shaheen?
I think that'll leave it with, typically when that happens and it's a mistrial without prejudice and the state can bring it back. I just feel like these men have been incarcerated for forever. There's other defendants or indictees that have been incarcerated, even that are still awaiting. They don't even have, representation or anything like that. So I just feel like these guys are spending, regardless of what you think of whether or not they're guilty or not guilty, in the eyes of the law, they're innocent until proven guilty. And from what we've seen thus far, they don't have beyond a reasonable doubt for any of this garbage. Like, this is insane. This is insane to me. But anyway, they don't have beyond reasonable doubt. So if you do it because of a jury issue and you decide to do it without prejudice at that point because of a jury issue, now we're still sitting here. They're still sitting in jail. This is insane. I don't know.
Do you guys think that
I think that's the easy out.
Yeah. Do you guys think that she is really just, because I remember, and I'm not sure if it's on record, but remember when she said that she was seeking like additional counsel regarding emotions? I think maybe she's basing it specifically on whoever that judge is. And I'm not sure if they have to have that on record of who she's seeking counsel from, but I would be curious to know which judge that is.
Yeah, I agree.
I believe the jury, truthfully, not the jury, but the judge has been putting it off, especially with Bruce Weinstein motion until the jury come back, because the jury is really what's going to matter, and they have to poll that jury on what they know. And to me, the judge is waiting to see what the jury say and do, far as what they say they heard or haven't heard, seen and haven't seen, and that would give her a chance to be mistrial, and then the jury will be responsible, and it won't be nothing in her hands or prosecutor hands or nothing like that. That's what I'm thinking she's waiting on.
That could be true. Yolanda, good to see you. I always catch your commentary somewhere else, but it's great to have you up here. We also grabbed Money Cass up here, who does something I can't do. I'm not very good at drawing.
Awesome.
Hello.
Hello. And I don't know if Money Cass, if you have
I don't know if
thoughts
you can hear
on.
me, but...
Yeah, we got you.
Okay, good. I'm gonna start. I do this in my city.
That's cool. I love courtroom sketch artist work. So this is so cool. And I know, like, we'll clear the commentary panel when the court starts back up, but if you want to hang up here and keep sketching, you are totally welcome to. That'll be awesome.
Love it.
So, and thank you so much. I saw that we had Black Butterfly drop off. Miss AB had sent a super chat showing some love to you. Thank you, Miss AB.
Yes.
And then I pulled it up, but would you guys want to spend your like going through another Christmas with this case going on, and then maybe another Christmas? Like, it's just such a big ask.
I said the other day, everybody should already start picking names and doing Christmas gifts in the chat, because basically we done been a family right now. So everybody just draw one name and that's who you buy a Christmas gift for. But hopefully, again, if the jury come back this coming week, and basically if the judge see that, I know it's got to be at least 3 jurors that's going to be like, look, I done had enough. They don't do the Jennifer Lopez. I had enough of this, judge. Can I go? And hopefully that'd be enough for her to be like, you cannot hold them hostage. Like, if they want to go, they should be able to go.
Actually, you can hold them hostage. They have to have a
yeah,
real reason.
you can.
Like,
But it wouldn't be fair to the people, because they're not going to be sitting there paying attention. When you get jurors like that, to me, it messes up the whole case no matter what. They're not paying attention. They don't want to be there, and they're not going to give you good input.
I understand, but legally they've already been picked for jury duty. Legally, then they're seated sworn jurors. So at this point, unless they've seen stuff, heard stuff, whatever, or in this case, they don't feel they can forget and erase from their brain what Woody said, that I feel like those are the only reasons they're going to be allowed to be excused.
Well, they're excused then, because who can forget Woody? Nobody.
That's it.
This is impossible.
I think it's
Nobody's
going to
forget Woody. Nobody.
I think it's going to be the one juror. Do y'all remember the one who was always vocal about the money with Glanville? Like, I think it was a he, but he would always be like, hey, can you check on our pay? What's going on with our pay? I think that's going to be the juror that's not with it.
I think he done got some friends along the way, because again, it's hard. I'm in North Carolina. You can go to the beauty shop, the barber shop, you go get your nails done. This trial is being talked about. So do we think that them jurors are not going out in the public at all? They're just in the house and not doing anything, not talking to family. That's hard for them to do for the last 2 months. You don't think they're in question on what's going on? Why are we not in court?
I'm in North Carolina too. Where you at?
Child, I was born and raised Fayetteville. I'm a truck driver. I done been all over the world. Atlanta is the worst traffic other than New York. But yeah, I'm in North Carolina. Where you at?
I'm in Greensboro.
Oh, cool. You're not far at all. But yes, this is crazy with the jury to me, because I've been on a jury before, and I know for a fact it was like the worst. I felt, again, like a hostage. It wasn't that long. And eventually he pleaded out, because they end up stopping the trial and he ended up taking a plea. But the whole time and it was a murder trial, looking at pictures, looking at stuff like that, is just like, you don't get them images out your head. That's why, how are we going to get Woody from sitting up there, falling asleep, telling Miss Hilton she's staying. They're not gonna forget none of that stuff.
I don't even know
That's
if it
true.
matters because someone could just say
The other
it.
way I
Someone
was
could say
looking
that's
at
the
it is
excuse. Sorry, go ahead.
I was on, that'd be asking.
Oh, if I was the juror, you don't even need to necessarily truthfully mean that you can disregard something that you've heard. You could just say that you can't if you're looking to get out of there. Like you truly, truly have an out because a reasonable person might not be able to disregard it. So if you say I can't disregard it, how do you question that person for saying that?
I'm trying to disregard love green fingernails right now. I'm sorry, y'all, but those have been just listen. And I know, Kat, you got on the lumberjack today, but yours looked like lumberjack. You hear what I said? She looked like Christmas tree. So it's a lot you can't regard when it comes to her, period.
I tried. I have 2 red flannel shirts. The one is like more muted. It doesn't have the white stripes. I was like, this one looks more like what Love was wearing yesterday. I gotta wear that one.
Yeah, love is like when it come to dressing, I'm like, oh Lord, either when them pants come up to her ankles. And the guy that yesterday, he said she had ashy ankles. I like to fell out. I was like, Lord, you can see her ankles. Did anybody knows that lady ankles? Because I was not paying her ankles no
I
attention.
really don't pay that woman that much attention with them.
But she do wear flooded pants though. She wear ankle pants a lot. So I think it's her height.
Right, it's her height, but technically those are like there's a certain height for a dress pant. Like when I was in corporate America and stuff, there's a certain height for a dress pant. Like you can either get it like higher up over your ankle when you get them tailored, or get them a little bit lower if you want them to cover the back of your heel. So like literally, but sometimes taller women don't do it that way. They prefer to have it a little bit.
Well, she got a high jacked up behind, so I think that got a lot. Because every time Kat be like, "Lord, she's in the screen again," I like to follow. She don't mind putting her butt in the screen. She don't mind doing that. Yeah, she don't mind doing that. She'll bend over in a minute, Lord.
I got a question, Kat, if you don't mind, for the panel.
Yeah, go ahead.
Everything aside, right? Just think of if this was like a family member of yours that had been, unalive. Would you guys want Love to be the DA presiding over the case? Like, take away everything aside.
Absolutely
You
not.
are reminding me about that
thank you.
phrase. The unalive. People ate Kayla up with love and with hate. It went both ways about using the word unalive. And I was watching The Lawyer yesterday, his dad, Big George. He was like, I think unaliving is becoming part of just vernacular. The younger generation is using that term in everyday language. Not just because they're up on screen, on YouTube themselves, trying to avoid YouTube flagging it because you're talking about certain things, but unaliving is just becoming regular usage. So I thought it was interesting to hear, Big George, I don't know how old he is, but he used to be a prosecutor, has his own practice now. And he's actually saying like, no, the younger generation's actually just using this word regularly now. Unalive.
Yeah.
And I just heard you use the word.
Yeah, because when you think about it, the other word is really, really harsh, right? Like
it's very hard. It is.
And I
It's
think
very
that's
hard.
just a way to unalive and just makes
it.
I don't know, a little better. But interesting to hear you guys' take on that. As far as her, like if it was your family member.
Oh, most definitely. We would not want her as the DA because the flaw in the case comes from her being mischievous, devious. She's very undermining. She's very manipulative. What she's doing is, again, when she say, we're going to switch witnesses, and she still haven't gave over anything from the other witness, then you're going to get a new witness, and then you still don't give over nothing for that witness. Like, we'll be on the third witness, and you still getting time. You're buying time, but she's trying to do it in such a way that it's looking like she's like, okay, we didn't know. You knew the whole time because all this stuff should have been given over already. Let's go back to the other day when she said that she was waiting for the warrant to be issued and he was already in jail. You told a lie. You're waiting on a warrant to issue for someone that's already locked up. But you knew you didn't have that affidavit.
Yeah, did she ever
she didn't
submit
have it? No, she still haven't submitted it. No. And she
Well,
got more time. Didn't they give her to Friday again to have everything? Another
Friday
Friday?
at noon. This Friday at noon, she's supposed to have everything submitted. We should probably take bets and see uh who thinks that she's going to actually have it by noon, or is it going to take till 5 p.m. because, whatever.
She submits stuff late at night. That's what she do. And it's always late on the state and she
Well,
gets away with it.
I'm hoping, who knows? I think Whitaker is getting fed up with all of this. Like, at this point, you've had 19 months and you still don't have everything ready. Like, in what universe does that happen? But I also
Imagine
think
another boss anywhere else. Like, nope, you gotta go. I'm not paying your
They
salary
wouldn't
anymore.
stand
But this
for
is
it.
the
They wouldn't
public
stand
paying
for
you.
it. Exactly. And Fonnie is her, like, that's her protege. So you got to know she's going to get leeway on anything. And you notice how she keep blaming her team. You are the team leader. So whatever they go wrong, you go wrong. I feel like that.
Well, and I think this was a great question. Would you want Love prosecuting, in general? But Dante, like, great timing for this. Dante says justice for Donovan Thomas. Don't lose sight of that. What if you were Donovan Thomas's family member and Love was handling your case? And you
True.
see on YouTube, the public's like, the state still doesn't actually know who may have been the real killer, the real unaliver
They
of
have
Donovan
no
Thomas.
idea. They have no idea who killed him at all. They want to go with what Woody was saying in them interviews. And I believe Woody would say Cat did it just to get out of the interrogation room. You know what I'm saying? So we cannot go by him. And whenever Hilton was adamant about you can't say you killed Nut, or that's when you don't know if he did or didn't. He didn't throw
And I
too many
want to see
accusations like he could have.
I want to see the evidence they say for sure that they know it wasn't him. Because if it's just cell location data and Woody said that he doesn't bring his phone places, how much confidence can we have in that? So I thank you, Dante, because, that's the flip side. We don't often, especially you look at the AI chat. I doubt the AI chat for YouTube today has said, we're talking about how victims are denied justice.
Yeah,
We
and
still
that was
don't
kind of my
know.
point. Mm-hmm.
And I think, yeah, that was a great, great question for this exact reason.
I don't think anyone, certainly we're not discounting that or forgetting that. Of course, we want that to happen, but we want it to be actual justice, right? We don't want, I don't think any of us want a wrongfully accused person to sit in prison for that. And I also think if the state honestly cared about justice for him, then they would actually be prosecuting the people that they actually think committed that crime. They're
Yeah, like a
wrapping
lot
all of
of
this stuff
plea
up.
deals, immunity.
Yeah, they're wrapping this all up into a huge RICO case that they are clearly not prepared to prosecute. And they're just saying, oh, because you said this, that, and the third. I'm not saying that rat beefs don't become real beefs. I mean, we've seen that clearly. I'm not saying that doesn't happen. I'm of the Tupac Biggie, like I'm that old. So, I remember firsthand when that was happening, right? So I'm not saying that can't occur. However, Fonnie ran on this platform of I'm going to clear the street and rid the street of, gang issues, and then what does she do? Instead of like going after, in my estimation, this is my feeling. I don't live there. This is my feeling though. Instead of going after real gang issues that is being committed, she goes after a high profile person, a high profile rapper, to put a feather in her cap. It's more grandstanding than it is actually cleaning up the streets.
I
That's
totally
how I
agree.
feel
She has
about
an
it.
agenda. She definitely had an agenda by charging them and doing this RICO. It definitely was to me, again, when it comes to the trial itself, you have such poor witnesses. You have 100 and some witnesses, and so far, neither one of your witnesses have helped you. They only hurt your case. So I don't understand, Love. I would not want to see Woody if I were her.
Yeah, I agree. I mean, I also think they're hinging their case on potentially 3 witnesses now that might not cooperate, We do have movement in the court. Heart of Inspiration, I know you have a channel. Yolanda, do you have a channel? Because I'll share your guys' links if you have a channel. Because we're going to keep Cass up here doing the sketching. But if you guys have channels, I want to drop them.
I'll mute my, so you don't hear scritching.
Sweet. Let me put the screen back on.
Thanks.
And the sound in the courtroom is not back on yet, so.
I'm doing.
Kat, I dropped
Mistrial.
you something in the private chat, by the way.
Okay. Okay, yeah, I'll have you on X. I'll message you on X.
Sounds good. Thank you.
Thank you so much. This was another great comment earlier too. The Rush trial was dismissed 4 days after one Brady violation. So in comparison, we're stretching this on and on and on when it's clear that you don't need to keep trying to say, oh, we shouldn't call a mistrial quite yet, because it can be done much sooner. Davis, thank you for the super chat. I don't think we wish this on anybody. Love just made breaking news. She might as well start an OnlyFans. This chat. I love you guys. Can the feds come in if there's a mistrial with prejudice? I think they would need a reason to look at something specifically.
I have just received about 2 minutes ago, the state's, no, that's, the state's proposed instructions, 105 instruction, and then an instruction in the event that Mr. Copeland decides. Oh, sorry. I know, I have to tell myself to talk into the microphone. Sorry about that. Okay, so a few minutes ago, I received, and I assume y'all all did as well, yes, the state's proposed instruction on 105, and then a proposed instruction in the event that Mr. Copeland does not grace us with his testimony beginning Monday. So I'm just looking at those right now, and those look pretty good to me. I don't know if y'all have had a chance to look at them or not. I don't know if y'all have come up with your own instructions for us to ponder, but this is the only new one I've gotten so far. I think y'all were all hard at work until you just came in on something as well. So if y'all want to forward what you have, that would be great.
Your Honor,
Yes.
regarding the jury instructions, I think Miss Westmoreland is working on typing one up,
Okay.
but I'm just going to say it is very lengthy and also it addresses a lot of, it's going to be very lengthy. I'll just put it like that. Because we feel that it needs to address every alleged overt act and who it would not apply to.
Okay, well.
So we could possibly come up with, we could possibly come up with a general charge, but then it
Okay.
would have to be repeated for every overt act for every individual who is not charged substantively with that overt act.
Okay.
Is that fair?
Why don't you give me the really detailed one and then also a more general one. And it may be that even if we don't use the really detailed one now, we use it, at the end of the trial when we're giving them all the instructions. But I'll take a look at both of them. And I know we are going to need to sort of give each other a chance to look at what's been cross-proposed and then make edit, come up with something else, and then actually figure it out, which, maybe can happen in the next hour and a half or 2 hours, maybe can't. But this is finally a good start. So, do you need a little bit more time before you send whatever you're going to propose? Okay.
To do it right.
Like 30 minutes? Like how long?
To do it general.
I think Miss Westmoreland's on the hot mic.
I think that we definitely can do this. And I think that that it deserves, attention. And as you mentioned earlier, that we need to be specific so that the jury understands what we're trying to, what you're going to convey to them. With that being said, I think that it's going to take longer than an hour.
Okay, so I guess I'd rather have it late and good than not at all. But I am having a really hard time understanding from not necessarily everybody, but not simply one person or one side either, why when I say kind of A, over and over again, and B, with a week or more's notice, I would like for y'all to be working on this and provide it to me. Why lots of this is still not provided in a timely manner. And y'all don't have to give me an answer, but I would like for y'all to stop doing that, okay? Because we are in the middle of this trial, as y'all all well know. And, one of the complaints made by the defense is, man, the jury's been out so long, they're not even going to have any idea what we said before. And the longer we take on everything, the longer the jury stays out. And I'm having the jury back on Monday at this point. And it should not have been a surprise that we were going to talk about this today. And y'all should have already had whatever you wanted to propose ready and in final form. So let's please try to be more timely with the tasks at hand. Okay. Okay.
Oops.
All right. So I think maybe we'll all be here really early on Monday I'm going to give y'all all orders so you can get in early, and we're going to be here starting at I may need to find out from the deputies how early we can have our defendants here and ready to go. I mean, I was thinking 8 a.m. and I know that means an early day for everybody, but
it's not that bad.
Since we can't spend 3:30 to 5 talking about this, what can we do? What's the earliest we can do? Can we do 8 a.m.? All right. We're going to be here at 8 a.m. on Monday. And we're going to, finish, and y'all work together over the weekend, over Friday and the weekend, to the extent you can, to narrow down any disagreements or discrepancies and bring to me only what still needs to be hashed out Monday morning. Okay. Yes, ma'am.
Judge, I just want to make sure, so as our position, is that some of the instructions would be better given at a different time than Monday? Is it a certainty that the court is definitely going to give it at that time? Or is the court open to hearing any, law or any?
It's not a certainty, but it's a probability. And yeah, if you've got law, I'll consider it, but you don't have to wait till Monday morning to send it to me either. But it is a probability. Okay. Yes.
Your Honor, do you want objections to the state's proposal or just the re-proposal so you can then evaluate it? A separate proposal in writing.
Right now, I don't think necessarily want objections. What I'd like is for y'all to try to work together on something.
Okay.
I mean, if you think there's some entirely incorrect legal concept, but I'd really rather y'all try to get together on it first.
I do object to it, but I think that makes sense because I could do all of the objections.
Okay. All right. Thank you. Okay, so given that we are not able to sort out jury instructions right now, and I think we have dealt with all of the evidence that we think might be, objectionable that we need to hash out beforehand with regard to Sledge now. Is that right?
I believe so.
Okay.
Okay, so they did finish that.
I saw some inquiries over the time that you wrote regarding a couple of exhibits, maybe that were.
Yeah, and I don't know if those were objections as much as they were just, we need to sort this out,
Right.
so.
So certainly we would not be entering the same piece of evidence under two different numbers.
Yeah.
We just wanted to make sure that we got.
Yeah, no, I mean, so yeah, just take a look at that and. Yeah. Okay, so yeah, I don't think that was an objection. That was just kind of an observation. All right, so then who's our next witness that we can get through evidence on? Do our motions in limine on.
Do you think they have a witness that they'd even be ready on? And good point, DJ Fridays. So DJ Friday said that once you become a Street Gang member,
Miss Love,
you're no longer a victim.
Now given to defense counsel the detailed list, right? But have you given that to the court? Didn't you give them something?
I shared with them the bucket of physical exhibits for Sledge and a list from yesterday. And I'm about to send over another bucket for another witness. So as opposed.
Good.
To be able to give all of the exhibits themselves.
Mm-hmm.
That's what.
So are you then not just, so I understand, are you re-providing the actual exhibits?
That's what I had.
Okay. I mean, that's fine. Fine with me. What I want to have happen though is, have you now only done that for Sledge and you're about to do it for one other?
The actual exhibits?
Yeah.
Yeah, because Sledge was the next.
Right. Okay. So what happened to the tranche of the first 30 witnesses?
So I was working on her.
Okay, they were due yesterday.
So that's what
That's what I've been She really hadn't said much.
I haven't said much. Yes, I.
She was speechless for a minute.
Oh my God, they called out the buffer.
And now she says that's what I've been working on.
No.
Okay, so, and maybe you're confused about what it is that I want produced. If you have got if all you're using, for example, with Thomas Burnett is demonstrative pictures of the infinity, and they have all the demonstrative pictures of the infinity, and demonstrative pictures of the infinity serve, XYZ date as, item number 73B, that's fine. I don't expect you, unless it's easier for you, to reproduce those things. I do want you to identify it specifically enough that they can go, oh, here are the 10 pictures she's going to use. And I hope you don't have 10 pictures because that would be excessive with this one infinity representative. So does that help a little bit? But I do want it to actually have happened for 30 witnesses at this point in time, because we can't.
So
the way to operate this trial is not witness by witness at this stage of the game. Okay, so do you need clarification beyond that?
No, no, Your Honor.
Okay.
I have all of the exhibits in folders.
Okay.
So what I was doing was trying to extract the specific ones. So for the 30 witnesses, we have the exhibits in 30 folders.
Okay.
And what I had done was label them and extract relevant ones and send them over.
Okay.
And so I won't do that. I'll just go through the folders and put it in a table, because I was actually going to do that for the ones that are listed. I was actually sending the list yesterday. Mr. Atkins sent it for me just to say, hey, here's what we're sending you. But
okay, whatever is easiest. And I mean, if it's easier to have them each give you a thumb drive, that's fine too. I mean, logistically speaking, I just want them to know with some degree of specificity, here is the actual evidence they are going to be using with this witness, not social media. But
I understand.
what social media? Okay. But they should have been served at this point in time with everything you intend to use with every witness.
they have.
Okay.
And understanding the court's instruction about making sure about anything that the court told me to give to them by noon. So both of those.
Okay.
I understand. And yes.
Okay. And so when can they expect the next 27 or 28 witnesses info about which exhibits?
So I'm just gonna upload.
Okay.
Because it'll be probably quicker to upload them to a Dropbox link than it would be to sit and, or maybe we can have some team members. typing in some uploading, so.
Okay. And can you share it with the court as well, just so I can have it as well? Okay.
And know that you sent it.
So
Lola, I agree. Stop giving her an
by
out,
the end of the
Judge.
day?
As in an hour and.
I mean, I figure you're gonna work past 5.
I have.
So what I kind of mean is by midnight. Okay. All right. And then is everybody, okay.
Lola, you are on
So are we
point.
ready to work on another witness's chunk of evidence that we think might be subject to motions in limine?
And then Cass, do you sell your drawings? FFS is asking.
Give me a minute just to get my list.
Okay.
If you have a link, put it in the private chat and I can share it.
Your Honor,
Yes.
may I bring up another potential issue?
Yes.
So it's my understanding and belief that that there may be some outstanding Brady material regarding Antonio Sledge.
Okay.
Brady to include impeachment.
Okay.
My understanding and belief is that the state may have met with Mr. Sledge and he may have said some things that would fall under Brady in a prior meeting with the state. I'm not asserting that as fact,
Okay.
but I am inquiring about that. If
All right,
there was
can
a
you-
prior meeting with Mr. Sledge
Okay. So,
at a coffee shop.
all right, was there?
He is, Mr. Shart is correct. I was at the meeting and an investigator, Lancico was at the meeting. There was nothing that I took to, I'm going over in my head everything he said.
Okay.
Didn't say anything. I don't know what part of that
Okay,
meeting.
so,
Mr.
do you two want to huddle together and maybe Mr. Shark can share with you what he thinks got said and then you can confirm or?
Yes, would the court give us a moment just to step outside now, or do you?
Sure, or you can.
I don't know what was said.
Okay.
I don't know specifically what was said.
So do you have any reason to believe Brady material or impeachment material was shared then? Or you're just saying they had a meeting and so there may be Brady material that stemmed from it?
It's a reasonable question either way.
My understanding is that there may be Brady material.
That stemmed from it, but you don't know what it was.
If I knew what the Brady material was,
Okay.
then I wouldn't have an issue.
Well, since there, Mr.
Cassidy, was there a typo? I
Sledge's
tried it, didn't
attorney
work.
was present at the meeting. So, if Mr. Shart has spoken with him, or I don't know where the idea that there was Brady material, there's no privilege. So Mr. Sledge's attorney is a ready source of everything discussed at the meeting.
All right, maybe would Mr. Shart, would you be willing to share privately with somebody on the defense? Do you have the same issue with talking to Miss Love that Mr. Steele does?
I don't.
Okay. Would you have an issue with sharing with her maybe the source of your information? And if you do, that's fine, but.
I prefer not to.
Okay. All right. She seems a little in the dark on what might be, I mean, I don't know.
Not the source, just if he would, just the content. I don't know what he's talking about.
I don't think he does either. Apparently he got some tip that Sledge may have provided Brady material and that's about all you know. Is that right?
If there is anything inconsistent with what Mr. Sledge has signed in his plea agreements or anything or said before, that would be
That would be
considered
impeachment and therefore Brady. Yes. So you have reason to believe that he may have said something at the coffee shop inconsistent with something he already said.
I'm asking.
Can you be more detailed with regard to which thing it might be inconsistent
I
to, or you just don't know?
I don't know.
Okay.
And that's why I'm asking.
Okay.
There were four people in the meeting. If anyone's recollection of those set of events are different than mine, I'd like to know what they are, because mine is not that he said something inconsistent. And as I said, the people who were there are me, Mr. Sledge, Lieutenant Lancico, and Mr. Sledge's attorney throughout the entire time there. So.
All right. Well, it's really the relevant issue is not who was there. The relevant issue is, did Mr. Sledge say something inconsistent at the coffee shop with whatever he has told the state or law enforcement previously? I guess any of those 4 people could sort that out, the best two would be, well, the best one would be you if you were the prosecutor there, because I mean, I don't know what else to say. Maybe there's nothing, but maybe if you've got notes, or you and your investigator get back together and think it through and try to figure out whether he said anything that's inconsistent. And I mean, that's, I don't know what else to do.
As I know. So we will search our collective memory.
Okay.
And if you, I am really interested in speaking with Mr. Sharp about what he is talking about, so that I can understand where.
All right,
So
I'm not
I
sure he knows.
Different. So, somebody has said the word Brady or something, and I don't.
Somebody said Brady and I went into panic mode.
I will talk. We will.
Okay.
search our collective-
Something inconsistent.
Did anybody take notes? I mean, we had 4 people there. Nobody took notes. Nobody recorded.
I don't know
it.
that we know that. I don't know.
No, I'm asking. We're entitled to it if that's what happened.
Well,
So the
if it,
answer is,
hang on. Mr. Harvey, talk to me. Don't talk across to opposing
I am
counsel.
not. I am just somewhat astounded that we had 4 people meet at a coffee shop and nobody took note number 1. Nobody,
Mr. Harvey, no one
nobody
has made that
recorded it.
assertion.
Nobody recorded it. I'm asking if there was a report, if there were notes taken, if there was a recording, we would
Okay.
have something to review to determine whether or not there was something that should be provided to us.
Okay.
Okay?
I don't know whether that happened or not.
I would, if I had I did not record our meeting, our conversation, because I would have turned that over. I did not.
And that's
record
why
our
we didn't
conversation.
record it.
Okay.
It was literally a conversation.
Right.
And that's it.
Okay.
Sorry, I missed it. I understand then that not a single person took any notes of that meeting.
So I don't know if Ms. Love can speak to what Mr. Sledge or Mr. Sledge's attorney may or may not have done.
I'm asking from the state. It's the state's obligation to provide it to us. We don't have to go out and talk. to
I
anybody.
understand.
All right. So I'm just inquiring as to whether there are any notes, and I'm just surprised. Well, I would like an answer as to whether or not any notes
Notes were taken.
Thank you.
2 things. I did not take notes. I talked. Lieutenant Lancico, as she sat there, she looked around and listened and looked around our surroundings. We were not within Fulton County.
Okay. So no notes?
No.
All right. No notes.
I would not, well, there are no notes. I did not take notes. She did not.
Okay.
My notes are not something, my investigator's notes would be something to which either the defendants would be entitled. My notes would not.
Because they're attorney work product.
Yes.
However, if there's something Brady in your notes, then as you know, you need to provide it. And if there's something Brady that you hear, then you need to reduce it to writing and provide it. We talked about this before, you know that.
Yes.
And so you are maintaining that, no, you didn't take any notes. No, your team didn't take any notes. As far as you can think right now, nothing Brady impeaching was said. You will give it some further thought along with your
His attorney.
Sure.
Make sure that I
Okay.
check his memory was
All
mine.
right, that's all we can do at this point. Thank you for raising it so that they can think about it some more.
I wonder
Yes,
who the
sir.
other people present were.
You asked the state, pursuant to my request, whether there was any Brady whatsoever from any fashion, not only impeachment evidence, but exculpatory evidence. And the state said, let me think about it. This, I believe it was yesterday.
Right.
And I'm presuming by the silence, there's nothing.
All right, so I think I gave y'all, remember I told you to huddle with your team, and not just on Brady, but on anything that is discovery that you intend or think you intend to use that they might not yet have. And I think I gave y'all until Friday to finish that huddle and get that answer back. So, yes, so I think they're still huddling on that. And by 5 p.m. on Friday, if there is anything, please detail it in at least an email, in writing some way that you send to the defense and to the court.
Thank you, Your Honor.
All right. All right. Any other issues before we get to the next witness that we might have evidentiary things to sort out on?
And thank you, Chloe Albert's Revenge, with the new name, Judge Kick the Can.
Okay. Okay, who's the next witness now that we should turn to?
Miss AB says, just keep digging. That hole is so deep. Geez.
To sort through their evidence. So we've done Sledge and Zachary. Then also on that list, coming up after them is Detective Thorpe with the Kendrick interviews. Have y'all already hashed that out?
So so Your Honor, I'm glad, thank you for reminding me. So with respect to the Kendrick interviews, we needed to bring to the court's attention, I don't expect to be playing them or getting into them by next Friday, but we had.
Okay. Okay, that's fine. But remember, we're not doing this week by week anymore. We're doing as much as we can possibly get through beforehand. All right, but anyway, okay, go ahead.
We had previously, Mr. Weinstein, Mr. Kendrick had filed a motion to suppress his statement. And the Honorable Judge Glanville heard arguments from Mr. Weinstein.
But didn't decide it?
He decided it as to the portion of it beyond a break in the interview.
Okay, and that part got suppressed?
So that part got
All right.
suppressed. But as to the portion before, I believe that there needs to be a Jackson Deno hearing unless there's no argument about it, because he did not suppress the part before. My witness was here, but he was permitted to put him on a stand. So,
okay, so a part after some break was suppressed. Was an argument made that the entirety of it was should have been suppressed?
no, I think that, no. Mr.
Okay.
Weinstein argued that just.
Okay, well then it seems like there's not anything pending. Is that correct, Mr. Howell?
Sure, I am jumping into this.
I know, so am I.
I will need to check with Mr. Weinstein. I should have an answer.
Okay, all right. All right, so we think that whatever wasn't suppressed is legitimate to be presented, and so there shouldn't be other issues as to his statement or statements. Is that right? Is it more than one interviews?
There's more than one part of it, but no,
There's only one interview, and obviously you're only using the unsuppressed part. Okay, so, and that'll be Miss Detective Thorpe's testimony at that point in time.
Cassie Experience said she left and came back, and it was a Bob Ross class for Cassie. Cassie's IG link, I'm dropping it in the chat right now. Go over there, make sure you give a follow.
Speak up a little bit, because I'm sure they're gonna say they can't hear you.
There is a second one.
Okay.
And so the argument may be, hey, we needn't reach that second one because in the first one, this break occurred and everything beyond that point should be suppressed. I would have a different argument, but we have not even looked, we got to one interview.
Okay. And you would like to use the second interview?
Yes.
Okay.
We would object.
Y'all, this is just, was there a deadline for filing challenges like motions to suppress?
How can there be a deadline for a motion to suppress when evidence isn't turned in on time?
Okay, I'm gonna need that motion. If there's a motion to suppress the second interview, I'm gonna need that ASAP, and not just this interview should be suppressed. You tell me why. You tell me the legal basis. You tell me the facts that back it up. Give me a specific motion to suppress, a particularized motion to suppress.
One of the opinion that the original order covered everything past.
All right. Anybody be able to point me quickly to date of original order?
It was March the 4th.
Okay, thank you.
Of this year.
All right. Yes.
Let's go with March 18th.
All right.
And I just emailed you.
Thank you.
And the point.
All right, so I'll take a look and see what that seems to say.
What do you guys think here? She Dun says, thank you for the super chat. Does anyone think the state has proven
All right,
Jeffrey
the next
Williams is the
thing
leader
would
of
be,
YSL?
or the next witness would be Mr. Bean with text messages.
So we,
Or just that YSL is a
Judge,
music label?
I think since we talked about Mr. Zachary's interviews, I think that Mr. Bean won't be the next one. Mr. Zachary would be before Mr. Bean. And there are social media postings. I don't think that there is going to be any kind of an issue, but just I can name them or send them, share them.
Well, if you'll share them with the defense, then the defense can see whether they've got objection. Does the defense think at this point that they have objection to Mr. Bean's text messages or social media? I assume y'all know what she means by that.
Judge, I don't, so unless something in particular happens to allow us to introduce it, the state is not going to, I don't anticipate using those text messages of Mr. Bean.
Okay. All right. Can you send me that whenever you get it?
Your Honor?
Yeah.
May I add to that? Just to be fair, those text messages, my opinion, come from a phone that was seized on July 15, 2015 from Mr. Williams' home. It's been suppressed and all derivative evidence.
Okay.
So, and I'm assuming that's why the state said that, but if it is going to be used at all, I think we need just to alert the court that we'll need a hearing on it.
That's why you don't intend to use it.
Right, and that's why I said unless something specific happens, unless there's a door, anything, I don't know, but we don't intend to use that in our case in chief. I don't know. I don't foresee a circumstance, that occurs.
Yeah, I don't foresee a circumstance where that would be permissible either. All right.
If an attempt were made to make an argument that is directly refuted by something that was suppressed, I might ask the court, hey, Your Honor, this argument was made. This is not true. We have a reason to believe it's not true. Here's why we think that. Would the court consider X or Y or Z as a curative?
I mean, if you want to provide me some really specific case law that says I can do that, sure, but I wouldn't waste your time on that right now. Okay, so Bean will probably just be some social media postings. So, I mean, if I had the more detailed list, I could.
I don't, right now, it would be testimony.
Okay.
It would just.
All right. I'm just trying to figure out what we can make progress on while we're here. Kenya Morton interview.
So Kenya Morton would, it would be her interview to impeach her if necessary. She is listed as an alibi witness of Mr. Kendrick.
Okay.
And so
Okay.
her interview is the
All right. And everybody's got the interview. Anybody anticipate, assuming they're going to impeach, that there are other issues with her interview that I need to think about evidentially right now?
and we have impeachment, but it would be impeachment and substantive. That just, since there was the issue raised, but that would be the only thing with Ms. Morton. And the other pieces of evidence that would be used with Ms. Morton have already been introduced.
Okay. Easy enough.
And guys, I don't understand why Bean would be coming back. I don't know.
Okay. So I've just looked at the very first paragraph of the order on Mr. Kendrick's statements that's filed March 18th of this year. And I haven't looked at the end of it yet, but it certainly says the motion to suppress was as to an October 6th and an October 12th statement. So I would imagine that he covered both. Yeah, continuing through the entirety of his October 12th interrogation or suppressed. So yes, that second one has already been ruled on and is not allowed. So it's the October 6th one prior to the 2:16 p.m. mark. Okay. All right. So that answers that. That one was an easy one.
There may be, I have to refresh my memory, there may be some brutal issues in that it's a law enforcement statement. I will look at it though and alert you.
All right. So we would definitely need to sort that out before presenting it to the jury too. Okay. So yes, thank you. And just share with the state whatever you think about that so that they can have a response prepared. And normally Bruton, not necessarily normally, but oftentimes Bruton issues can be cured by redactions. So if you've got proposed redactions that would cure it, that would be immensely helpful.
We'll send over anything.
Great, thank you. All right, and then next, at least on this list, is Mike Sprinkle, who, I mean, I don't know what all, is he going to be testifying to stuff that's already in evidence or new stuff too?
A combination of things because ADA Sprinkle was after the DA's office was given a case, ADA Sprinkle went and continued to research and work on it.
Yeah.
As a result of what he found, different persons were charged.
Right.
So he would be speaking to both jail calls that he found.
Okay. And then is he going to testify to the contents of those jail calls? And
He would play them, not.
okay, he'd be like, I found this jail call and it's between these people, or okay. And you'll give the defense, if you haven't already, details of what those jail calls are, when they occurred, et cetera. Okay.
Yes, and also, for instance, Martinez Arnold is a witness further down.
Mm-hmm.
I don't think he's on this list, but he is a witness that we are intending to call. So we would not endeavor to put, before Martinez Arnold testified, we would not be endeavoring to put his jail calls in.
Okay.
But for instance, Mr. Stillwell's, we would. Mr. Sledge, he would have already testified. So anything that we needed to impeach him on, or anything that he didn't, Mr. Sledge
Okay.
denied knowledge of or refused.
All right.
So,
All right.
So, Your Honor, my client has about maybe a dozen jail calls listed under Mr. Sprinkle in the spreadsheet that was shared yesterday by Mr. Adkins. They had previously identified, I think, 4 calls, and so there's additional calls. I still need to review those calls.
Okay.
Because that's the first time they've been specifically
Okay.
identified beyond those 4.
All right. And I mean, sometimes people continue to make calls and Mr. Sprinkle probably continues to listen to them.
Well,
I don't know.
From 2015, but
Oh, okay. Well, there are a lot of jail calls to get through with some people. So, okay. So sure, we're going to have that whole week in another week that starts on August 19th. So maybe we'll be doing that then.
yes, Your Honor.
Okay, thank you. All right, and then it looks like there's a series of custodians of cell records. Do y'all anticipate objecting to those people? How about for Mr. Kendrick? Mr. Nichols? Mr. Huey? Okay.
Caveat, presuming, of course, that we've got all of the business record certifications. I think we probably.
I would certainly hope that, but yeah, y'all will have certifications for this. All right, so those will be easy witnesses. And then Bernie, this was the guy we talked about yesterday, but you were saying the report he's going to be providing at this stage of the trial is not that new-ish one, it's something else, right?
We would not be endeavoring to have him talk about the 2 new ones that he plotted. We would
Okay.
only be presenting the plots of the cell phone numbers that we had previously provided to the defense.
Okay. All right.
Why would he have them plot something new if they don't plan to use it at some point? They're like, oh, we're
Then
not
we
going
got
to use
a
it.
firearms analyst, which of course there'll be lots of cross, I would imagine, maybe not, I don't know, on the stand, but do we have any like motion and limine type issues that y'all know of with regard to the firearms analyst? Things I could be thinking about beforehand?
Army nurses, love has been ambushed by the defense. Karma. I 100% agree.
I have to refresh my memory whether there's a surrogate witness, but otherwise, no. It's nothing from us.
Okay. All right.
Thank you, Army
I'm
nurse.
sorry, I couldn't hear all of what Mr. Steele said. If you could.
Do you mind repeating that?
Not at all. Unless like a crime lab person left the office and this is another person coming in to say we reviewed notes, but he or she didn't do the testing. There's a new United States Supreme Court case, I can't remember, but came out within the month.
Yeah.
That talks about that's a Confrontation Clause violation.
This is the same person that actually did the analysis to begin with?
So both, both Mr. Whitesell and Mr. Voss physically analyzed them.
Okay.
Neither are still with the GBI.
Okay, but they're going to be the ones that come and testify.
Yes, I don't at this point, unless something has happened to them. I haven't.
All right. Well, maybe get somebody on your team to check and make sure they're still lined up. Okay. Super.
Your Honor.
Yep.
As we go. No, not that. There was one. Set of instances, and this is something that will be included tomorrow, but just as I'm thinking about it and looking down at the next few witnesses. So we have provided crime lab photographs, APD photo lab photographs for the intrinsic acts, the shootings that occurred after the murder of Donovan Thomas.
Okay.
One of them, I think April the 28th, we provided a crime scene technician's report of a set of photographs.
Okay.
The actual photographs, the lab said it could have either been affected by the hack or what. The description of each of the photographs was listed in the crime scene report. I've asked the lab, do you all have a physical copy of whatever you uploaded to your server that may have been affected by the hack? I have not received anything from them.
Okay.
And that's something that while I looked at it as we were sitting here, that I wanted to.
Okay, and this would be photos from which crime scene?
It is the one Adele Avenue, 1428 Adele Avenue. The crime scene that is 1180462, 151180462.
Moses Dupree has the never-ending question here. What happened to 0 more chances?
All right, and they no longer have the originals, or what's the deal? Because a description of the photo, I don't
know. They've been looking for me. So
well, do y'all have copies of them?
No. So that's just it. We didn't have the photographs themselves. If we had a copy of them, that would be great.
Right.
But we were never given the photographs themselves or a disc of the photographs themselves. We just got an email or a response saying we couldn't locate this one.
And this is APD?
Yes.
Took these photos?
Yes, and crime scene Turner.
Yeah, okay.
Actually, that's the tech. We have all the information about the photos. They just don't have the photos. Or at least they said they couldn't find the photos. And I have someone on the inside who's trying to get the photos, looking for the photos. They have not been located.
All right.
That's it.
So, I mean, I would think that.
Is it really the inside when the police are part of the state?
Well, a report of what the photos show is going to do for anybody, but what witness is this going to be?
That is, so Denise Bell.
All right.
The witness who was the.
Okay, so that's
the person who's one of
It's
the
like the
people who
proof
was
they
inside.
could have had is gone.
Oh, right. Okay. Well, we may just have to have a description from the witness's memory as to what things look like if y'all can't find the photos. Because I mean, and you can provide the report. Like, I mean, what were you even thinking you might do instead if the photos can't be found?
they have the report. We turned
Right,
over the report.
right.
I mean, if the photo, if they just don't,
I mean, there are all kind of creative things that might be able to be done if this place still exists and looks the same as it did. I have no idea whether it does. If the report is descriptive enough that somebody who has artistic talent can draw out a really good diagram, that might be a solution as well. But I mean, I don't know. I doubt if just I don't know. So, okay.
that was just something I wanted to.
All right, well.
Something that I'll go in detail about if I have to tomorrow.
No.
This is a little crazy. And
Y'all
Miss,
are
it'd be perfect timed comment.
on
There's
notice
an
of that,
issue with
and to the
everything.
extent you think you might use some substitute for those photos, if those photos cannot be found,
I don't have any.
talk to, or what do you think? I mean, do you think you'd probably just have a witness describe it, an eyewitness describe it?
Yes,
Okay,
I can.
well,
I
that's
can.
fine. All right. Okay.
An issue with everything the state presents. Bad case all around. It's so
So-
apparent. It's scary. Who did she
Miss,
cash draw?
Latner's is
This
a
is-
witness that
are you-
we called. and
Let me share your link again. And then
have
let me
had
figure out how to
call at
spotlight
different
this
times,
screen.
Regarding the 911 calls. I don't know that there are any objections to them. There have in the past been some objections to 911 calls, but
To the contents of them, or to them coming in at all without?
to the contents of some of
Okay.
them.
We had a long discussion. Judge Glanville excluded part of a 911, one specific 911 call because it was not for an ongoing emergency, and it identified a person, in that case, Mr. Williams, but the speaker, the caller, 911 caller, was not available, so we could not confront. So it was a confrontation clause issue, is what the state's talking about. If I have the 911 call, I will look at it and make sure that there's no issues. And that's under Pitts, Pitts versus State of Georgia. I believe it's a 2006 case. It was written, I believe, by the Honorable Justice Sears. It's cited, I know it's under old law, but it's cited in 2023 or 24. It's a great opinion, actually, by the Supreme Court of Georgia. But I think that's what Miss Love is referring to.
No, we were talking about the ones
Thanks,
that
guys.
are coming up. We're not revisiting the ones that
Right,
are already.
right.
Sorry,
yeah,
I was
yeah,
boomerang
but-
with the
okay,
screen.
So as to whatever other 911 calls, y'all know what other 911 calls they intend to introduce?
Those are the ones that are listed on the list that the court has in front of it.
Which I just have this exhibit list that doesn't have any detail. It just says 911 call.
Yeah, that's what I
okay.
have.
So,
I don't have the
okay.
new list you
So,
shared.
The 911 call and the CAD report from 151.
Oh, okay. I do. Yep. Club Crucial, 1428 Adele and 1903 Drew. Okay. So y'all, the defense, know what all of those 911 calls are going to be?
I could link it up, yes.
All right. And you're going to be getting that more detailed exhibit list over anyway. So, I mean, whether you have an exhibit number for them or not, you could be like, 1223, 1248, 1255, or whatever, on whatever date. And then they'll be able to search their discovery and find it and figure out for me whether there is any objection to the 911 calls, content, or otherwise.
Yes.
Okay, so that might be something we have to deal with. All right. Yeah.
CAD reports. I have a case for the court. I have to just put my finger on it, but certain information in CAD report is also confrontation clause. I'll get you the case.
All right, and then point out for me, as to whichever CAD reports are going to be used, what is objectionable. All right, thank you. All right, it looks like the next few are not necessarily any objections other than the normal ones in a trial. How about, is this number 26
Oh my
that
God,
was
I
on
love
my
that
list,
Fletch.
Tyrone Dennis, is he just has a lot of different types of evidence listed next to him. What's his, is he law
Defense team,
enforcement?
maybe.
Yes,
Okay.
he was one of the lead detectives
Okay.
that investigated that assisted in the investigation regarding Mr.
Oh,
Thomas.
right,
Later
yeah.
on.
We've heard about him in our videos we've been listening to. That Dennis. Okay.
Yes.
So, is he going to be, do y'all know generally what evidence he's going to be testifying to? And do you think you're going to have objection to it that we can take up beforehand?
So he is also, in addition to being a fact witness, he's also one of our gang experts. I think. I don't know if that was brought out before, but as it relates to the social media, some of the social media posts between Mr. Garlington and Defendant Williams, the we ain't going back and forth social media posts, I think some of them we may have already put in, but the social media posts between Demikion Garlington and Mr. Williams, I'm screaming 30, fuck a blue jean bandit. Other social media posts that we've specifically identified and I'll send over. Between Mr. Garlington, Mr. Stillwell, Mr. Arnold, and Mr. Kendrick. Photos of the gun recovered by law enforcement from Mr. Kenneth Copeland that belonged to Quindarius Zachary. A photo of the gun Mr. Zachary was arrested with on May 7, 2015. The video of Mr. Arnold getting into a fight with Kelvin Watts at Magic City on September 30th, 2015, which led to the subsequent arrest of Mr. Kendrick, who was in the car with Mr. Arnold. Following that fight, and at which time Mr. Kendrick was found to be in possession of a gun, and it led to the revelation that they were going to retaliate against members of a rival gang at this apartment complex.
Okay. All right, and then you also have music next to that. Is he gonna just testify about certain songs, or what's that gonna be?
He would intended to play portions,
Okay.
not whole songs.
Okay, and he'll give his gang expertise about what
Yes,
all
that
that
is-
stuff means. Has he already testified once? Has he been qualified already? Okay.
Yes.
All right.
So
Yes, sir.
a couple things about the state's proposed evidence about through Mr. Dennis or Investigator Dennis. With the music, I'm interested. Is the state planning on playing videos, audio? How is that? Are they proposing, of course, over our objections? And
Right, and a lot of that's already been ruled on. Let's find out. Did you intend to play video or audio when or whatever, I don't know what his rank is, Dennis is going to be testifying?
They probably don't know.
So it's audio, and these are the overt acts that we have listed. For instance, Act 78, 60, 74, 95, 97, 103, 125, and 129. So we would be playing the audio portions of the audio.
so strictly audio, no video, no pictures.
No, I didn't say that. I also
'Cause you
said
didn't
that
answer
we
the
would be
question.
putting in the described social media post.
Oh, yeah, no, he's not asking about social media. He's asking about when you're going to be playing clips of songs. Is that going to be just audio or is it going to be video also? Is that the question?
Yes, and if there's video, I mean, we've discussed, from my recollection, and I wasn't the one litigating a lot of the
Right,
free speech, First
Right.
Amendment issues here.
right.
But if there's video, there's certain things in a video that could be problematic to be introduced in front of a jury as well. That's why I'm inquiring, are we confining it strictly to the words that are spoken?
No. So when we had, so what I didn't make the distinction on my list of which ones we will be entering the videos of. So I will speak with Mr. Sharp and whomever else wants to
Okay.
be involved in that conversation and identify the videos that we will put in as, or
Okay, so this witness is within the first 30, and so by
midnight. You said?
the end of Friday, you need to have details for what specifically, not just music, but, you know, a video of whatever the name of this song is, or, you know, a 2-minute clip from this song, and here's the minutes that are included, and audio from whatever other song. Detail it for them so that then they can make detailed objections.
And Your Honor, also, just to give the court a heads up, 87 Lima is Operations Planner's PowerPoint. I don't have it in front of me, but I'm very familiar with that PowerPoint. That PowerPoint includes all sorts of conclusory language, all sorts of additional information that is not relevant to this case, all sorts of commentary from it written down on the, I believe it was intended to be a PowerPoint to other law enforcement. That's my understanding. I could
Is
be
that
wrong.
PowerPoint that Dennis is?
I believe so. And I understand that the state's intending to call him as an expert, but you know, hearsay and an expert can't be used as a, you know, mere conduit to get into hearsay and other inadmissible evidence. And there's a lot of, I'm saying I know I have numerous objections. And
All right, is 87 Lima already in evidence or no?
No, I don't think we've introduced it.
Okay.
Evidence, but they,
Your Honor, when we were served with this, I filed, I'll get you the date. I filed a motion challenging the admission, and my memory is Judge Glanville said he's not letting that in and asked the state, and they said they were not using it. Now, if that's wrong, I apologize, but I'm pretty sure that's
Okay, all right, so,
if I'll check back into our notes because I don't have memory.
don't
of that
remember.
particular
Okay,
conclusion,
all right,
but
just check
I'll
on that one.
back.
Thank you. See, this exercise may be boring, but it's helping everybody. All right, and then there's Arnold, Munson, Kilgore, and Underwood would take us through 30. And it doesn't look like there's, other than maybe Arnold. He doesn't seem to have an interview. He just has jail calls. Is that right?
Jail calls and the plea agreement.
Right. Okay. And the plea agreement would be kind of the same issues as the other plea agreement we were talking about
Yes.
previously? Okay. All right.
And then some social media.
Okay. All right. All right. So y'all get together on what I've told you to get together on. As far
Laura
as
has a
I
lot of
know,
homework.
outstanding, waiting on an order from me are Mr. Stillwell's renewed motion for a fair trial, which I'm finished but have not filed yet. And then Mr. Kendrick's supplemented motion for mistrial, and then Mr. Williams. I don't know if it's two different ones, Mr. Steele, or just one and two amendments to the motion to disqualify the prosecutors. Is that two different things, or am I just supposed to?
You ruled on one, because I said I would.
The earlier one, but then you sent two more.
Okay, I remember one,
Okay.
but I'm sure you're right. But I remember one about ethical concerns.
All right. And as far as I am recalling, those are the only outstanding motions that need ruling from the court. Does anybody have a recollection of anything additional? No. Okay. All right. Any other matters that you need to bring to the court's attention or that we can deal with right now before we adjourn for the day?
Your Honor?
Yeah.
Mr. Adams, you're correct. There are two, but there's an amended additional motion that was filed on August 6th at 3:53.
Yeah.
And then there's an additional motion to disqualify lawyers Love and Hilton, which was filed approximately 56 minutes before that. But all I added was, all we added was a footnote. That's the only difference.
Okay,
there's
so
really
basically one just supersedes the other then. So I can look at whatever the latest filed one is and
Yes.
that'll deal with it.
That's
All
correct.
right, thank you for that clarification. Okay, y'all have got lots to do. Thank you for your hard work thus far. I will see everybody bright and early on Monday morning at 8
Monday morning.
a.m. All of the attorneys should already have orders for early entry into the courtroom. Does anybody need one? Mr. Howell, will you be with us Monday or will Mr. Weinstein be back with us? Okay, and he should have one. And our defendants are already with us, so. Speak into your microphone, please.
We've got an old order from Judge Glanville. I'm
Okay.
assuming,
He's still our chief judge, and it probably, does it just say through this trial?
I don't know.
All right.
I'll have to look.
I'd
It does
imagine
say
those are
through the
still
Okay.
in effect.
All right.
Okay. All right. So I will see everybody on Monday, and please do the homework that I gave you. All right, thank y'all.
All right, let's see if they actually get quiet. So, you know the drill. We keep the screen up for a little bit. Again, we have had awesome extra entertainment here thanks to our sketch artist.
Thank you.
So right now, if you want her link to her Instagram, I'm pasting that in the chat.
I've always wanted to do this on a live, and I always.
I'm
thought it would
loving
be
you
a
pick the green.
whole thing, right? Why not? Like.
And then you had a great suggestion here from Sledge. I loved it. Oh wait, it was a different one. This one.
Oh yeah,
PNC,
I'm like,
would you
yeah.
consider working for the prosecution to
I'll
recreate
help,
those
absolutely.
missing photos?
Call me. I'll tell you
We gotta
exactly.
find Love. Someone tweet Love and say, look, we can help recreate those missing photos that APD lost, and you can have your case go forward.
Absolutely. Like, I mean, this is like 30 minutes, maybe. It is not exact, but y'all know who it is.
I love it. And I had pulled up a bunch of people. Let me see what the chat's saying now. We had pulled up a bunch of love for
really
you.
Appreciate you shouting me out so hard. Like, this chat is so great. Obviously, we say that every day, but like, I always say we're trauma bonding together. Like,
Oh, and you guys are asking if I'm going to stream tomorrow or a recap. I will stream any motions that come in. a recap, guys, I don't know if I can do it. I mean, a bunch of evidentiary stuff going on. You know, honestly, the same thing from Judge Whitaker. Okay, 0 more chances. Oh, you're late on something else again? All right, well, now you have until Friday at noon. Oh, you don't have something else that you provided yet for these 30-day witnesses that we want to make sure we know what to prepare for the next 30 days, including a week off, which means they only need to have like 3.5 weeks prepared rather than a full month. And, oh, no, we don't know either. We don't know that either. Well, can you turn that in by midnight? So it's hilarious that the state is going to have a bunch of homework. They still need to respond to. And what I think is interesting is I thought the state may have wanted to respond to the motions about the mistrial, but
Right,
Whitaker
then-
said she already ruled on shards.
That was
Mr.
weird.
Stillwell's.
That was weird.
So I guess, okay, but they're supposed to at least respond, I guess, to the disqualification motions filed by Mr. Steele still by Friday. So they've got all of this stuff to sort out. Some by midnight, some by noon tomorrow. I don't know if they have permission to file stuff all the way till end of day tomorrow. And then Judge Whitaker has to spend the weekend looking at it. And we've got this looming issue now about jury questions. And I think, you know, we're talking about appeals. Camp had said way earlier that it's common to cite case law regarding jury instructions because that's the most common area when you speak about appeals, reversible error. Because the instructions could be prejudicial to the defense. So, for example, if someone does something in self-defense and then the jury isn't instructed that, okay, if this person shot somebody, you might find that they literally did shoot somebody. But could it have been justified? And if the jury isn't given that charge to find that justification, I mean, you guys can kind of spell out why that would be a huge error for appeal. So, great point, Cam. And we've got these jury instructions here. And we can pull this up. Joseph Babb, in relation to what Whitaker's getting at with this idea that, hey, we've got all these jurors, they've been sitting out, we're going to tell them to disregard someone's testimony. Joseph had pulled this case. It's a Georgia Supreme Court opinion in 2020 that said the trial ensured the defendant's right to a fair trial by giving an emphatic curative instruction and polling the jurors as to whether they were able to disregard a witness's testimony. So further, it says, and I got to hide this so you can read it, the trial court ensured that Davis retained his right to a fair trial by giving an emphatic curative instruction and polling the jurors as to whether they were able to disregard Agent Lynn's improper testimony. None of the jurors indicated that they were unable to disregard the state's question and Lynn's answer. Accordingly, the trial court did not abuse its discretion in this respect. So in other words, if we poll them and there's no issue, we can properly move forward. So we have to give this instruction, and if we have to give this instruction, we also have to poll. So Whitaker's looking ahead. And then they are referencing another case, Childs v. State, that says no abuse of discretion in denying the mistrial, where trial court instructed jury to disregard improper witness testimony. Plus also favors v. State, qualified jurors under oath are presumed to follow the instructions of the trial court. So again, where we're taking them at face value, we think they're supposed to follow what they're supposed to do. How do we really know they didn't unless there's some hard proof that some juror went rogue? So that's where some of that stuff is coming from. And that's why there's a lot of, we looked at 1-page proposed instructions for the limiting issue, but you heard Ms. Westmoreland and Bruce Harvey say they wanted a little bit more time. The instructions are so serious. That's why it makes sense that even though it could be a short page, you're going over line by line, every letter, every grammatical point to make sure it's correct. You don't want to make an issue on something like that. So thank you so much, Cam. And then shout out to Franju and Crawfest, the Dora the Explorer haircut, for becoming a member. Also, I know I've seen, it's so good. And maybe that can be your next drawing.
It's so good.
All of the day. Also,
I need
new member.
suggestions.
That would be awesome. Hold on.
Yeah.
Do you want to take a picture of it?
Oh yeah, actually I do. Like, I'll start doing it, and I can donate this. Like, I don't know if you can do like a raffle or something. I don't know how you do that. But I'd love to donate this or something.
That would be awesome. I know you had FFS and others asking for your link. I did mention a few times that you take commissions through IG.
Yes.
So that's really cool.
The only
I
setup
can't
I
draw
have
at all.
right
This is obviously not something I did. It wouldn't, if I did this,
Commission
it would
work
just be
is-
orange.
Oh, I love that orange on the wall though.
I know, that's why I bought it. I didn't make it though.
Commissions are hard because everything that I do is so like different, and like the court stuff can be blanket stated, but I'm still selling it to the court. Technically, it is their property once it leaves my hands. So
Okay, that's
stuff
cool.
like this, like public hearings and things like that, are a very good thing to practice. Like I'm not perfect, but maybe.
No, but this is cool. I wouldn't know how to do like an auction formula, except maybe,
Yeah,
I
right.
don't know, like blind bid and pick someone in the chat.
I know,
But
right?
this
And,
is
like, I don't-
this is a great picture from Franju. I saw it yesterday and loved it.
Yes. I'm gonna do that next. That's gonna be great.
And I know Niniola had become a member, so thank you so much. Simon Beebe had become a member, so thank you so much. And then we've got a few super chats here. So thank you again to Cam. Kedrick had said, what if they can find any jurors from Fulton County that don't already know about this case if it's a mistrial? Like, how would they find another juror pool to seat this trial? Well, hopefully seating a jury wouldn't take 10 months. I'm sure they could find some people. It's a populous area, right? If this was a smaller area, I might just say there's no way they could do it. And I'm sure the defense might raise this issue because if they can get it moved to a different jurisdiction, maybe that'd be a huge win for the defendants. Might not be. But I do think that since there's so many people in Atlanta, a judge might find that it would be okay to, you know, pick another group of people, bring them in, get them through voir dire, and see if you can get some people that haven't heard about this case or that anything they've heard, it wouldn't impress too
The
hardly
likelihood
upon
of
them
that.
to weigh fairly. And I think the same thing happened with the Trump case in New York. They had to let people on that obviously knew, like everybody has to know who the president is. That might be a little bit different. But they seated jurors based on, you know, we say that we can disregard what we heard and still judge the evidence fairly. So just because we think it might be unfathomable doesn't mean that, or not we as all of us, but just because it might be a possibility doesn't mean a judge will conclude that there's absolutely no way to find a pure jury pool. And I think it might be in the defendant's best interest maybe to keep it in a county that they're, I don't know, it depends. I think voir dire is really the solution there for both sides. So great food for thought there. FFS, this was so good earlier, said, imagine you're getting cheated on. And when it all starts to crash, they say, just disregard anything you've seen or heard. Just disregard it.
Imagine.
And can't really just tell someone to do that. And that might involve like an emotional reaction, but still. Natasha Vega says, do you really think she went back to watch every single day of the case? If she tried to, I think it'd be impossible for her to catch up with, you know, we were on day 100. I think it would have been impossible even if she left court every day, didn't do anything else except sleep and eat, and tried to catch up on 100 days. I still don't think we'd be able to. So I think she's missing a lot of context, and I don't think she'll be able to catch all of it. It's disappointing to hear she already decided on Shard's motion. She's probably gonna be like, yeah, I'll give you a fair trial, because that's technically what Shard was asking for, first and foremost. So thank you, Natasha. Mahadi is saying that the out Whitaker gave is the logic she's pointing towards. This gives an end without prejudice, a win-win. So a mistrial out of necessity because we don't have enough jurors to continue. Because there's a necessary reason to call this mistrial, you know, it's not going to be with prejudice. Maybe they can make an argument as to why it should be. You know, maybe they'll make some long-winded argument that the prosecution is somehow at fault for this thing that we need to issue a curative instruction to the jurors on. But I think they've essentially tried to make that argument already. And if they're not impressing that upon Judge Whitaker now, I don't think it'll work any better in a roundabout fashion. But I agree, Mahadi. Not only do I think this is an out, but I do think, especially reading what Joseph Papp had shared, I think this is the judge realizing, like, if I'm going to give this instruction, I have to give the poll. Otherwise, it's going to become an appellate issue in the wrong direction. So thank you so much, Mahadi, for your support always. Dark Lane Demo says, I think Woody will plead the 5th on Monday. Whitaker will revisit her ruling on Steele's motion for immediate review. Now, I don't know if I think Woody will just immediately plead the 5th. I think he might get up there and try to blurt what the state told him about, you can't get up there and say you killed Donovan Thomas or unalive Donovan Thomas. I think there might be things that Woody wants to say. And when he's ready to go, he'll go, oh, I don't want to testify anymore. So it might be a little bit of a mix. Thank you, Darklane Demo. And then FFS said, I can't read the whole thing out loud on YouTube, but Love gets dressed in the dark. I think she looked pretty put together today. We didn't have the reds clashing. I don't think it was that bad. I think a lot of us just dislike Love and we wait to see what she wears with those green nails. But I think there are some days where it did seem like maybe she got dressed in the dark. And Sherry, I loved this earlier. I had pulled it up. Shard wouldn't have brought it up if nothing. And he did qualify. He might not be sure. But his question was, he knows that there were 4 people present at this coffee meeting with a witness, and nothing was turned over. So he's curious that there could be possible Brady information that, once again, wasn't turned over. And the difficult part about that is prosecutors will go interview somebody and purposely not take notes, because if you take notes, then there could be something that you should be turning over. But if you don't record something, if you don't take the notes, you've got nothing to turn over. It's a little trick, and it's really bad for transparency. Doesn't seem to promote justice very much, but it's a trick that's on the table, and it's used quite often. So thank you so much, Sherry. Miss AB says, now she knows that she should not be challenging the preparation and readiness of the defense team. So they got chastised a little bit for not being prepared with these proposed instructions. And then right after that, so right after Miss AB had said that, Love got herself in hot water again for not being ready for something. So it was almost a moment where we could have almost ended the day with the defense being the one that was yelled at or criticized or chastised a little bit. Love took that spotlight right back. She was like, oh, here's another thing. We don't have photos. We've got this thing. We want these pictures to come in, but we don't have the files. And the judge is like, well, do you have like an alternative on what you want to do? You can't just... What are you going to tell the judge? We have photos. So then Whitaker has to help her. Like, can you get some witness testimony that was there that may have seen it? And Love is just like, oh, can we have some time to think of alternatives? I have an inside person. Like, how do you have an inside person at an agency of the state? You're part of the state. The police department is a governmental agency. What do you mean you have an inside person? That was weird language. And she laughed like she was proud of it. Like, when I go to the club, I know the guy at the door and he lets me in for free. That's like how she kind of compared this, we've got an insider here at APD. It was weird. She could have just mentioned she needed to figure something out and might need time because it's relevant for the next 30 days. But the way she presented it kind of rattled the judge. She rattled the judge. So, all in all the negative that went to the defense like 5 minutes before that, washed away. Love took it right back. But yeah, the insider thing, guys, I don't know. We're going to say it's just because she's sneaky. And then FFS says, this is the other thing too. As soon as Whitaker tells the state that there's a deadline for something, Love starts buffering. And she starts trying to come up with words that can help her reinvent the time frame. So Judge Whitaker says, I want this on Friday because we're going to be back on Monday. Love is stumped. She's staring forward. Can you do this by this time period? And then Love has to go into a whole rambling rant just for the judge to cut her off and be like, all right, fine, noon tomorrow instead of midnight tonight. It's just one thing after another. JT Coinring, so good to see you. Hello, Cat and Chat. Rhyming bars. It is really cool that Cat rhymes with Chat. I love that. Looney Boy says, Cat, what do you think this trial does for future case law? so much is going to change in Georgia due to this trial. I think the change comes really slowly, and that sucks. But maybe there will be change from it. Maybe there will be prosecutors that don't want to end up looking like Love. They don't want to be part of the YouTube generative AI summary descriptions of a YouTube chat. Like, oh, the prosecutor's failing this case. So, but any change that would come through, case law has to come from an appeals court. That's time. So change would be really, really slow.
So I just posted this
And
on eBay. If anybody wants to go bid on it.
Sweet. Oh my God. You can put a link in the private chat so I can copy and paste it.
Yeah, let me go find it on the computer real quick. I was like, I know somebody suggested that, and I was like, duh, eBay.
I haven't used eBay in so long. I don't think I've used eBay since I sold some of my Pokemon cards. Like when I was in college, I was like, I need money. I'm broke. I'm tired of, having to fix a car and just for it to fall apart because I'm doing a cheap fix. So I haven't used eBay since back in the day, but they do a lot. Like they've evolved, they've adapted. So while you get that,
too.
You said marketing?
Yeah, I've
does
just seen
marketing?
a lot of events have eBay be a sponsor lately, like fashion events.
Oh, like
and
they're
things
getting like
promoting, reusable fashion and not encouraging the fast fashion of it all. But I thought that was cool. I hadn't seen that.
what's a smart angle?
Mm-hmm.
Like for their team to decide this is how we should brand ourselves is like, what the fast fashion, you wear it once, it falls apart when you wash it, and now we throw it into a landfill and it's made with a bunch of plastic
But we
fibers.
still believe in capitalism, so like
Yeah, they're still like and literally the demand, right? eBay
Yes.
is based around supply and demand.
How do we?
So true. They're trying to do a little bit of both.
Why
Let them
not?
rock. And Lola says the judge would rather put her foot down over chewing gum. Oh. But not for the state's mishandling over everything else. It's a joke. And I mean, like we heard 0 chances yesterday and they got like 3 more chances today. So, and I guess like one of them was, I guess technically the picture thing wasn't their problem, but my solution to that would be, okay, so you're not going to be able to bring pictures in. And I don't think it would be appropriate to have the detective just try to recall what they saw in pictures. They would need a witness that was there present, either the person who took the photos, that would be the witness I would want to call. And Love couldn't even think of that as a suggestion on the fly. So I feel like she's just trying to hope that something can be recovered, but if there was a hack and something was recovered, how do we know that it's the right files, that it hasn't been altered? How are you recovering things in a way that metadata wouldn't be affected if you haven't recovered it by now? It just seems not gravy to me. So, Lola Dane, I don't know. I don't think this is the end of the state mishandling something, though. I certainly do not think it's the end of the state mishandling something. So, guys, I am sharing I will share it right back in the private chat. This is the eBay link. We're going to call it YSL Steel.
I didn't want to put that on there, and I don't know. Now I'm part of it. Like,
well, I can say it in the chat because I'm not the one labeling the piece. Because
there you go.
Subjective interpretation there.
A+.
And there you go. So Fletch, we need to find a way to tell the prosecution that we have a solution for these pictures. Don't forget.
Absolutely.
Chloe Albert's Revenge. Great shout out to the Karen retrial there. Says one better. Fire everybody and let her sketch the whole trial and jurors all guess like Pictionary. That would be shorter than this. You got to give us like a picture flip book of the events that they're trying to lay out across these 100 days.
Oh my, like the best moments, like that moment when Love walks past the camera and she gives like the worst side eye I've ever seen. Like bombastic side eye.
Just annoying.
I like that one.
When she said, "Are you certain?" And she like put her head forward at a witness because the witness said no to something she wanted a yes to. There's a lot of Love moments, but it'd be a lot of like back of the head because of the camera
and I'm not
angles.
trying to be ugly to anybody. I just want her to do her job. Like
fair enough. And then FFS, this had to be about the gang expert. The gang expert is self-qualified. Don't forget, one was disqualified. And I still don't know why they need to call multiple gang experts from the same department that we're all trained the exact same way. Like, what's the difference there? Why do we need different ones? And Fletch says, I'm more of an Iron Maiden fan, but I'd be willing to hear some Young Thug. Now, what's cool about Young Thug is Young Thug actually samples like artists that you might not expect of. I think he's done like Elton John is one I can think of off the top of my head. So who knows? Something like that could be around the corner if both parties would be willing to do it. Who knows?
Diana Ross.
Wait, really?
Yeah, he sampled Diana Ross. I cannot remember at the top of my head, but my friend is a producer, and he mentioned that, and I thought that was cool.
Yeah, just a lot of sampling in his music. So, look, here's the opportunity to use Iron Maiden and Young Thug in the same sentence. Get the YouTube AI chat to put 2 and 2 together and start sending signals out there.
What is
Black
a yin set?
butterfly? This is a gross metaphor. You can't outslick a can of oil, love. Sit. So now I'm picturing her sitting down in oil after she's done talking and she slides right off the seat. Thank you so much, Black Butterfly. FFS, so I'm qualified to be a criminal defense attorney and an expert at calling BS based on past experience. I mean, I think some attorneys, this is a weird story, you guys. I think some attorneys lack common sense. I think when you hang out in a YouTube chat, you start to think of things that are maybe common sense, but you took for granted. This is a weird example, but I had a conversation with a criminal defense attorney who had questions about the phrase. It was a text message between male and female. Female was claiming male did something wrong. And the message in the text said, I came on your back. And the criminal defense attorney didn't know that came is another word for, ejaculate. And they thought that it just meant I did something to your back, physically and aggressive. But really, the purpose of the text was the pregnancy was talked about previously and a few messages back. And the male was just trying to say, why would you be pregnant if I pulled out or whatever? So, but the criminal defense attorney didn't know that was a common way to say something like that. So I was just like, look, I'm not trying to doubt your credentials, because he had said something to the lines of, I've been doing this for 28 years. And I'm like, well, why don't you want to hear me out? Because if you have to represent someone in this situation, you might want to know what those words mean. And it was just one of those things where we joke, we feel like we're qualified to be criminal defense attorneys. And I'm not saying we should just go in and say we can represent someone or go pro se. But sometimes the things we say as regular lay people out here could be helpful to someone, making their case for defense of their client. So totally hear you, FFS.
Brian.
Oh, that's cool.
Thank you. This is
Thank
my
you,
alphabet
Brian.
book. I have the alphabet in there.
That's cool too. Every super chat, you got to flip to another one. If you want to hang out, you don't have to hang out if you don't want to.
If you're okay with me hanging out, this is
hang out.
I don't mind at all.
Sweet. So you can flip a letter every time. So I think we got into this one. No
Yes,
recap
fine.
tomorrow, but if new filings come in, we'll look at them for sure. So remember, the state's supposed to have their filing in, but just because they're supposed to doesn't mean we'll get it. I think we will, though. They really shouldn't play around and mess this one up. Too many chances at this point. And this perfect Sentinel bets on the homework getting done. So put a 1 in the chat if you think Love's homework will be turned in tomorrow. Specifically, what did they want? They wanted to know for sure the remaining witnesses. I think they wanted them locked in. The evidence for Arnold, Munson, Underwood. There was a 4th one. Gore, maybe. They want to make sure the relevant evidence for those witnesses is turned over to the defense so they can prepare for the next 30 days. They also need to respond to these motions to disqualify. Put a 1 in the chat if you think they'll get it done. Put a 2 if you think they will not get it done. Yeah, you guys are putting 0s and 2s on your own before I said it.
Yeah.
So, but we'll be on the lookout for that. Thanks so much again, Sentinel. I remember you gifted memberships earlier, so you've done a lot for this chat today. I appreciate you. FFS says, I'd pay her not to paint the scene for love. I'd pay her not to paint the scene for love. They lost. It's their fault. C is for cry about it. C is for cope. This trial is really getting on my nerves.
C is for coping mechanisms. A is for ADA love. No.
Oh, we need a different person to get A. A looks cool.
I know, right?
A is for auction on eBay.
A is for auction on eBay. Yes. Somebody said we're sponsored by Adidas. We have the same hat on. Like, hey.
I know, I switched. I don't know if
Sponsored.
you
I
were
didn't
drawing when I
notice.
switched. Because my other hat was Diane Fossey Gorilla Fund, but it's probably like the logo is probably above the screen most of the time.
Very good, very good.
Okay, so there's the eBay link again. So A is for auction. And then Fletch says, now who's giving who homework? Love was giving Glanville homework in the ex parte. I don't think this judge will be giving that type of homework to anybody, but that's a good reminder. So thank you so much, Fletch.
For calamity.
And FFS, sorry with your F-bombs of super chats. You get away with it for your name. You always can get away with it because you're FFS. So don't forget that. And Nancy New wants a poll. Let's do a final poll here. Poll, oh yeah, poll on if love will hand over everything on time. We kind of just voted on it, so maybe no poll. I think we did an impromptu poll in the chat. Everybody, I don't even think I see it won. No chance whatsoever. We have a 99. Just anything but a 1.
D for don't.
Because I don't see a 1. I do think we'll get that response, that written response. If she doesn't, that's it. Like, how could you not do that? Thank you so much, Nancy New. Will Bowman says, you think the fact that she ruled on shards and not steals means maybe she didn't need to rule on steals. Ready for mistrial already. I don't know, because it's just like, it's weird, and maybe she's trying to give people a timeline and doesn't want to come out and spill the beans of what she's going to do. But it was weird of her to say that if it's going to be anything but a denial, in my opinion. It just doesn't seem like a natural way to say things. So, I don't know. I wish I was optimistic about a mistrial. Can't tell you that I'm optimistic. Oh wait, I don't know your name reference. I just thought it was for F's sake. I thought that's what FFS stood for. And yeah, here we go. We're promoting. This is what you were referencing. We're both promoting our Adidas sponsorship. Or mine might be reversed. Am I getting the Sabiba or whatever it says in reverse? On StreamYard, I'm in the right direction, but on YouTube, I'm always the other way. So sometimes I'll point to a document I'm reading, but on YouTube, it shows me pointing away from it. So
it still checks.
I think I'm Sabiba. Thank you so much. Good to see you, innocent bystander. And then we are all caught up. So, okay, it is. There we go. Yeah, I don't know if you told me. I just assumed that it was FFS. And we've got an encore. Sherry, thanks so much for the encore super chat. Thanks, Kat, for making my workday fun. Happy weekend. Yeah, oh my God. It's technically a weekend because there's no court tomorrow. That means I get a day off a little bit. I can do my other work. So one last time, we're going to do this auction link. A is for auction. And we are going to wrap it up. Any closing thoughts, Cass?
Closing thoughts. Maybe this has been my theory the whole time, because she has to do proper procedure before the jury gets there. She could have just been slow rolling them to actually get face in front of this jury, so they don't have to just call them on the phone to have it all go down. I think she does want to have a certain explanation, because they are going to think it's very strange that they were off for this long. And maybe she's waiting for all these motions for them to be present for it.
Yeah, I mean, I do think, well,
That's
no,
what I want.
she only wants them
It's
to
not
come at
what's going to
8.
happen, but
She only wants them to come at 8, though. So she has the jury there at 8:45. I mean, that's only 45 minutes for whatever when she said we're going to be here early, I thought she was going to say something like 6 in the morning.
Right.
And I was like, I don't know if they'll like allow that with all the different, because they're coming from different places where the defendants are being transported from. It's not like you just have to coordinate at one time.
It's a lot of
but then
wishful
she said just
thinking.
8. 8 isn't that early, but that also means it's not a lot of time to hash things out. So.
And it's very different from her very 8:45 every single day. She was very adamant about her poignant timing.
Mm-hmm.
And I don't know. I think that she does want to get some face in front of this jury, but it may not go the way we're thinking.
No, I don't think so either. But I do think polling the jury, guys, they might not say that they can't disregard something, but they might pretend they can't disregard something because they want out of this trial. They just don't want to do it anymore.
Yeah.
So, and that would be, again, a mistrial, but without prejudice. So it doesn't solve the defense's problem.
Mm-mm.
So I think we're all caught up, guys. One more time in the chat, the YSL steal, according to me, not according to Cass.
Right.
And thank you so much for joining. We have shared your channel. We've shared your YouTube channel.
So many
and your
people
Instagram
followed
as well.
me on my YouTube. I'm gonna have to
Yeah, I
start.
hope
doing
your
this for
phone was
real.
blowing up.
Thank you, thank you, thank you. I will start doing this for real now. So on here.
Yeah, super awesome. But you guys, keep your eyes out for tomorrow. Some motions being filed. Maybe tonight if something comes through. I'm crossing my fingers everything comes through tomorrow, though, because I'm hungry and football starts tonight. So you
Hey.
guys all have a good one. Thank you so
Bye,
much.
guys.
Bye-bye.